Good morning. Welcome to the University of North Carolina at Chapel Hill Symposium on the Equal Protection's Grand Promise and Betrayals, Reconstruction, Plessy to Bakke and beyond. We are virtually together, and we want to thank everyone who's joining us for this conference, all the participants, all those who will be watching and listening. I have to say that we are together, fortunately, in a way that we couldn't be in person, even if it was a sunny day and the kind of weather that Dean Chemerinsky is used to in California. Um, because it's not a sunny day here. We have freezing rain. And in addition to that, we couldn't afford to bring everybody here together. So thank you so much. It's wonderful. I'm not going to spend time right now with introductions. As a general matter, we're not going to be spending much time with introductions. You will meet the staff of the Center for Civil Rights, but we also uh, will let you all see the introductions on screen so that we can get to the meat of the program. I met Dean Erwin Chemerinsky uh, in the 1980s, somewhere around 86 or so, in Southern California. He and I litigated cases together, and we became fast friends, and we've been friends in the decades since. We collaborate on a number of different things. He's one of the leading constitutional scholars. Where he finds time to do his work is beyond me. So you know who he is, you know his expertise, and I present to you Dean Erwin Chemerinsky. He's the dean of the law school at the University of California um, in or at Berkeley. Erwin, thank you for being with us, and I turn it over to you.
Thank you so much. Thank you for the kind words. What you didn't add, Ted, was when we met in 1980s in Los Angeles, we were both in middle school at the time. I'm deeply honored to have been asked to speak here today as part of this wonderful conference. I want to thank Ted and Jack Boger for this amazing invitation. I only wish we could be together in person. My thesis is that the Supreme Court has been a dismal failure in dealing with issues of race throughout American history. I fear that the foreseeable future, with 6 conservative justices, offers little basis believing that the court will be a force for racial justice. Indeed, I see a likelihood for the immediate future of just the opposite. We therefore must look elsewhere, but in doing so, I do find a basis for great hope for the future. I believe that other institutions can, and I'm cautiously optimistic, will act. The racial reckoning in the United States that began last May after the tragic death of George Floyd saw protests for racial justice in literally all 50 states. I am very hopeful that they will be the impetus for real change. It's understandable why we look to the Supreme Court to advance racial justice. We know that the political process so often has badly failed. We want the court to give meaning to the majestic language of the Declaration of Independence and to the constitutional guarantee of equal protection. We take heart, encouragement from when this occurred, most notably from cases like Brown versus Board of Education. We know to a certainty that elected Southern legislators and judges would not have ended segregation in 1954 or for a long time after. We watch today how legislators and elected officials are still systematically disenfranchising minority voters. We understandably want the judiciary to enforce the Constitution and move our society towards greater equality. This morning, beginning this wonderful conference, I want to address three questions. First, looking back and looking across time and issues, how is the court done with regard to racial justice? Second, what can we expect from the court in the foreseeable future? And third, and perhaps most important, if not the court, where can we go to pursue advances in racial justice? So let me start with the first of those questions. Looking back across time and across issues, the Supreme Court has a terrible record when it comes to racial justice. This is, of course, familiar to everyone, so I'll sketch all of this very quickly. But although it is familiar, I think it's important to look at this history together. Simply put, the sum here is much worse than the parts. Prior to the Civil War, not a single Supreme Court case chipped away at the institution of slavery or did anything to protect slaves. When the court was involved, it was entirely to protect slave owners and to uphold the institution of slavery. From 1787 into the adoption of the 13th Amendment in 1865, a period of 78 years, the court did nothing to further abolition. Everyone in this audience is familiar with Prigg versus Pennsylvania in 1842, where the court enforced the Fugitive Slave Clause and declared unconstitutional a state law that prohibited removing an escaped slave to Pennsylvania by force or violence. We celebrate Justice Joseph's story as one of the greats in Supreme Court history, but we cannot do that unless we overlook his tragically wrong decision in Prigg versus Pennsylvania. Everyone here, of course, is familiar with Dred Scott versus Sanford in 1857, where the Supreme Court held that slaves are pieces of property, not citizens, even if they're born in the United States. The Supreme Court declared unconstitutional the Missouri Compromise as an impermissible taking of property of slaves from their owners. We should not excuse the court for these abhorrent decisions. The court could have and should have done much better in bringing about an end of slavery. From 1896 to 1954, the court articulated and enforced apartheid, the doctrine of separate but equal, which of course was separate and always unequal. The Supreme Court enforced the Jim Crow laws that segregated every aspect of life in southern states and many border states. Of course, everyone in this audience is familiar with Plessy versus Ferguson, the 1896 decision that upheld separate but equal. But we shouldn't forget the cases that followed it. Cumming versus Board of Education, 1899, where the Supreme Court held that the government could maintain a whites-only high school when no high school is available for blacks. Or Berea College versus Kentucky in 1908, where the court held that Kentucky could prohibit a private college from admitting blacks. Or Gong Lum versus Rice, where the court in 1927 held that Mississippi could exclude Chinese students from white schools. I could go on. So many other cases during this period of 58 years where the Supreme Court aggressively upheld Jim Crow. We look at the Warren Court as our model for advancing racial equality. But on reflection, I would suggest it's less admirable than it seems. Now, I don't want to deprecate the importance of the Warren Court's efforts. It did finally overrule Plessy. It did strike down the laws that created apartheid in every aspect of life. But there's also some other aspects of the Warren Court we shouldn't overlook. First, Brown itself was written narrowly, and it never explained why segregation was inconsistent with equal protection. Brown, in Chief Justice Warren's opinion, focused solely on how separate schools hurt the education of Black children. What the court didn't explain was why segregation was inconsistent with the very essence of equal protection under the Constitution. So I'm sure you remember the Supreme Court struck down other laws imposing segregation without opinions. In a series of per curiam decisions, the Supreme Court declared unconstitutional the laws that segregated parks, in beaches, in playgrounds, in every aspect of life. But never did the Supreme Court write the opinion explaining that equal protection inherently is meant to repudiate the idea of subordination of a race. Laws requiring segregation are based on that subordination. Second, even in the area of education, Brown did little to bring about equality or to end segregation. As everyone knows, when Brown was decided on May 17, 1954, it didn't indicate the remedies to be imposed to end segregation. The court had the case re-argued the next year. And then it didn't impose timetables, didn't prescribe remedies. Instead, what it said was that it would send the cases back to the lower courts to bring about desegregation with, quote, all deliberate speed. As I always tell my students, the very phrase all deliberate speed is an oxymoron. If you go back to the day after Brown 2 was decided and read the articles in the New York Times and other newspapers, the segregationists declared that it was a major victory. And it was, because the Supreme Court did nothing to bring about an immediate end to segregation. Justice John Paul Stevens, in a book many decades later, said that he believed that the court made a mistake in choosing unanimity over remedy. The result was that a decade after Brown, not one Black child was attending school with a white child in Alabama, Mississippi, or South Carolina. In North Carolina, where this conference is hosted, less than 0.1% of Blacks attended school with whites in 1964, a decade after Brown versus Board of Education. Third, we often forget that it was the Warren Court that was responsible for greatly expanding racialized policing in Terry versus Ohio in 1968. In Terry versus Ohio, the Supreme Court held that the police could stop individuals without needing probable cause, could search them without needing probable cause. The Supreme Court said that only, quote, reasonable suspicion was required. To this day, the Supreme Court has never defined what's enough for reasonable suspicion. As recently as 2020, the Supreme Court said it's more than a hunch, but less than probable cause. But study after study has shown how this standard of reasonable suspicion has fostered racialized policing. It has made it too easy for police to stop individuals solely for being Black or being brown. Statistics in every major jurisdiction, whether it's where I live in California or in North Carolina where this conference hosted, shows that Black and brown people are disproportionately stopped by the police, disproportionately frisked by the police. This was entirely foreseeable in 1968. The NAACP Legal Defense Fund wrote a stunning brief to the Supreme Court explaining how adopting a standard like reasonable suspicion would reinforce and even further racialize policing. Terry versus Ohio was an 8-1 decision. Only Justice William O. Douglas dissented. It came down from the most liberal Supreme Court we've ever had in American history. The majority opinion was written by Chief Justice Earl Warren. The majority included, among others, William Brennan and Thurgood Marshall. It's interesting to speculate why the Warren Court, at the height of its being liberal, handed down a decision like this. I think in part the Supreme Court was reacting to the intense criticism of its other decisions protecting criminal defendants in the 1960s. A case like Matt versus Ohio, Miranda versus Arizona. I think it has to be remembered that it was decided in 1968 in the midst of a year at a time when there were many urban disturbances. It's a time when there's great concern over crime control. But as we applaud the Warren Court for all that it did, we can't forget Terry versus Ohio and its tragic effects with regard to racial policing. The Burger Court that followed the Warren Court had a devastating effect on many key aspects of racial equality. Let me pick a couple of examples. In the area of public schools, the combination of San Antonio Board of Education, Rodriguez in 1973, and Milliken versus Bradley in 1974, created and institutionalized separate and unequal schools in virtually every metropolitan area in the United States. San Antonio Board of Education versus Rodriguez was a challenge to the Texas system of funding public schools largely through local property taxes. The result was that poor areas had a tax at a high rate of assessed valuation, but still had relatively little to spend on schools. Wealthy areas with large property tax bases could tax at a low rate of assessed valuation and had far more to spend on schools. Even in a single metropolitan area like San Antonio, where there are different school districts, there was a huge disparity in funding for education. I grew up in Chicago. I went to Chicago public schools for a time. And the difference in the funding then and now between, say, the Chicago public schools and the New Trier and the Glenbrook public schools is dramatic. But the Supreme Court, in a 5-4 decision, upheld the Texas system for funding schools. Justice Lewis Powell for the court, he'd been appointed by Richard Nixon. His majority opinion was joined by Warren Burger, Harry Blackmun, and William Rehnquist, who had been appointed by Richard Nixon, and also by Potter Stewart, who had been appointed by President Eisenhower. Justice Powell, in his opinion, said that education is not a fundamental right under the Constitution. He said it's not explicitly mentioned, and it's not implicitly there. This, I think, is the most tragically wrong Supreme Court decisions in all of American history. The court also said that poverty is not a suspect classification. A year later, the court decided Milliken versus Bradley. It arose from the Detroit area, and it was an attempt of the federal court to desegregate the public schools there. Detroit, like cities throughout the country, was an inner city, city itself that was predominantly minority students, surrounded by suburbs that were predominantly white students. Again, to focus on my hometown of Chicago, see the same thing with the Chicago public schools, overwhelmingly students of color, but surrounded by suburbs that are almost entirely white. The federal judge formulated a desegregation plan that would involve taking some of the students from the white suburbs and bringing them to the city, taking some of the city from moving them to the suburbs. The Supreme Court, again in a 5-4 decision, again with the 4 Nixon appointees in the majority, held that there generally cannot be such inter-district remedies. So you put these two cases together, you end up with city schools that have far less to spend on education and that are predominantly students of color, and the suburban school districts that are predominantly white that spend far more on education. These two cases did institutionalize the separate and unequal schools that continue to exist to this day. A second set of tragic decisions from the Burger Court concerned the requirement for proof of discriminatory intent. as everyone in this audience knows, in Washington versus Davis in 1976, the Supreme Court held that equal protection violations were proof that the government acted with the intent to discriminate. Case involved a Washington, D.C. requirement that in order to be police officers, individuals had to pass a test. Statistics showed that African Americans failed that test significantly more often than whites. But the Supreme Court, in an opinion by Justice Byron White, said that equal protection is meant to deal with purposeful discrimination. Discriminatory impact is not enough to prove race discrimination. In fact, discriminatory impact isn't enough to trigger more than rational basis review. It doesn't shift the burden of proof to the government to demonstrate that there is a non-racial justification for its actions. Discriminatory impact just means that the government is most always likely to prevail when there is a constitutional challenge. The court followed this up with other cases. In McCleskey versus Kemp, which was litigated by Jack Boger, the Supreme Court said that proof of racial discrimination in the application of the death penalty is not enough to bring an equal protection challenge. The court said unless it could be shown in Georgia, where the case arose, that the Georgia legislature adopted the death penalty for a discriminatory purpose, or that the particular jury had a discriminatory intent, there's no basis for bringing a challenge. In Mobile versus Bolden, the Supreme Court said that proof of a discriminatory impact with regard to an election scheme is not enough to show a violation of the 14th and 15th Amendment. The importance of these decisions in limiting the reach of equal protection cannot possibly be overstated. And then the Supreme Court followed them by making it very difficult to prove discriminatory intent. In Personnel Board versus Feeney, the Supreme Court said it's not enough to show that the government acted with knowledge that there'd be a discriminatory impact. It has to be proven that the government took the action with the desire to bring about the discriminatory impact. In Village of Arlington Heights versus Metropolitan Development Corporation, the court showed the very limited ways in which there can be evidence to prove discriminatory intent. These decisions so terribly narrowed the reach of equal protection and the ability of courts at any level of government to remedy the discrimination that exists. When we think of the Burger Court, in addition to these areas, we often want to focus on the one area where there seemed to be a triumph then for racial justice: affirmative action. In 1978, in Regents of the University of California versus Bakke, the Supreme Court, in a splintered 5-4 decision, upheld the ability of college universities to engage in affirmative action. Subsequent cases, like Grutter versus Bollinger and Fisher versus University of Texas Austin, have reaffirmed that holding from Bakke. But I would suggest that Bakke was less of a victory than it may seem. Bakke said that affirmative action is permissible only for the sake of enhancing diversity. The court rejected, and ever since has rejected, what affirmative action is really about: remedying the long history of discrimination, ensuring equal opportunity and equal playing field. When the court says that affirmative action is allowed only for the sake of diversity, isn't it really saying that affirmative action is allowed because it benefits white students who are able to learn in a diverse classroom? Doesn't the court then set up the criticism that later came from Justice Clarence Thomas, that it's really an aesthetic, that it makes us feel better to look out at a classroom with the diversity of faces that are there? I do not mean to lessen the importance of diversity. I've been a law professor for 41 years. I've taught courses like constitutional law and criminal procedure in classrooms almost all white, in classrooms with a significant number of students of color. The education for all students is better when there's diversity. But I think that the court made a mistake, a terrible mistake in Bakke, in rejecting what affirmative action is really about and focusing just on diversity. The Rehnquist and the Roberts courts have very much continued down the path begun by the Berger court. In so many ways, the Rehnquist and the Roberts courts have set back the quest for racial justice. Let me mention just a few quickly. First, the Rehnquist and the Roberts courts have limited the ability of the government to deal with school segregation. For example, in Oklahoma City versus Dahl in 1991, the Supreme Court said that effective desegregation orders must end once they succeed. In other words, an effective desegregation order that really does bring about desegregation in the public schools has to cease as soon as that's achieved. The Supreme Court said that's so, even though ending the desegregation order will mean the resegregation of public schools. In Parents Involved in Community Schools for Seattle School District Number 1 in 2007, the Supreme Court said that public school boards for K through 12 cannot use race as a factor in assigning students to schools unless they meet strict scrutiny. Chief Justice Roberts wrote the opinion for the court. Infamously ended by saying, the way to stop discriminating based on race is stop discriminating by race, and emphasized his view that the Constitution requires that the government be colorblind. The effect of these and other cases from the Rehnquist and Roberts courts have meant that our public school systems are ever more segregated. I remember speaking at a wonderful conference here at UNC Law School that Jack Boger put together about the resegregation of North Carolina public schools. The same thing has been seen throughout the country. A second effect of the Rehnquist and Roberts courts has been to further empower racialized policing. I have a book coming out this summer that's titled Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. And I focus a great deal on what the Rehnquist and the Roberts courts have done in this regard. Let me pick one example, and maybe it's less familiar to you than the other cases that I've been discussing. It's a case called Wren versus United States from 1996. It involved some undercover police officers who were driving around the District of Columbia. They saw a car that was stopped at a stop sign. So that was an unusually long period of time, about 40 seconds. I have the world's worst sense of direction. I am often stopped at stop signs that long. It used to be to try to read a map. Now to look at my GPS. Solely on the basis of this, the officers decided to follow the car. They waited until the car turned without a turn signal. They pulled over the car. In DC, undercover police officers are not allowed to enforce traffic laws, but they pulled over the car for turning without a turn signal. They then, as they're allowed to do, ordered the driver and passengers out of the car. They did a search of the immediate area and they found drugs. No one denied that the traffic stop was entirely pretextual. But the Supreme Court unanimously ruled in favor of the police officers. Justice Scalia wrote the opinion for the court. He said, so long as the officers have reasonable suspicion for a stop, let alone probable cause, they're allowed to do so. Their subjective motivations don't matter. If any decision furthered racialized policing, the stopping of drivers just for being black or brown, it was Wren versus United States. It remains the law to this day. Final example, as I talk about the Rehnquist and the Roberts courts, is how it struck down crucial civil rights laws. We're all familiar with the Supreme Court's decision in Shelby County versus Holder from 2013. I think the Voting Rights Act of 1965 is one of the most important laws adopted in my lifetime. Section 2 prohibits state and local governments doing election systems that discriminate against minority voters. But Congress knew that wasn't enough. Congress had seen how especially southern states would repeatedly adopt discriminatory laws to disenfranchise minority voters. One would get struck down, only for another to be adopted. It was like the old arcade game of whack-a-mole. So Congress created Section 5 of the Voting Rights Act. Section 5 says that jurisdictions with a history of race discrimination in voting would need to get pre-clearance, pre-approval before significant changes in their election systems. Section 4 was the formula which provided for which systems, which election systems, which state and local governments would need to get pre-clearance. In 2006, Congress almost unanimously extended this for another 25 years. President George W. Bush signed it into law. By every account, this was enormously successful. But the Supreme Court, 5-4, declared Section 4 of the Voting Rights Act unconstitutional and thus nullified Section 5, the pre-clearance procedure. Why? What was the constitutional provision or principle that this violated? Chief Justice Roberts said it violated the principle of equal state sovereignty, that Congress must treat all states the same. But where in the Constitution is that found? I'm obviously not an originalist, but if there's any place where original meaning seems clear, it's that Congress in 1868, when it ratified the 14th Amendment, did not mean to require that all states be treated the same. The same Congress that ratified the 14th Amendment also voted to impose Reconstruction on southern states, literally military rule over the former rebel states. And yet, the 5 most conservative justices in Shelby County v. Holder set aside their originalism and struck down this enormously important law. Very quickly, states like North Carolina and Texas instituted the very voting restrictions that pre-clearance had been denied for. So this is a very quick sketch of familiar history, but you can see when you put it together why I say the sum is worse than the parts, and the Supreme Court has a dismal history. It brings me to the second question that I posed. What now from the Supreme Court? Having painted a bleak picture of the past, I fear it's going to get worse with the 6 conservative justices on the current court. What might we expect in the foreseeable future? Let me suggest 3 things. One is a narrow interpretation of civil rights laws. I want to point your attention to a case from last term that didn't get much media attention, but is given effect with regard to many federal civil rights laws. It's a case called Comcast versus National Association of African-Owned Media. I should disclose here that I briefed and argued this case in the Supreme Court, and I lost by the close margin of 9-0. My client, Byron Allen, may be familiar to you. You might have seen him perform. He owns the Weather Channel. But that's not what this case is about. This case involves 7 cable channels that he owned. If you get DirecTV or Dish TV or Uverse, you would have these Byron Allen channels. But Comcast refused to carry them. Allen went and asked for them to be included in the Comcast service. The Comcast officials told him that there were many things he needed to do in order to be considered. He spent hundreds of thousands of dollars to jump through those hoops. He then went back and asked them to carry his channels. They said, sorry, they no longer had bandwidth. But he said, you've picked up in the meantime 85 white-owned channels. A Comcast official said to him, according to the complaint, quote, we don't want to create any more Bob Johnsons. Bob Johnson being the very successful head of the Black Entertainment Television Network. Allen, through the National Association of African Media, sued in federal district court in Los Angeles. The judge, in a short opinion, without explanation, granted Comcast's motion to dismiss for failure to state a claim. I argued the case in the Ninth Circuit in October of 2018, and I prevailed. The Ninth Circuit said that all that's required in order to sue under 42 United States Code, Section 1981, is to allege that race was a motivating factor in the denial of the contract. Section 1981 was adopted as part of the Civil Rights Act of 1866, the year after the Civil War. It says that all persons should have the same right to make and enter and enforce contracts as white citizens. And the Ninth Circuit said that Allen stated a claim for race discrimination in contracting. Comcast sought and received cert in the Supreme Court, and the Supreme Court, in an opinion by Justice Neil Gorsuch, said that in order to have a claim under Section 1981, it has to be alleged and proven that race was the but-for cause for the denial of the contract. Justice Gorsuch said that 1981 was written against a backdrop of tort law. Tort law requires but-for causation. I think historically, Justice Gorsuch is plain wrong here. There was an amicus brief filed in the court by John Witt of Yale and Mark Gergen of Berkeley that showed that but-for causation with regard to tort law didn't develop until the early 20th century. Why does this case matter? Well, as every civil rights lawyer knows, it's a lot harder to allege and prove but-for causation than show that race is a motivating factor. As an example, an answer I gave to a question from Justice Sotomayor at oral argument is imagine somebody goes to a hotel to rent a room. And imagine that the proprietor says, sorry, we don't have rooms available. And besides, we don't rent to Black people. Imagine the complaint alleges those facts. If it's enough to say that race is a motivating factor, that complaint would stand a motion to dismiss. But if it has to allege that race is the but-for cause, that complaint fails. And what's particularly troubling about this decision is Justice Gorsuch, writing for a unanimous court, said that all federal civil rights laws are understood as requiring but-for causation unless Congress has specifically provided otherwise. Title VII specifically provides otherwise, but almost no other civil rights statute does that. So the Supreme Court here has very much narrowed the availability of civil rights remedies. I fear it's going to do so in other ways in the years ahead. I concluded my oral argument in the Supreme Court by saying Congress had such a broad remedial purpose for the Civil Rights Act of 1866. I said to the court, you have two different ways of reading the statute. One that every civil rights organization favors, as indicated by the amicus briefs filed. The other favored by Comcast and the Chamber of Commerce and the Trump administration, which seems more consistent with what Congress intended. 9-0, the court rejected that argument. Second, with regard to the foreseeable future, I fear that we're going to see an end of affirmative action. I ask you the following question. Are there 5 possible votes to reaffirm Bakke, Grutter, and Fisher? Remember, Chief Justice Roberts, in his opinion, and parents involved in Community Schools Without Students #1, explicitly said that he believes that the Constitution requires the government to be colorblind. In Shuadi versus Bam, a number of years later, Chief Justice Roberts reiterated this view. I think there are now likely 6 votes on the Supreme Court, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, to say that Bakke, Grutter, and Fisher were wrongly decided. Obviously, I hope I am wrong. I believe that affirmative action is crucial to remedying past discrimination and achieving diversity. But I don't see any indication from any of these 5 justices. My hope is that the Supreme Court will not take the First Circuit case involving Harvard University, that the very factual nature of the district court in the First Circuit's holding mean that the court will stay away from it, and that the court will stay away from this issue. for a number of years. But ultimately, I think so long as these 6 justices are there, it's not likely that affirmative action will survive. And to continue bleak predictions for the future, the third is I'm very worried about what the Supreme Court's going to do with regard to statutes that allow for disparate impact liability. I mentioned earlier, and everyone here knows, that the Supreme Court has held that for equal protection, disparate impact is not sufficient. But statutes can allow for disparate impact liability. In 1971, in Griggs versus Duke Power, the Supreme Court held that disparate impact is sufficient under Title VII with regard to employment discrimination. The Supreme Court said that Congress, in the Voting Rights Act of 1982, effectively overruled Mobile versus Bolden by saying that for purposes of the Voting Rights Act, disparate impact is enough with regard to voting. In 2015, in Texas Department of Community Affairs versus Inclusive Community, the Supreme Court 5-4 held that disparate impact liability is allowed under the Fair Housing Act of 1968. As everyone knows, it is so much easier to prove disparate impact than it is to show a discriminatory intent. But I worry that the conservative justice on the court might go so far in the future as to say that disparate impact liability denies equal protection. Justice Scalia, in a concurring opinion, in Ritchie versus Stefano, outlined this. He said, disparate impact liability requires that decision makers take account of race in order to avoid liability. He said, for the government to require that decision makers take account of race is inconsistent with a constitution that he sees as requiring colorblindness. You find this echoed in some of the dissents of Justice Alito in voting cases, and most recently by Justice Thomas in his dissent in the Texas case in 2015. I worry that with this conservative majority, there could be a real threat to disparate impact liability under statutes. I, of course, so hope I am wrong in this fear. As we look to the foreseeable future, it's not just this year or next. Think about the age of the conservative justices. Amy Coney Barrett is 48 years old. If she remains on the Supreme Court until she's 87, the age at which Justice Ginsburg died, Justice Barrett will be on the court until the year 2059. Neil Gorsuch is only 53. Brett Kavanaugh is 55. Just a few weeks ago, John Roberts turned 66. Sam Alito will turn 71 on April 1st. Clarence Thomas is just 72 years old, even though he's been on the Supreme Court since 1991. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the Supreme Court. Justice Stevens didn't step down and retire until he was 90 years old. So it's possible to imagine that at least 5 of these 6 justices will be together for another decade or 2. So this then brings me to the third part of my remarks, the hopeful part. What are the alternative ways to achieve racial justice? I believe that there are other paths to achieve racial justice, not focusing on the Supreme Court or the federal judiciary. Let me outline 3 that I think are going to be quite important. The first is at the institutional level. What institutions can do so as to combat discrimination, to achieve diversity, to remedy discrimination. At the institutional level, I believe it will be possible to continue to engage in affirmative action, even if the Supreme Court overrules Bakke and Grutter and Fisher. And I can speak here from experience, having been part of the University of California system for the last 13 years. As I'm sure you know, in 1996, California voters adopted an initiative commonly referred to as Proposition 209 that ended affirmative action in the state. It said that state and local governments cannot discriminate or give preference on the basis of race or sex in education, contracting, or employment. Initially, this had a devastating effect on diversity at schools such as UCLA and Berkeley. The statistics are stunning in terms of the precipitous drop in Black and Latinx students. But over time, schools like UCLA and Berkeley have discovered ways to achieve diversity consistent with the end of affirmative action. I am at a law school where 50% of the students are students of color. In the time that I have been dean at Berkeley, we've gone from 12 African-American students in the first year class to then having 28 African-American students to 33 to this year having 43 African-American students in our 1L class. We've done this completely consistently with the decisions of the California Supreme Court and Proposition 209. UCLA, other UC schools have done this as well. California is not the only state where these initiatives prohibiting affirmative action. And schools in these states as well found ways to achieve diversity. So the overruling of Bakke and Grutter and Fisher need not mean the end of diversity and the end of remedies for discrimination. My great fear is that overruling Bakke and Grutter and Fisher will have an immediate adverse consequence. It'll be like that scene in California. I worry also that it will let administrators who don't really care about diversity and remedying racial inequalities to throw up their hands and say there's nothing they can do. But at the institutional level, we must make a difference, no matter what the Supreme Court decides. Second, we must increasingly turn to state courts and state constitutions. In 1977, Justice William Brennan wrote an article in the Harvard Law Review urging the use of state courts and state constitutions. He had seen the change in the Supreme Court from the shift from the Warren to the Burger Court. He saw a conservative court for many years to come. He obviously couldn't foresee how long it would last or how conservative it would become. But he urges an alternative turning to state constitutions and state courts. We must do this, and we must do this in so many areas to achieve racial justice. And there are plenty of precedents where it's worked. Let me start with the example of marriage equality. The lawyers who are responsible for the strategy to create the right of marriage equality for gays and lesbians wisely began in state courts under state constitutions. They started, of course, in Massachusetts, and they didn't bring any federal claims. Had they done so, the case could be removed from state to federal court. They filed only claims under the Massachusetts Constitution. And in the Goodridge decision, 2003, the Massachusetts Supreme Judicial Court found that it violated the Massachusetts Constitution to keep gays and lesbians from marrying. There was then litigation in other states. It failed in New York. It succeeded in Iowa. It succeeded in California. There then were initiatives and momentum built. Had this gone to the Supreme Court in 2003, there is no possible way the Supreme Court would have found a right to marriage equality. But this strategy, beginning with state courts and state constitutions, meant that within a dozen years, 2015, in Oberfeld versus Hodges, the Supreme Court could find a federal constitutional right to marriage equality everywhere in the country. Or as another example, I point to how just a year ago, the Washington State Supreme Court found that the state death penalty violated the state constitution. The Washington Supreme Court's decision focused on the racial disparities with regard to the administration of the death penalty. The same kind of statistics that the court in McCleskey versus Kemp said didn't matter under equal protection were deemed to violate the Washington Constitution. or the area of school finance. As I mentioned, in San Antonio Board of Education versus Rodriguez, the court said disparities in school funding don't violate the United States Constitution. But many state courts, places like New Jersey, Texas, California, have found that disparities do violate the state constitution. Another example here is with regard to policing. Many state Supreme Courts have found that things that don't violate the United States Constitution, because Supreme Court's restrictive interpretations of the Fourth and Fifth Amendments, do violate the state constitutions. I gave the example earlier of Wren versus United States, which allows pretextual stops. Several state Supreme Courts have said that that's not allowed under state constitutions. I think some of the burden here is going to be on law schools. We need to do a better job of teaching state constitutional law. I think some of it is that the lawyers who litigate these cases that previously might have reflexively gone to federal court now need to think about using state courts and state constitutions. A third avenue for change is state and federal legislation. Congress, state legislators, local city councils can do so much to advance racial justice. Congress can adopt federal civil rights laws to fix bad decisions like that in Comcast. Congress can amend federal civil rights statutes to say that it's sufficient to show that race is a motivating factor. It doesn't have to be but for cause. Congress, for that matter, state legislators, can expand the ability to find violations based on disparate impact liability. At least unless and until the Supreme Court says it's not allowed, statutes can create disparate impact liability and need to do so. Congress needs to reform the voting and the political process, including adopting legislation to overcome Shelby County and reinstitute a form of preclearance. And Congress and state legislators can do so much to reform and change policing in the United States. They can outlaw practices like the use of the chokehold, racial profiling, no-knock warrants that lead to abuses and deaths. Congress by statute can change the standard of qualified immunity, which has provided protection for so many police officers who engage in excessive force, including that which leads to death. Congress can expand the liability for local governments to give them the incentive to oversee policing and make a change. As I said at the beginning, the protests for racial justice in every one of the 50 states provide an impetus for this reform. And it's our responsibility to continue that pressure. Though I paint a bleak picture with regard to the Supreme Court, I believe that there can be tremendous advances for racial justice through other avenues, such as the ones that I've mentioned. And I think if we look at these other avenues for change, we can have enormous hope and optimism for the future. Over the course of American history, there have been tremendous advances in our society with regard to equality and liberty. There is, of course, tremendous work to be done to solve the great racial inequities that remain in American society. But no one can deny that there's been progress. I was born in 1953, at a time when every Southern state was segregated by law. Well, there's an enormous way to go with regard to progress in terms of sex equality, but there's certainly been great progress in all of our lives. Or I think with regard to sexual orientation, it is just 6 years ago that the Supreme Court held that state laws prohibiting same-sex marriage violate equal protection and deny due process. There's been a tremendous growth of freedom over the course of American history. I think that the late Dr. Martin Luther King got it exactly right when he said, "The arc of the moral universe is long, and it bends towards justice." Again, thank you so much for having me to begin this wonderful conference.
Thank you so much, uh, Dean Chemerinsky, my dear friend Irwin. Uh, that was a uh, panoramic tour of Supreme Court jurisprudence related to the 14th Amendment. And we want to get to questions and answers, although I want to cue up that we jump right into your address to get us started um, in a moment after we do question and answer. Alan Buenti, the Deputy Director of the Center for Civil Rights, will come to us with some housekeeping remarks. But I invite those of you who are uh, able to and enabled to submit any questions and answers. We have a lot of people who are here virtually for the conference. We will only be able to take a few of them, but nonetheless, if anybody has questions and answers, or questions for answering rather, we appreciate your submission. A few questions just to start us off, Erwin. Um, I, as I listened to your address, I was thinking about why this symposium at this time. I mean, you've been to many, many symposiums, participated in many of them, seen others. And here with this Supreme Court at this moment, why participate in another symposium on the 14th Amendment? If there had been a different and successful appointment by a different president after the passing of Justice Scalia, we'd be in a different moment, perhaps, or somewhat of a different moment. And certainly, if there had been an appointment by now President Biden after the passing of Justice Ginsburg, on top of that other possible appointment, we'd be in a different moment. And this would be a different symposium. Is this, I was thinking about the question about it, whether this is a sour grapes moment, or is there a productive purpose to our gathering virtually? Put differently, as the symposium is entitled, is there a way forward? And you seem to be indicating yes, but it's not 14th Amendment. It's not the federal Constitution. And yet, even though you said it's going to get worse, you come back to hope and the moral arc of the universe bending toward justice. And so I appreciate your hope, but in counterbalancing it with the sobering reality that you've talked about, the question is, how much can we really accomplish now? And whether what's left of the 14th Amendment that's constructive for people who want progressive change.
Let me answer the question this way. In November 2016, after Donald Trump was elected, the students at the school where I was, University of California, Irvine, were enormously upset. And they called a meeting of students and invited a few faculty to speak. And I concluded what I said to them by saying that we really only have two choices. We either have to give up or we have to fight harder. And that means we really only have one choice. We have to fight harder and better than we ever have before. I don't think we're going to succeed in most of those fights in this Supreme Court. It doesn't mean we're never going to win. In Bostock versus Clayton County, Georgia, just in June, the Supreme Court said that Title VII prohibits discrimination based on sexual orientation and gender identity. So that was a civil rights victory. But I think those victories are going to be few and far between in the court. I think what we need to do is to channel the energy into looking for other avenues for reform, which I was trying to talk about. But I also think one other thing, Ted, if we look to the long term, this court isn't going to be there forever. The court is an accident of history, and the manipulation by Senator Mitch McConnell. There's going to be a time with a progressive majority on the Supreme Court, and we need to set forth now the intellectual framework for what it should be doing then. If only Merrick Garland had been confirmed, if only Hillary Clinton had won and replaced Kennedy and had replaced Ginsburg, we'd have that court today. But it's going to come, and conservatives did such a good job of laying an intellectual framework for the long-term future. So when they had control of the court, the agenda was in place. Progressives need to do that now, especially with regard to race.
Another question. Do you think the Supreme Court's resistance to the changes in the area of race are somehow special, more grudging than its holdings in areas of gender, sexual orientation, et cetera? And if so, why? Is it the reflection of the court's own prejudices or its silent assessment of the likely degree of popular and political resistance? To put it differently, it's significant that the marriage cases and the cases involving rights of LGBTQ people in recent years, they've come even when the court was conservative, maybe not as conservative as it appears to be now, but nonetheless conservative.
Yes, I mean, I think we have to focus on the fact that Shelby County was 5-4, and the marriage equality decisions were 5-4. United States v. Windsor in 2013, Obergefell versus Hodges in 2015. In fact, if you think back to 2013, Shelby County came down on a Tuesday, and it was 5-4 with the 5 conservative justices in the majority, Ginsburg writing her stirring dissent, one of her very best, joined by Breyerson and Kagan. Literally the next day, the Supreme Court strikes down key provision of the Defense of Marriage Act, with the 4 liberals, Ginsburg, Breyerson, and Kagan, being joined by Justice Kennedy. Or the last affirmative action case, Fisher versus University of Texas in 2016. It's Kennedy who's joined by Ginsburg, Breyer, and Sotomayor, who's the majority in that case. So when we talk about the court, what we're really saying is Justice Kennedy was much more focused on and wanting to advance the rights of gays and lesbians, transgender individuals, than Justice Kennedy was focused on racial equality. And if you look at the current court, I think when it comes to marriage equality, it would have come out very differently today than it did in 2015. That said, I think the overall premise of the question is right, that the Supreme Court has been, over the course of American history, much worse with regard to race than with other kinds of discrimination.
That may be a piece of you. It's going to get worse. Your reference to the how these cases regarding the rights of LGBTQ people would have been decided if they were before the present court. One of our panelists who will speak later asked a variation of this question. Doesn't the likelihood that states and other branches of government presuppose a cultural desire to end racial discrimination, doesn't broad support for Trump suggest that such a consensus might not exist? Your thoughts?
One of the difficulties in relying on states, state courts, state constitutions is to win, you have to win in all 50 states, and that's not going to happen. Whereas if you can win in the Supreme Court, it's for the whole country. I think that there are places where there can be sufficient support for and substantial successful efforts towards racial justice. I don't think it's going to be in all 50 states. And you're right in the question that Donald Trump got 74 million votes, but Joe Biden got 81 million votes. And there are places like California where Biden won basically 2/3 of the vote. So in those places, I think that we need to use this impetus for racial justice. And hopefully that can then lead to pressure in other states where the political process is less inclined. But I'm not being Pollyannish. I'm not saying in all 50 states that there's going to be successful state legislation and use of state courts, but I do think it can happen in many places.
I want to ask a question or a combination of questions involving your case with respect to Byron Allen and Comcast, and connected to something that we've seen in Fisher. There was a time many decades ago when the NAACP Legal Defense Fund almost had or virtually had a monopoly on race discrimination cases that went to the Supreme Court. That time is long gone. And cases come from all kinds of places now and involving all kinds of plaintiffs and parties. In your case, some people observed that Byron Allen may not have been the most sympathetic plaintiff because he was wealthy. And the connection with Fisher is the part of oral argument in Fisher where there was an exchange with Justice or between Justice Alito and a lawyer for the University of Texas when Justice Alito asked a hypothetical about, and you'll remember this, about Black parents who were a doctor, a lawyer. Why should they get the benefit of diversity? After all, he asked something like this, wasn't all of this about helping the disadvantaged? So the notion being that diversity really should not play to the benefit of wealthy or upper middle class people of color. Is there a hostility with respect to people bringing claims or being beneficiaries of diversity efforts? Those are two different things, but nonetheless, there's a connection here, arguably. Is there a hostility with respect to them and claims or diversity beneficiaries?
The obvious answer is yes. Now, what we've learned in California is that affirmative action solely on the basis of social class doesn't yield racial diversity. And the reason for that is simple arithmetic. Though a much larger percentage of African Americans and Latinx individuals are disadvantaged, in our society, the number of disadvantaged whites is greater. So if you create affirmative action solely on the basis of disadvantage, you don't achieve racial diversity, and you're not remedying the long history of racial inequality. But in terms of how judges react or justices react, of course you're right, Ted, that their instinct is, as Justice Alito said at the oral argument, well, why should this child of a Black doctor or professor be a beneficiary? It's a very narrow view of what affirmative action is about. And of course, you and I had conversations before the Comcast case was argued in the Supreme Court of exactly this issue. It wasn't, though, that Byron Allen took the case to the Supreme Court. Byron Allen won in the lower courts, and Comcast took the case to the Supreme Court. And there wasn't, we tried to find a path to keep this case away from the court and settle it, but there just wasn't such a path. And it ended up making very bad law. But the bottom line answer to your question is obviously yes.
Let me shift for a moment. Are you more hopeful when you think about the rights of Native American people, given the Oklahoma case, given McGirt? Do you have more hope with respect to a muscular application of the 14th Amendment?
I was more hopeful this past summer when McGirt came down. McGirt, for those who aren't familiar, involves a part of Oklahoma where there was a treaty between the United States government and the Creek tribe. And it provided that members of the Creek tribe who were prosecuted for crimes either to be prosecuted in tribal court or in federal court. And it allows individuals convicted in state court. And the Supreme Court, in an opinion by Justice Gorsuch, said that treaties have meaning and that the treaty between the United States and the Creek tribe had to be enforced. And this, especially the stirring language at the end about that, provided hope that maybe this is a court that's going to really advance Native American rights. But that was 5-4. Gorsuch was joined by Ginsburg, Breyer, Sotomayor, and Kagan. Roberts, Thomas, Alito, Kavanaugh dissent. Well, whether McGirt is going to matter much in the future is whether Amy Coney Barrett is more likely to agree with Gorsuch, Breyer, Sotomayor, and Kagan, or is she more likely to agree with Roberts, Thomas, Alito, and Kavanaugh? My guess, everything we know about Amy Coney Barrett, is the latter is more likely than the former.
What strategies were used at Berkeley and UCLA after affirmative action was ended in California? What can other universities do more specifically? And I want to throw something else into that question, which has been submitted, and that's, haven't you been conflating affirmative action with diversity? Is there anything to be gained by drawing a distinction between those two things?
Diversity is a goal. Affirmative action is a means. Now, diversity is a goal because of the educational benefits of diversity, but diversity is also a goal because it's how we remedy the long history of discrimination. Affirmative action is a means to achieving diversity. Obviously, there's many other means as well. If we would improve K through 12 education for Black and Latinx students, affirmative action would be less necessary at the college or law school level. But we can't wait for that to happen. I think that there's so much to say beyond our last minute or two about what the UC schools have done to achieve diversity in the face of Prop 209. And I hope, if ever my prediction would come true, and I hope it doesn't, that there's the end of affirmative action, that other college universities will look at places like the UC system or University of Michigan that are able to achieve diversity. I'll give one example, just an immediate one. As I said, my first year at Berkeley, which was 2017, there were only 12 Black students in the first year class. And I was enormously worried about that. I mean, I was horrified by the statistic, but also worried it would then create a self-fulfilling effect that fewer Black students would then come. And I asked my admissions team and a committee on equity and inclusion to look at what was it that, where were we hurting? Was it a lack of applications? Was it a lack of acceptance? Or was it a lack of retention, of getting them to come? And we learned that it was the latter, that there wasn't a lack of Black applicants or Black admissions, but they were choosing to go to other law schools. So we created a program of using our alumni, our students, and our faculty to aggressively reach out to those who we had accepted to try to recruit them. As I said, the next year jumped from 12 to 28, the next year to 33, this year to 43. And that's just one technique, and it proved effective. Now, I realize that what that means is we're not enlarging the pool. We're taking students would have gone to other law schools. And what we have to do is enlarge the pool. And that's a whole nother conversation of the things that I think law schools need to be doing, college, university doing in terms of pipeline programs to enlarge the pool, not just take students from one school to another.
Uh, I want to go back to what you said, though, about institutions and diversity effort / affirmative action, and ask what is a cheeky question, admittedly. Are you advocating another version of massive resistance if the Supreme Court strikes down, diversity efforts, affirmative action? What's different with respect to what you're saying about institutions and resistance in the 50s to Brown?
I think it's the difference in the goal, that the massive resistance of the 1950s was to perpetuate segregation. Here, if it's massive resistance, it's about remedying racial injustice. And to me, that makes all the difference. Now, what I'm urging with regard to massive resistance is that college, universities find the ways to achieve diversity, even if they can't engage in affirmative action. And there are many ways of doing that, and I think they have to. And if it's to be called massive resistance, I'll accept the label, though the connotations of massive resistance are such that I think this is totally different because the ends are totally different.
It strikes me also that there's a question of a kind of formalism that would be at issue. If there are ways to pursue the goals that you and others, including me, of course, that we believe in, what can be done that doesn't run afoul of what we presume, or I presume, would be a ban or a check on explicitly race-conscious actions.
What I've always said as a dean, and I've been one for 13 years, to my director of admissions is, I care deeply about diversity. Just make sure that if I get sued, we have a good defense. And there are many things that can be done in the admissions process. But Ted, you and I have been part of faculty hiring for a long time. What I always say to the appointments committee at the beginning of the year is, diversity really matters, but we should never articulate that we're favoring one candidate over another on account of race or sex. We can think it, we can vote it, but we should never say it and provide the record. We've hired 3 African-American professors in my short time at Berkeley, and as well as most of we hired at Bakke. We are not engaging in affirmative action, but certainly as we evaluate candidates, we can have diversity in our mind as something that's valued. But again, this is part of the longer conversation of how can college universities still achieve diversity, even if my prediction comes true and Bakke and Grutter and Fisher are overruled.
I want to thank you for spending time with us. Of course, for you, as I think I indicated, unlike most of the people who are with us virtually today, who will be speaking at least, I hope there are people on the West Coast who are also up early like you watching. But for you, it's very, very early in the morning. It doesn't in any way, diminish your, your sharpness, your acuity. And we're deeply grateful to you for spending your time with us, for challenging us, and frankly, for laying out some hard realities, but nonetheless, for also talking about hope, which I've come to understand and believe is not something that comes to us fortuitously, it's a choice. So thank you so much, Erwin.
thank you for having me, and just such a wonderful conference, and I'm tremendously honored to get to be part of it.
Um, I want to turn this over then to, as promised, to Alan Buensi, who's going to then give us some housekeeping rules and talk about some matters about how things will proceed and unfold. Thank you all, and we'll be back to you shortly. But here's Alan Buensi, the Deputy Director of the UNC Center for Civil Rights, and by the way, a graduate of UNC Law School.
Thank you, Professor. Good morning to everyone who has been able to join us on the call this morning. We know that there are folks out there who are having a really tough time, and it means a lot that you have still taken time out of your day to join us. Thank you to Dean Chemerinsky for a tremendous address, and thank you, Professor Shaw, for kicking us off. So, as Professor Shaw indicated, the team here at the UNC Center for Civil Rights, along with the Wheel Lecture Series, the Frank Porter Graham, we all extend a very warm welcome to you all from the University of North Carolina at Chapel Hill. Again, my name is Alan Buensi. I'm the Deputy Director at the UNC Center for Civil Rights, and I will be your host today and tomorrow during the Center Symposium, and I will be moving us through our program. We pose the question that we want you to keep in mind that Dean Chemerinsky teed up for us. When we think of the Equal Protection's grand promise and betrayals through Reconstruction, Plessy, to Bakke, and beyond, is there a way forward? Most of you are here as attendees, so I'd like to lay out a few housekeeping items for our attendees. We have 25 panelists and moderators, we have 4 plenary speakers, and we have over 600 attendees today. So for the sake of efficiency, our slides in between sessions will contain introductory information on the moderators and speakers for the ensuing panel sessions. So neither the moderator nor I will be robustly introducing the panelists just out of consideration for their time and out of consideration for your time. Next, this symposium will be recorded, except for Professor Foner's address. You will notice that the mic and video for attendees has been disabled, but you can still pose questions in the Q&A function. We encourage you to send any questions that come to mind, starting around the middle of the session when the moderator indicates that we'll go into question and comment. Please note also the closed captioning feature at the bottom of your Zoom window that you can turn on and off. It is called the live transcript button. For panelists and speakers, please remember to sign into the symposium using your panelist link 15 minutes prior to the start of your panel. Once you sign in using your panelist link, please mute yourself and turn off your video until I prompt you closer to the start of your session. Please also silence your phones. Back to our attendees, you have received a powerful address from Dean Chemerinsky, and we have even more in store for you. So sit back or lean forward, relax, and enjoy the treats we have in store for you today and tomorrow. We will now take a short intermission. Please enjoy the slides transitioning us to our first panel while we prepare our moderator and panelists for that panel. That panel will begin at 10:30. Thank you. Good morning to our panelists and our moderator. Professor Schnapper, would you mind trying to turn on your video? Thank you. And Dean Goluboff, would you also mind turning on your video? Thank you. And Professor Amar, we're not able to see you. There we go. Thank you.
Alan, can you hear me?
I can hear you, yes. We are good to go. Thank you.
Wonderful. Thanks.
My audio working too?
Yes, you're good to go. Thank you. I'll go ahead and get us started here. So welcome back, everyone. It is my privilege to introduce our moderator, Dean Risa Goluboff, and our two panelists, Professor Akil Amar and Professor Eric Schnapper, for our panel one's discussion about the 39th Congress and how it framed the 14th Amendment, the Equal Protection Clause, and affirmative action statutes to assist newly freed African Americans. Dean.
Thank you so much, Alan. It is a pleasure to be here with these esteemed panelists and on this fabulous day. What you've planned here over the next 2 days is really stupendous. Just amazing people talking about this incredibly important topic. So I'm really thrilled to be here and to be a part of this. Our role this morning, I know Dean Chemerinsky started talking about the future already today, but our role is to, in my view, as a historian, start at the beginning and to talk about the origins of the legal interpretations, the origins of the political wrangling, the origins of the social movement claims about the 14th Amendment and the Equal Protection Clause that will be the basis, I think, for a lot of the conversation that comes out over the course of the rest of the symposium. So we have two wonderful panelists who are going to take us both deep and wide into that history, discussing the Equal Protection Clause, but in the context of the 14th Amendment as a whole, its legislative history, its other provisions, and the legislative actions taken by the Reconstruction Congress in around the same time that shed light on its meaning. So we're going to have a moderated discussion, and we'll follow that by Q&A. And as Alan had said before, you can put your questions into the Q&A function, and we will take them up later on. So my first question for both of you, and I think I'll start with Akil, is, our panel is framing the discussions to come. And so we're going to start, I think, broadly, and then we can hone in. So can you talk a little bit about how the 14th Amendment fits into the Reconstruction amendments more generally? What was the constitutional context in this post-war moment for the Equal Protection Clause?
Thanks, Risa. Such an honor to be with you and with Eric. Thanks to UNC, to Alan, to Dean Boger. We all just witnessed an extraordinary keynote, an introductory keynote by Irwin. That was an extraordinary tour de force. It was great to see my friend Ted Shaw. Can't wait. Speaking of Eric's, to hear the other Eric as well at lunchtime. I hear Eric phoner, so it is a little intimidating to be asked to talk about the Reconstruction amendments in history when Eric Foner is waiting in the wings. Of course, there are three Reconstruction amendments. There, the first set of amendments after the founding era, the first in 60 years, really. What you need to understand is how transformative the 13th Amendment was, because we start with a pro-slavery constitution that gives slave states extra seats in the House of Representatives and the Electoral College, because of 3/5. Almost all the early presidents are basically slaveholders, Southern slaveholders or Northern men of Southern sympathies who play footsie with the South, because it's a pro-slavery constitution, unfortunately. So the 13th Amendment is utterly transformative, again, providing for uncompensated, universal, immediate emancipation everywhere, of a sort that had never happened anywhere in America that had, a lot of slavery. It's Russian Revolution style redistribution. It's just stunning. It could never have happened without a civil war. And so you might say, and Lincoln, when he was elected, was hoping he could do something like that over the course of 100 years. And now it's happened. So you might say, well, then why not? Why don't they just say mission accomplished? Let's have a beer. Wow. And the 14th Amendment and then the 15th Amendment will follow. Let me just make one point, and then I want to, obviously get Eric involved. Here's partly why they can't stop with the 13th Amendment. That's their initial inclination, because they, being Congress people, are politicians, and every time you solve a problem, this is advice for the students in the world. When you grow up, you solve one problem, you often create other problems. That's what success means, creating new problems for yourself. When they end slavery, they have this moment. I know that this is being recorded, but I'll say it's the oh shit moment. And it comes to people at slightly different nanoseconds, but they realize, oh shit, okay, we thought we solved the problem, but we've gotten rid of slavery. 3/5 has become 5/5 because there's no slavery anymore. Blacks who are now freed in the South, okay, they're freed, but that means they're not voting, but it means they're actually going to be counting for more than they did before. The former Confederacy says, okay, we want back into the House and the Senate, the Electoral College, and they're going to come in with even more clout than before. Oh my God, oh shit, we're going to need at least a Second Amendment, which we call the 14th, and it's going to create issues in turn that will require a 15th Amendment about voting rights.
Thank you, Akil. Eric, you want to add more about the kind of general constitutional circumstances that we're talking about?
Certainly. And again, let me express my thanks to UNC and our host for this wonderful program. I'm not usually in a program where I'm the other Eric, but I'm definitely only the other Eric here. The part of the history that I'd like to focus on is the race-conscious legislation that was being adopted between 1865 and 1868 by the same Congress, particularly in the early years, that adopted the 14th Amendment. For those of you who are an originalist bent, and I guess everyone's a bit selective about that, in this particular instance, it weighs pretty heavily in favor of a view of the 14th Amendment that's not entirely colorblind, although the situation's somewhat nuanced. And the debates about these pieces of legislation is eerily like the debates that we've had in this country since the 1960s about whether the government should be race blind or not, and if not, when not. So perhaps I could just walk through some of those pieces of legislation, and then if you want later on, we can talk about the debates. So the first of these was the Freedmen's Bureau Act of 1865. This and the next act actually happened before the 13th Amendment is effective. They're dealing with the consequences of the Emancipation Proclamation. So the 1865 Act protected freedmen and refugees. As a practical matter, the refugees were generally white. They were a relatively small part of the white population in the South. And so the provisions, insofar as they applied to both freedmen and refugees, and not all did, were virtually all the African Americans in the South, and only a handful of the whites there. It was selective, racially selective among the whites. And the original provisions of the 1865 Act dealt with a variety of things: food and clothing, the lease and control of certain lands that particularly had been conveyed by General Sherman in Georgia, and then a plenary control of all matters related to freedmen and refugees. The way the act was implemented was even more race conscious. And that's important for two reasons. First, the Freedmen's Bureau expressly reported to Congress what it was doing. It made this very clear. And then the debates about renewing the Freedmen's Bureau, that was a point of objection on the part of the opponents of the legislation, who pointed out that although the Freedmen's Bureau dealt with freedmen and refugees, in most respects, it was expressly only for freedmen. So the regulations of the Bureau with regard to a number of topics and the programs were limited to freedmen. And those included things that were probably most important: education, regulation of labor, land, overseeing the legal rights of freedmen, and registration of marriages, which was a problem among the former slaves. That stuff was exclusively operated for the freedmen, and the regulations said so. The Bureau provided medical assistance, and the numbers were that 96% of the people getting medical assistance were freedmen. With regard to food, 25% of the people getting food were refugees. And then there were some programs providing transportation, getting people back to where they'd come from or where they wanted to go. And that was evenly divided between the freedmen and the refugees. So that bill was in effect for a year, and Congress had to renew it, which it did in 1866. For those of you who aren't steeped in this history, the renewal of the Freedmen's Bureau was critical to the extent to which Congress turned against President Johnson. President Johnson vetoed the first Freedmen's Bureau bill. That produced a huge backlash. Congress moved more in a progressive direction, Republican direction back then. And actually the Freedmen's Bureau bill that ultimately passed was more race conscious than the one that Johnson had vetoed. So let me just skip ahead to what was in the bill that ultimately passed. First of all, the education provisions were expressly limited to freedmen because of the way they were set up. On the face of the statute, you could see that. Secondly, the provision about protecting lands was expressly limited to freedmen. It applied only to General Sherman's order of early 1865, and that order was only for Negroes in the terms of the order itself. And then the general grant of jurisdiction to the Bureau was over freedmen and refugees, but with a cutoff. And one cutoff was until they were self-supporting, and the second one was until they'd achieved the freedom provided by the Emancipation Proclamation. So the second clause could last past self-supporting, but it only applied to African Americans. So the Freedmen's Bureau lasted actually till about 1870. In 1868, Congress amended the statute and shut down everything but education. And education was exclusively for freedmen. The second telling piece of legislation was in 1867, and it concerned bonuses and bounties that had been provided to Union soldiers. Congress, during the course of the war, had created a number of those. I could keep people in the military in the dark days. And the soldiers then had claims for reimbursement, and a lot of them were being cheated out of that money by unscrupulous agents. But Congress adopted first a race-neutral provision to help the former Union soldiers, and then there was in 1867 a provision that applied only to Black former soldiers. And it did so without regard to whether they'd been freedmen originally or they would have been free African Americans even before the Civil War. That produced pushback again, like the other race-conscious measures. And one of the things that the opponents pointed out was that the new statute wasn't limited to freedmen and wasn't limited to uneducated African Americans. It covered all of them. And that was administered by the Freedmen's Bureau. The other thing that's interesting is there are a pair of social welfare provisions that were adopted in 1867. So one was about poverty in the District of Columbia. It was limited to freedmen and destitute African Americans. The second one was about famine in the South. In 1867, there was a crop failure, and large numbers of people were at risk of starving to death. That provision was not race conscious. It applied to everybody, although it was administered by the Freedmen's Bureau. And there was some pushback by the supporters, the original Freedmen's Bureau, that it shouldn't be in the business of helping everybody. It was there to help freedmen, but that's not what Congress chose to do. When it came to people who were starving to death, it chose very deliberately not to draw the distinctions that had been drawn with regard to the Freedmen's Bureau. And that was consistent with the way the Freedmen's Bureau had operated with regard to food and medicine. It hadn't drawn distinctions which were as rigid as they were about education. And the provision in 1867 applied to non-loyal Southerners. A destitute former Confederate soldier could get food. So it was broadly race conscious in the way that even the 1865 Act on its face was not. So that was the pattern of legislation. As I said, the debates were very much about race, but let me come back to that a little later, whatever you want.
Great, thank you. So, when you put together Akil's description of the 3 Reconstruction amendments and your description of the various statutes that were passed around the same time, you get a sense of an enormous federal outpouring of protection for the formerly enslaved laborers and for Black Americans as a group, in both the constitutional and the statutory realm. So let's get a little more specific now. Akil, I'm going to come back to you first, and then Eric, I'll come to you. So when you read the 14th Amendment, you read it within the context of a tremendous shift in federal power toward the protection of the freed people. But even beyond that, so, a lot of what we're going to talk about is the Equal Protection Clause, but I know you've written also about the first sentence of the 14th Amendment. So let's start there. What does it say? How do you read it? And how big is it? And how big should it be as we're thinking today about the Equal Protection Clause, but thinking about the whole amendment in this context?
It's enormous. So let's begin at the beginning, and I'm going to begin to, as I said, before there's the 13th Amendment. Of course, that sets everything up. And I said it's because 3/5 has become 5/5. We're going to need to talk ultimately about voting power, and that's going to be Section 2 of the 14th Amendment. It's going to be the 15th Amendment. But let's start at the beginning of the 14th Amendment. And I am going to be very personal here. This is my beginning as well as a human being. I begin and I'm born, and I actually happen not to be Black or white, but I'm born in the United States. And because I'm born in the United States and my parents are not American citizens when I'm born, Constitution, the 14th Amendment, gives me personally this amazing birthday gift. It makes me a citizen, an equal citizen with full and equal civil rights as a citizen against the federal government and the state, all by dint of this one opening sentence. So it's my beginning. It's how when I look back on my life, I think that's why I want to be a law professor, because the very first day I'm born, a constitutional law professor, the Constitution gives me this amazing gift of full and equal citizenship. And that's the first sentence of the 14th Amendment. And wow, it's big. I'm going to identify 8 or 9 things that's all about. Even if we had nothing else, we could get it all or almost all from the first sentence. And since Eric very helpfully talked about the Freedmen's Bureau bill, I want to remind our audience of one other companion piece of legislation, which is the Civil Rights Act of 1866. And its opening sentences are actually almost identical to, and they were companion bills put forth by Trumbull. Eric is absolutely right. They were vetoed, and the veto overrides Johnson's veto. Andrew Johnson's vetoes were overridden. These were the first major veto overrides of an important bill in all of American history. Presidents had not had their vetoes ever overridden on important issues, but the Civil Rights Act of 66 and the Freedmen's Bureau Act are the two early on. And if you can get 2/3 to overrule Johnson. Maybe you can get 2/3 for constitutional amendments. And the first sentence of the Civil Rights Act of 1866 is birthright citizenship. It's almost word for word the first sentence of the 14th Amendment. And so let me just read it to you, because I'm saying it is epic, and we forget about it when we talk about equal protection and due process and privileges and immunities and voting rights. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. I'm going to identify, just stop me if I go too long, but like 10 quick bullet points about what this does. First, it means it has no state action requirement. You see, like the next sentence is no state shall. It's like the 13th Amendment in that regard. So one, it's about my relationship to the federal government, and it's going to be a basis for, in effect, reversing corporation equality rights even against the federal government, because it says I'm a citizen, therefore an equal citizen, and the federal government has to respect that. That's Bowling versus Sharp, even before we get to equal protection. Two, because it has no state action requirement, Congress under Section 5 is going to be able to implement what it means to be a citizen. And I think what it means to be a citizen, and early Congresses did, not just against the state government, but I have a right to go show up in a hotel or a motel, a train, a place of public amusement. I'm an American citizen, and Congress can pass laws saying cash out what that means, even when a state hasn't acted, but when we're in the public domain. But maybe not the private domain. Dinner parties are not the domain of citizenship. So if I'm excluded from a dinner party because people don't like my race, that's beyond the 14th Amendment. But now it's telling us, oh, it's about civil rights, not political yet, and not social rights like dinner parties. Why not political rights? Because being a citizen doesn't mean you vote. A child is a citizen. I'm born a citizen on the day I'm born, but I don't get to vote until I'm 18 or 21 or what have you. Women are citizens, they're equal citizens, but they don't yet have a right to vote. We're going to need a 19th Amendment for that. So this first sentence, with the idea of people being born citizens, is beginning to gesture toward a tripartite distinction between civil rights, like the Civil Rights Act of 1866, versus social rights, dinner parties, private action, and political rights, voting. Again, it applies to the federal government. It's about our relationship, citizen one to another. It's what does it mean to be born a citizen? I think it means to be born a free and equal citizen. It's a birthright equality idea. It's a constitutionalization of the Declaration of Independence idea that we're all created equal, we're all born equal in some fundamental sense, not just black and white. You're born black, you're born white, you're born equal. Oh, but you're born equal. I would say male and female. People are born male and female, but that's an equality idea. You're born Jew or Gentile, but you're treated equal. You're born the child of legal immigrants or illegal immigrants or slaves or free folk or white people. Doesn't matter. You're all born equal. You're born first in your family or fifth in your family. You're born equal, no primogeniture and entail. You're born in wedlock or out of wedlock. You're born equal. You're born gay or straight. Erwin mentioned Obergefell. You're born equal. Wow. That's a really powerful idea, this birth equality idea, and it begins to gesture toward what we're later going to call strict scrutiny for certain laws that treat people differently and unfairly because they're born differently. We shouldn't have that in America, but all sorts of other laws, like the difference between someone who makes $200,000 and someone who makes $150,000. The tax code treats them differently. There are all sorts of distinctions in our law that are okay, because they're not birth-based. So this sentence is going to begin to gesture toward an idea of strict scrutiny for birth-based laws, not just race, which is at the core, but sex and sexual orientation. If we believe with Gaga that people are born this way, sex, sexual orientation, wedlock, firstborn versus fifthborn. Final point. It gestures toward an idea of the privileges and immunities of citizens. What it means to be a citizen is to be able to claim rights. In the Bible, in the New Testament, St. Paul says, I'm a Roman citizen, and therefore I'm entitled to certain things. So it's going to anticipate the Privileges and Immunities Clause, reversing it's going to anticipate Equal Protection Clause, reverse incorporation, broad federal power to protect rights. Now, here's the one final unfortunate thing. It's not going to be about the rights of aliens, quite. It's about the rights of American citizens. It's about the rights of children of aliens. I'm a child of aliens. My parents aren't citizens when I'm born. But wow, it's a really powerful idea. And I think because there's so many other powerful clauses in the 14th Amendment, equal protection, privileges and immunities, due process, we sometimes overlook what an amazing beginning that amendment has.
Thank you, Akil. And as we go forward in time, I want to come back to all the different groups that you were referencing there as having a home in that first clause. So when we think about the 14th Amendment itself and think about its breadth, one piece of it is that first clause. But another, Eric, is the Equal Protection Clause itself and the background to the 14th Amendment, where you find in your work all of the race-conscious ideas about helping the freed folks who were formerly enslaved in the 14th Amendment itself. So can you tell us about that legislative history and how you see those themes in the amendment and not just in the statutes that surround it?
Sure. So I think the key tie-in is people in time. The leaders of Congress and members that were the outspoken supporters of these race-conscious measures were also amongst the outspoken supporters of the 1866 Civil Rights Act and the 14th Amendment. They're pending before Congress. It's the same Congress. At some moments, they're pending at the same time. So it's fair to infer that whatever the 14th Amendment meant, it wasn't intended to invalidate the Freedmen's Bureau that was being adopted, reenacted at the same time to invalidate the very statutes that were before Congress at that time. One has to read them together. And here the debates really become helpful because they really raise a lot of the issues that we're still grappling with today. And there are two sides to that debate. One of them is the opposition, which, as you'll see, looks eerily like a lot of what's said today in public debates and by increasingly, probably a majority of the Supreme Court. And the other side of it is the arguments that were made by the proponents of the Freedmen's Bureau, which were more nuanced. So let me start with the opposition, because this throws light on the question of whether the Equal Protection Clause requires the Constitution be colorblind. The arguments there look very much like much of the stuff that one would hear from the conservatives today. The most consistent objection was that the Freedmen's Bureau was what they called then class legislation. It was inconsistent with the principle that everybody should be treated alike by the government. And that's in not only the legislative debates, it's in President Johnson's veto message. And there are two of them because he vetoed the Freedmen's Bureau bill twice. The proponents talked about there being equally deserving whites, the widows and orphans of Union soldiers, for example, or the Southerners who fought with the Union Army. They weren't given they weren't eligible for most of the programs operated by the Freedmen's Bureau. And the opponents talked about the fact that there were people in equal need who were white, who were just as poor, or in theory, just as uneducated. There's also an argument which we don't hear as much in the racial context. We hear perhaps more about aliens, which had to do with taxes. The opponents object to the fact that white people were paying taxes for a program that was limited to freedmen. There was also an argument that this was a form of, and the phrase actually appears, special rights. And that was also used about the 1866 Civil Rights Act. And we don't hear that as much in the racial context, but it was used very much in opposition to gay rights legislation when that was being fought over more in the States than perhaps it is today. The arguments for this legislation were complicated. And again, to the extent that one cares about the intent of the original framers, they pour towards a complicated view of what Congress could and couldn't do under the, or what the states could and couldn't do under the Equal Protection Clause. And arguably, going back to Akil's point, what the equal protection component of the Fifth Amendment would now be. The most repeated argument was that the freedmen had been in the past the victims of terrible mistreatment. Their labor was stolen, they were beaten, they couldn't learn, they couldn't go to school. And Congress was trying to right the wrongs that had been done to those folks. There's also a fair amount of discussion of local hostility to the freedmen in the communities where they lived. There's a discussion in response to the argument that whites aren't given similar programs. There's an argument that whites have the political power to take care of themselves in a way that the freedmen do not. Again, in part, this goes back to the fact that the 15th Amendment hadn't yet been adopted. And when it was, one of the rationales was that it would enable the freedmen and African Americans in the South generally at that point to look out for their own interests when Reconstruction was over. But that wasn't there. This is 1866. It wasn't even on the table yet. And that the feeling was that you could still make some of this argument today that discrete and insular minorities have less political power and therefore can more appropriately be protected by the government. So those are the main arguments that were made there. They have, in addition to the nuanced ways that the bills were framed, complicated implications in terms of what the framers might have thought was and was not consistent with equal protection.
So before we move on, I want to talk about what happens to the 14th Amendment in the courts afterward. But before we do that, can you say a little bit about those complicated implications about what the Equal Protection Clause may or may not have encompassed?
Sure.
What the thought was at that moment before, holding in abeyance what happens later, how you think about that?
Yes. Again, at some point, this is like, anytime we start down the road of originalism, you're trying to figure out, well, what would the framers have thought if you told them everything that was going to come? I think the framers would have thought that addressing societal discrimination was totally appropriate. That's what this was about. Congress didn't say, we've been enslaving people, we've been stealing their labor, the federal government's been denying them education, we've got to make right what we did wrong. This was making right something that somebody else did wrong. If you go back to full love and the court just doesn't want to hear anything about correcting societal discrimination, that's what the framers thought they were doing. Secondly, they clearly, I don't want to use the word clearly about anything, but they were distinguishing between measures that had to do with self-support, both land and the enforcement of contracts and education. That was an area where they were doing the most that was race conscious, as opposed to on the other end of the spectrum, food, where they did not draw those distinctions. So if you were looking at affirmative action programs today, the framers would probably want you to draw those kind of distinctions. Now, interestingly, much of the current fight has been about things at the self-supporting end. Education, minority set-asides, those fall squarely in the heartland, what the framers would have thought was appropriate. Whereas if you were to propose giving more food stamps to African Americans or giving them preferential treatment in terms of Section 8 housing, I think they probably would have not been comfortable with that. So if you look to I try to think through the current rationales for race-conscious affirmative action, and some of them I think the framers would have been comfortable with, some of which they wouldn't have been, some of which would have been totally new. So insofar as we are arguing for affirmative action to deal with societal discrimination, the thing that Fuller tells us we're not supposed to do, framers would have been fine with that. Insofar as these measures were intended to defeat then ongoing discrimination, I think they'd have been fine with that. That comes up as well. And there's a story there that's a bit like Shelby County we can get back to. On the other hand, there's very little that looks like reparations in the debates. I saw one passage talking about what we owe the former slaves, but it's not the drift of what's going on here. And there are a couple of things that clearly aren't there. One of them is the notion that something should be done because discrimination and mistreatment against the ancestors of current citizens it has current effects. That idea is not there. It's really not there for historical reasons, because there were virtually everyone, all the blacks in the South, had been slaves until a couple of months earlier, or maybe a year or two earlier, as the Union forces marched south. So it was just a phenomenon that didn't exist. And finally, the rationale that is much discussed now about higher education, about the benefits to an enriched and effective education of having groups from different backgrounds, that's definitely not there. The schools that were operated, with very few exceptions, only had African American adults and children in them. There's some scattered instances where the white children of the white teachers were in those schools. But this is a wholly new idea, not something that would have been necessarily anathema to the framers. It's like telephones and the framers of the Fourth Amendment. It's just not part of the world they knew. There was not much higher education. But you can't find a basis for the value of diversity to a workforce or to a school. There's nothing like that in the thinking of the framers.
Mm-hmm. Great. So I want to come back to Shelby County later, but before we get to the present or the near present, let's stay in the 19th century a little bit longer. So what you've both described are incredibly expansive understandings of the 14th Amendment. And as we know, in the Supreme Court, in the years after, in the decades after the ratification of the 14th Amendment and the other Reconstruction amendments and the passage of these laws, the Supreme Court really radically narrows the scope of the 14th Amendment. So can you talk a little bit, Akil, about the civil rights cases of 1883 and Plessy in 1896, and how you see the amendment being interpreted there, and where you see the opportunities for the court to have read the amendment the way you do, and what the court does instead.
Thanks. So I want to go back once again to just how radical the 13th Amendment is in the first sentence of the 14th Amendment, and then even the congressional empowerment clauses. So our constitutional tradition, unlike, say, European ones, has a very strong focus on the government. We call it the state action doctrine. Our rights are almost always against government, state and federal. So state action here means not just state as opposed to federal government, but government as opposed to non-government. The 13th Amendment, though, has no state action requirement. It's actually about a broader phenomenon. Even if one private person enslaves another, that's a violation of the 13th Amendment, and Congress is supposed to do something about it. It's a requirement of affirmative government measures to ensure that neither slavery nor involuntary servitude shall exist. So both a mandate of government action and an application against private action. That's the 13th Amendment, and that's radical. And Eric mentioned earlier, he says, they're not just trying to remedy past governmental wrong, but a broader social wrong that they're trying to rectify called slavery. So the 13th Amendment is radical in that regard. Almost nothing else in the Constitution has that feature. So too, I argued about the first sentence of the 14th Amendment. It does not say no state shall. So it applies against the federal government, and in 10, it's about the relationships of citizens between themselves horizontally. It's a little more French that way. It's about fraternité and not just liberté and égalité against the government, but more, we are equal citizens, you and I. And if we were French, we'd call each other citoyen or comrade or something like that. It's about horizontal relations when we meet at the mall or in at Disneyland or in public conveyances, a train, a steamship, a place of public amusement, a place that today the shopping mall or something like that. Why do I mention that now? That's going to take me forward to the civil rights cases of 1883, because in tandem with that first sentence of the 14th Amendment that has no state action requirement, and the 13th Amendment that has no state action requirement, there are congressional empowerment clauses, Section 2 of the 13th, Section 5 of the 14th, they're going to be followed by Section 2 of the 15th, that are sweeping. The Bill of Rights begins saying Congress shall make no law. The framers of the Bill of Rights were concerned about too strong a federal government, and the rights are only against the federal government. And now we're having amendments that are restricting social practices and state laws, and ending with sentencing Congress shall have power, Congress shall have power, Congress shall have power. Using the word appropriate, which is borrowed from McCulloch, which means sweeping power. Congress shall have broad power. Irwin mentioned Prigg versus Pennsylvania. The courts upheld broad power to protect the slaveocracy in Prigg. And now Congress wants to say, oh, we want to use that same broad federal power to protect the former slaves that Joseph Story and the Supreme Court in Prigg, which Irwin mentioned, the Supreme Court allowed Congress to pass sweeping laws to protect slave masters. Why can't they pass sweeping laws to protect the former slaves? And the 1875 Civil Rights Act, Eric and I have been talking about 1866 statutes, but now flash forward, is in effect an early version, in important parts of it, of what our audience would recognize as the 1964 Civil Rights Act. It prohibits race discrimination in trains and steamships and places of public amusement. Today, that would be Disneyland or something like that, hotels, and the like, public houses, call them pubs today, places, common carriers and conveyances. And the Civil Rights Act of 1875 says no race discrimination in those places. Enter the Supreme Court in 1883. This is Irwin's story. They strike down what Congress has done. And one person, and here's what they say. You are the state action doctrine. The Constitution only guarantees rights against the state, and Congress here is regulating private entities like hotel owners, Disneyland, places of public amusement, steamships, state action doctrine. Here's what Harlan says, alone in dissent, John Marshall Harlan. This is going to be the same Harlan who is alone in dissent in Plessy versus Ferguson. He says, first of all, the 13th Amendment has no state action requirement. And maybe it's true that race discrimination at a hotel isn't slavery or involuntary servitude, but it's a badge of slavery. It's an incident of slavery. It's a relic of slavery. It's part of the slave. It's part of the racial discrimination society that gave us Dred Scott and slavery. And Congress has power under Section 2 to go far beyond Section 1. Section 1 may not say badge, incident, relic, but Harlan says Congress has sweeping power under Section 2, which is going to become in the 1960s Jones versus Alfred Mayer, which is forgotten. Okay, and why? He says, oh, because Congress had sweeping power to prohibit to protect private slave masters in Prigg versus Pennsylvania. Why shouldn't they have sweeping power to McCulloch-like power to address private wrongs? The 13th Amendment should be read generatively, and congressional power should be read broadly. That's one of Harlan's moves. But his second move is based on the first sentence of the 14th Amendment. He says, it doesn't say no state shall. It says citizenship. Yes, citizenship isn't about who gets invited to Reese's dinner party. She gets to invite whoever she wants to her dinner party because that's the private domain, or whoever she wants to have involved in her private life. But hotels are public houses. They're open to the public. Trains and steamships and places of public amusement. This is the domain of citizenship, or at least it can be if Congress so decides, and we, the court, should be deferential to Congress, the way the court was in McCulloch, the way the court was in Prigg versus Pennsylvania. So Harlan, standing alone, as we can uphold the clause. He loses, so that's why in the 1960s we have to refight that fight. Finally, one sentence on Plessy. See, because if Harlan was right in Plessy, and we all think he is today, then he was right in the civil rights cases of 1883, 13 years before, and that's not what the Supreme Court says today. The Supreme Court has revived all these bad doctrines of the civil rights cases. That is become City of Burney and Shelby County. It's all a narrow reading of Congress's enforcement power, and it goes all the way back to the civil rights case of 1883. Here's why Plessy is so analogous, because Harlan actually says in Plessy that race discrimination, he actually invokes the 13th Amendment. Why is he invoking the 13th Amendment? Because not being able to get on a train isn't slavery. He's invoking it because he thinks it's a badge of slavery, and that maybe this segregation isn't a violation in public places, in like hotels and trains. It's not a violation of 13th Amendment Section 1, but Congress can make it a violation of law under 13th Amendment Section 2, and he thought Congress did do that. And the court was wrong in the civil rights cases. And so look, all the court had to do is enforce the Civil Rights Act of 1875, and Plessy becomes an easy preemption case. The Congress in the Civil Rights Act of 1875 has said no racial inequality in railroads. All you'd have to do is just enforce the congressional law, basically say racial discrimination in railroads really isn't equal, as it's just a matter of simple preemption. But instead, last sentence, the court, and this is what Irwin is saying, strikes down a congressional law in which blacks, in a legislature for which blacks voted and in which blacks voted, strikes down that law, but upholds state laws in Louisiana, in Plessy, where black people aren't voting in the legislature and aren't voting for the legislature. And all they had to do, and this is what Irwin is saying, is enforce that Civil Rights Act of 1875, which they didn't, and Harlan says they should have because of not just the 13th Amendment, but the first sentence of the 14th Amendment, which radical has no state action.
Great, so there's a lot in there, and that was fabulous. Before I turn to Eric, and I might try to get some disagreement going, we'll see. I just want to remind the audience that you should put questions in the chat, in the Q&A function. We're going to talk for, I think, another 15 minutes or so, but then I would love to take Q&A from the audience. So if you have a question, please put it in there. So Eric, I wonder if there's some disagreement between the two of you, because what I hear Akil saying is that the state action requirement might limit the Equal Protection Clause and its operation, might limit the Due Process Clause and its operation. And so in order to get to the kind of fulsome and expansive interpretation of the Constitution that I think you both want to get to, he thinks you need to go to the 13th Amendment and the first sentence of the 14th Amendment. Whereas I think that your claim is slightly different from that. Your claim is no, even with the state action requirements, it is still the case that the conception of the 14th Amendment was broad enough that you don't necessarily have to go in the directions that Akil does in order to say that affirmative action is justified or that the civil rights cases of 1883 were wrongly decided. Am I right to see a little daylight between you two there?
I'm not sure you've managed to pick a fight quite yet.
Okay. I'll keep trying. I'm also happy if we don't have a fight. But
I'm contentious. You'll get there. It's not that hard to provoke me. But I think what I've been saying so far just has to do with a limitation that I see in the reach of the Equal Protection Clause. That is, I think it's a fair reading of the legislative history that it was not intended to be completely colorblind, although it was in some ways. It's complicated. And I don't think that addresses either of the questions raised by what Akil said about the scope of prohibitions against discrimination when they do exist, or about state action. Looking at the debates that surrounded the Civil Rights Act, and if some familiar with debates about the 14th Amendment as well, about the, sorry, let me recast that, about the 1866 Civil Rights Act, I think it's clear that Congress did not think the 13th Amendment required state action. The interesting thing is, when you think about the civil rights cases and you look at the discussions about the Freedmen's Bureau, Congress thought it was acting under the 13th Amendment. That's where it thought its power came from. And the debates are not about the wrongs done by states. I was looking through all the quotes I had in the article last night. There's not one about states. There's maybe one about laws. The description is about the way in which the slaves had been mistreated by the slave owners. That's the bulk of it. South Carolina wasn't stealing people's labor. The slave owner was doing it. So it's very much about things that private individuals did, obviously with the connivance of the state, but the focus isn't on the state, except with regard to education, where the state was prohibiting it. So I think it's fair to say that Congress thought it could do something about that. It could, under the 13th Amendment, correct the harms caused by private conduct. So I don't think Congress would have been surprised at that point of the notion that under the Section 2 of the 13th Amendment, it could adopt legislation dealing with private actors. I think the other takeaway from these debates is Congress didn't think slavery was just chattel slavery as a concept of property. Don't bother me about the details. It was about more than just you can own a human being. In fact, it wasn't really, the debate they were having wasn't about that at all. If we think, as we were taught to in law school, property is a bundle of rights, slavery to them was a bundle of wrongs. And they were catalyzing those wrongs, cataloging them. And it goes back to the point that Akil made about badges of slavery. Slavery was a bunch of badges, but that was the system. And it had all these consequences. You weren't allowed to learn, you couldn't leave the plantation, you could be beaten, you can get paid for the work you did. Your children could be taken away from you. That sounds eerily familiar in our era. This was this bundle of wrongs. And so it would have made sense to them that there would be a bundle of wrongs by private parties that Congress could correct through measures like the Civil Rights Act. I mean, you're seeing that bundle of wrongs concept and what Congress thought under the 13th Amendment it could correct. If not educating someone wasn't a wrong under the 13th Amendment, they had no business fixing it. Congress didn't have plenary authority over the ills of America. Its authority was under the 13th Amendment. So unless the problems they were trying to correct were problems that implicated the 13th Amendment, the power wouldn't have been there. So I think the 13th Amendment looks like a very broad source of authority to deal with any manner of racial discrimination.
And if I could just jump in and make a bridge of connection. The 13th Amendment is on the books. Where does Congress get the power to pass the Civil Rights Act of 1866, which says no race discrimination by states, but even in northern states, even states that never had slavery under the Constitution, like Massachusetts. And Congress thinks it has power to do that under the 13th Amendment, read broadly in light of Prigg and McCulloch, and that word appropriate. So Trumbull says, we have very broad power to under the 13th Amendment to deal with sort of all of the racial apparatus that underlay the slavery system. Johnson says, no, you don't have enumerated power, and he vetoes the 1866 Civil Rights Bill partly on that ground. Congress overrides the veto. And that first sentence, remember, says everyone's a citizen. Everyone born in the United States is a citizen, which goes way beyond slavery, you see. Now, Johnson arguably has a bit of a point because, gee, that's a very broad reading of congressional power. here's the final point. If you think that, here's the one thing, if you're a citizen, you should never do. You should never support a 14th Amendment whose first sentence echoes the first sentence of the 13th Amendment of the Civil Rights Act and says Congress shall have power, yet another provision, because the 14th Amendment is partly there to provide a secure constitutional foundation, not just because of Section 2 and 3/5 becoming 5/5, which I told you before, because without a 14th Amendment, the Civil Rights Act is vulnerable because can you overrule Dred Scott by merely a statute? Dred Scott says blacks can't be citizens. First sentence of the Civil Rights Act is yes, they can. Can you do that by a mere statute? And especially when Johnson's saying you don't have power. Enter the 14th Amendment that echoes the Civil Rights Act word for word, that first sentence of both the statute and the 14th Amendment. It says Congress shall have power. And if you don't want broad congressional power, you shouldn't vote for the 14th Amendment because they just showed you with the Civil Rights Act how they interpreted the Congress shall have power under the 13th Amendment. So I think the 14th Amendment ratifies in an obvious big public way a sweeping congressional power because Congress passes an amendment that says we the Congress have power, acts under it. We see what they do, which is very sweeping, going way beyond narrowly slavery itself, chattel slavery. And if you don't like that, vote against the 14th Amendment. But people like it and they vote for the 14th Amendment. And then again for the 15th Amendment, which has another congressional empowerment clause, which Irwin invoked when he talked about Mobile versus Alabama. And all this is why Shelby County is a disgrace. And City of Bernie is completely wrong because these were amendments written by Congress for Congress, with Congress implemented very broadly. And the American people seeing all of that said, yes, do it again, more, please.
So I want to, Eric had mentioned he has something to say about Shelby County too, and I want to come to that in a second. But let me just staying on the late 19th century court for a minute. There are those who would defend the court. I'm not among them, but there are those who would defend the court and say what the court was doing was really not about, reasserting racial subordination. It was really about the worries about the transition in the relationship of federalism and the role of the states and the role the states were supposed to be able to play. So how do you both respond to that argument about what the court thought it was doing, perhaps at the time?
In one sentence, I would simply say, and I do think Irwin's keynote was very powerful, so thank you, Irwin, for that. Boy, it's a double standard. And this is what Harlan says in dissent in the civil rights case. He said, wait a minute, you got the provision of the original Constitution. It says no state shall, and it doesn't say Congress shall have power to enforce, and it says no state shall, and yet in Prigg, the court upholds this congressional statute that regulates private people beyond no state shall, and in a massive pro-slavery way, and we, the court, uphold it. And now we have an amendment. It uses the same word appropriate. Congress wants to do for the former slaves what earlier Congresses had done for former slave masters with the court's blessing. And now you're saying we can't do it. You've moved the goalpost after the ball is in the air. You can't do that. So where was the federalism argument in Prigg? That's what Harlan says in dissent in the civil rights cases of 1883, and I'm with him.
Great. Eric?
Well, I have maybe a less expansive way of saying something of the same thing. In the debates that go on in 1866, one of the recurring arguments, it's really a background argument of the opponents, is that Congress, the national government, has no business mucking around with things that are happening among citizens or among individuals, private individuals in the states. Not just regulating them, helping them. It's not the business of the national government. This is a state and local problem. And the opponent's view is, acting under Section 2 of the 13th Amendment, the 13th Amendment has revolutionized the role of the federal government. It has given us a different responsibility, and it is very much given us responsibility for dealing with certain kinds of problems. It's not, we don't have plenary police power, but if we're dealing with the problems of the freed slaves, and I think Akil makes a good point, it's somewhat broader than that. They see racial discrimination, at least beginning to see that, as inextricably intertwined with getting rid of slavery. We're in the business of dealing with that. And if we can deal with that by setting up schools or by setting up a court system for the freedmen, or registering marriages, then they would undoubtedly thought we can deal with it by regulating the way African Americans are treated if they go into a hotel or a railroad. It was meant to be a revolution, at least insofar as it empowered Congress and the national government to deal with that problem. And it makes no sense to say, well, you could have federal railroads if you think you need it. You can have money, you can spend money to move people around, but you can't regulate the way people are moved around if a railroad company does it. And I think they would have said, we're in the business of dealing with these problems. And although the 1866, Freedmen's Bureau Act was an affirmative social program, it doesn't make any sense to say there wouldn't be a comparable expansion of the regulatory authority of Congress. So I think, but again, that's under the 13th Amendment.
Okay, so Shelby County, Eric.
Well, there's a story that comes out in 1867 that just eerily like Shelby County. And I mean, this is after the 13th and the 14th Amendment have been written by Congress. The 14th Amendment isn't ratified yet, so I don't know how much you can read into the intent of the states in ratifying it. But the 1866 Freedmen's Bureau Act was set to expire in 1868. And in 1867, General Howard, who had been running the Bureau through the whole time, thought things had sort of worked out. And there were these schools throughout the South, operated, I think, mostly by Northerners, and they were functioning. And so he recommended that Congress shut down the Bureau, thought things were under control, and started to withdraw the Freedmen's Bureau involvement in the schools. What then happened, he reported to Congress, was that the white Southerners immediately started disestablishing those schools, shutting them down, driving out the teachers. And so he changed his mind and said, whoops, I was wrong. I thought racism and the mistreatment of slaves was over and we could move beyond such things. As soon as we turn our back, things were good only because we were there. Once we started to leave, things went bad again, and we need to stay. And it was on that basis, on the basis of what he'd seen happen when they started to leave, that he recommended extending the Freedmen's Bureau, which is what Congress did. It's obviously like what happened with voting laws in the South after Shelby County, and not as fast, although it was very fast in Texas. But we've really seen a resurgence in discriminatory legislation and a flourishing of innovative ideas for disenfranchising people in the wake of Shelby County. It's very much like what General Howard saw in the South when they started to close down the Freedmen's Bureau.
Akil, you look like you want to add something.
I wanted to bring in gender in 3 or 4 different ways, if I could. The Civil Rights Act of 1866 talks about how people are entitled to the same rights as whites, and it has a racial focus. The first sentence of the Constitution doesn't use the word race. It would have, the 15th Amendment does, and I think it's about a broader birth equality idea. It's just, I said, it means we're not just black and white, but male and female. I would say gay and straight if people are born gay and straight. So that's one. It's going to lead to an equality doctrine, I think appropriately, that's not just limited to race. I'm going to eventually talk about Justice Ginsburg because I'm talking about women, and I just can't not think about Justice Ginsburg and that dissent in Shelby County, and again tell you something really personal about it, but I'll come to that just at the end. That's another thing. Slavery is such a big and pervasive system. Eric, I think it'd be great if you wrote a book called Bundle of Fronds. That's an amazing concept. We think of property as a bundle of sticks. We think sometimes of a bundle of rice. It's brilliant. Slavery has so many different parts of it. It's such a big, complicated bundle. And Risa's work, for example, has talked about the labor side of the 13th Amendment and unions and other things. Here's a whole other side. Let's, for example, think about the gender side of it. Half of the slaves are females, and for them, slavery takes a very gendered form. They're wet nurses against their will. They're breeders against their will. They're sexual playthings against their will. So when you smash slavery, which is what the 13th Amendment promises, slavery is such a big, pervasive social thing. It ramifies in so many ways. You're dealing with gender, and basic things. 13th Amendment, the first sentence of the 14th Amendment, it has a gender angle too, for example. Yet another one. If we basically said, oh, you're only a citizen if your parents are citizens, think about the following. Oh, well, what if your mother is not a citizen, but she says actually, oh, but my husband is? Your mother's husband actually your biological father? And if not, then you actually don't derive from citizens. Now we're going to have to investigate her, privacy and all the rest to decide whether you have a citizen. We don't do any of that. There are interesting gender angles on all of this because the 14th Amendment doesn't say race. It's not just about race. Race is at its core, but it's about other things as well. And that brings me to just one final tribute to Justice Ginsburg, because I did think that was one of her greatest opinions. It was an epic dissent. And I apologize, I maybe am overly personalizing it, but here was a key moment for me. The key moment in her dissent is when she says, here's why the majority gets it wrong. They just don't get Reconstruction and how big a thing it was. She says, nowhere in today's opinion is there a clear recognition of the transformative effect the Reconstruction amendments aim to achieve. Notably, the founders' first successful amendment said that Congress could make no law over a certain domain. In contrast, the Civil War amendments used, quote, language that authorized transformative new federal statutes to uproot all vestiges of unfreedom and inequality and provided sweeping enforcement powers to enact appropriate legislation targeting state abuses. And that means a lot to me because that's a quotation from my book, which she cites me, and I'm very proud to be enlisted in this project and cited by a great civil rights crusader for women's rights and African-American rights and equality more generally. And the key is she understood the transformative nature of the Reconstruction amendments. And it begins, as you properly began us, Reese, I think, with the 13th Amendment, which is just so unlike almost everything else in the Constitution, which is just sort of narrowly about the federal government shall not do this, the federal government shall not do this. It says no slavery anywhere, and the federal government must do things. It must enforce this. That's sweeping, and I think the first sentence of the 14th Amendment is comparably sweeping, especially when added to congressional power, no state action requirement, and no limit just to race.
Great. Thank you. So we have a question from Erica Wilson, which I think follows on this whole conversation about the 13th Amendment. And she asks, what are some specific examples of the way the 13th Amendment could be used to address modern issues of racial inequality that have roots in enslavement? For example, could Congress realistically use the 13th Amendment Section 2 enforcement power to define modern racially discriminatory policing practices such as stop and frisk, qualified immunity, et cetera, as badges and instances of slavery, and enact legislation that disincentivizes such practices? Who wants to answer that?
I think they can. I think the biggest thing, though, about the 13th Amendment is just the reminder that Congress has the power to regulate private structures, because 14th Amendment and the 15th Amendment also come in when you're trying to regulate state police or all the rest. So the most radical thing that the 13th Amendment would add is the ability to regulate a private structure. And one case that has just fallen into just a hole and has been forgotten It was an epic decision by the Warren Court at its apex. The oral argument took place a day or two after Dr. King's assassination, is Jones versus Alfred Mayer, which read the 13th Amendment very, very sweepingly indeed to give Congress power to regulate certain private conduct. I was only 9 years old at the time. I think Eric was 10 or 11, so he may remember that better than I do. So I'm going to defer to him on that because he may remember Jones, but I was just a kid when that came down.
Eric?
Well, I'm not going to get into how much I can remember from that particular year. But let me respond to the question because I think it raises a number of different issues. So first of all, with regard to qualified immunity, that is a creature of Supreme Court interpretation of Section 1983. Congress could overturn that tomorrow and would be well advised to do so. But I don't think there's any constitutional question about the ability of Congress to deal with that. Secondly, with regard to stop and frisk, insofar as there's a claim that that stop and frisk was being administered in a racially discriminatory manner, that is, let's stop and frisk that person, he's Black, and let's not stop that person, she's white, that's just a hardcore 14th Amendment violation. And Congress doesn't have to do anything about that. Sure, it could do more, but it's clearly unconstitutional. The broader question here about the police goes to an issue we haven't talked about, which is the original meaning of the Equal Protection Clause, which in one respect, at least, I think really goes beyond invidious discrimination. The Equal Protection Clause, strangely enough, was actually about protection. It was actually about the problem. It was framed first in the debate about slavery and then in the debate about what happened afterwards. That a slave didn't enjoy the protection of the law from beating, from forcible, from kidnapping, and then in the wake of emancipation, the southern states were not protecting the legal rights of former slaves. They could be beaten, they could be attacked if they tried to leave the plantation. And there was a need for physical protection that wasn't there. The abolitionists referred to slavery as murder, kidnapping. It just to them looked like ordinary crimes being perpetrated every day, and the government wasn't doing anything about it. And remember, in a number of southern states, there wasn't an affirmative slave code. Slavery existed because these abuses simply weren't dealt with. So I think when you think about maybe partially about stop and frisk, but partially about the extent to which physical abuse of minorities, particularly African Americans, by the police is a pervasive and intractable problem in this country. That is a hardcore concern. It lies very much at the core of the Equal Protection Clause. And I think the power of Congress to deal with the failure of the states to protect people from violence is at its apex under the 14th Amendment. That it lies at, it just fits, it's why it's framed in this way that we say equal protection and we don't hear it. We hear equal, we don't hear protection. It's a 19th century way of saying don't discriminate. It's not, it was about protection. So I think there the power of Congress is particularly great. All you need is 5 more votes.
Right. So there's a phrase from this era that follows through into the 20th century and is actually a big part of the first Civil Rights Commission of the modern era, the Truman Civil Rights Commission, the idea of the safety and security of the person, right? That there is an affirmative obligation on the part of the government to secure, this was the title of that commission's report, to secure these rights, and that there was really an affirmative duty there. So we have a minute and a half left. Any closing comments from each of you?
Thank you very much. And it's been
I can ask one last question if you don't have anything closing to say.
Well, Let me just say from a historical perspective, it's very interesting reading these things again from 150 years ago. It's striking how novel the problems are. How, the analogy, the story we already tell about the Fourth Amendment and telephones, we're just living in a world that doesn't translate directly into the world that the framers of the 14th Amendment saw. And I think the real challenge for the courts and the national government is to take principles which are written about a different era and be faithful to the underlying purpose, but understanding that you can't go back and read the journals of the Congress of 150 years ago and find people talking about the things that are happening now that are about a world they just didn't know.
Yeah.
And that's not easy.
Yeah.
And here's one little piece on the other side. You've often, and it relates to Kamala Harris, and back to my, the conditions of my birth. There are folks who say, well, maybe Amar's a citizen because his parents were, even though they were aliens and they weren't green card holders even, they were here legally. But of course, children of illegal aliens, they can't be citizenized, these anchor babies and all the rest. And like, what part of this of the amendment don't you understand? It says everyone born in the United States. And they say, well, they weren't thinking about illegal aliens because they didn't have such a concept because we have federal immigration laws. Oh, enter Jerry Newman. We're going to hear later from Michael Klarman. Jerry Newman is his great colleague at Harvard, who said, actually, there were technically illegal aliens in 1864 because Congress prohibited the international slave trade in 1808. And people were still being smuggled in illegal, not at their own behest, but they were sexual slaves and other kinds of slaves. And that's happening in New York City today. People are being smuggled in as sexual slaves and other slaves against their will. We had that in the 1860s. Abraham Lincoln refused to spare someone from the death penalty who was a slave trader. And Abraham Lincoln didn't like putting people to death. But there were actually people who were technically illegal aliens. They were slaves in America who had been smuggled in, and their children, Ray Newman says, and I'm with him, were at the core of those who are absolutely citizenized by the first sentence of the 14th Amendment. So Eric's work does show the world is different, but we can learn a lot from that Freedmen's Bureau Act of those Freedmen's Bureau Acts. And the world is different, but Jerry Newman has persuaded me, there are interesting parallels, even as there are obvious differences.
Wonderful. Well, with that, I want to thank you both for this fascinating conversation. Thank you to Ted Shaw and to Alan for having us and for putting on this incredible symposium, and enjoy the rest.
Thank you. What an incredible foundation, history, and context that you all have provided for us around the 39th Congress, the framing of and the early jurisprudence regarding the 14th Amendment and the Equal Protection Clause. Thank you, Dean Goluboff. Thank you, Professor Amar, and thank you, Professor Schnapper. To our attendees, we will now take a 30-minute break, enjoy some lunch, and we will see you all again at 12:15. For folks watching on YouTube, we will see you back here at 1:30 p.m. Thank you. a very powerful recount and insight into the history surrounding the 14th Amendment and in the ensuing decades. Thank you, Professor Foner, and thank you to Frank Porter Graham, lecture in 2021, for hosting one of our country's finest historians. To our attendees, we will now transition to panel 2, and we'll get started with that panel promptly at 1:30. See you soon. Good afternoon, Professor West-Falcon. Would you mind turning on your camera for us? Thank you. And Professor Klarman, can you also turn on your camera? Thank you. And Professor Stone, if you can turn your camera on for us.
Can you hear me?
Yes, we can hear you, Professor Stone, but your camera, I think, is turned off.
I don't see it. That's very strange. I don't know why.
Let's see.
There, that's my video. Okay?
Wonderful. Thank you. Thank you.
Sure. Sorry for that.
No problem. No problem. We will get started in the next about 30 seconds. All right, I'll make it shorter than 30 seconds. So welcome back, everyone. Alan Boinsley here again, your host. Today, we've got the great fortune of hosting a panel that has Professor West-Falcon as our moderator, and then our two panelists, Professor Klarman and Professor Stone. I will now turn it over to you, Professor West-Falcon, to take us through a bit after the period of time that we have discussed this morning. You all will be talking about the 14th Amendment a bit closer to our present time. Thank you.
Super. Well, first, I'd like to extend my great appreciation and the honor it is to be a part of this conference. It's always a joy to be invited to do virtually anything by Ted Shaw and Jack Boger. So thanks so much for having me. I am very eager and excited about the panel we have here and the topic we're endeavoring to engage with, the legal challenge that yielded Brown v. Board of Education and Brown's evolution during the succeeding 20 years. So we've got a time frame of 1954 to 1975. But I do want to pause. I want to say what a great honor it is to be able to share this time and hear from two very preeminent scholars in the field. But I also was told when the invitation was passed along that I could have a bit of moderator's privilege, and I debated about how I would use it, but I think I'm going to use it right now to first say how incredible it is to follow, even though we aren't in person, Eric Foner. And it's a good way for me to introduce this panel and also connect not just personally to what Professor Foner just shared, but to the topic for this panel. And then after I'm done with that, the agenda will be, we're going to hear from both Professor Klarman and Professor Stone. And after that, have a little bit of back and forth amongst us with some questions, and then most definitely leave time for those of you who are listening to ask questions as well. So I really look forward to that. But as far as personal privilege, I want to follow along in what has been a great morning of people engaging with how today's topic relates to them personally. And I was heartened to hear that from both Professor Omar and Dean Chemerinsky. And so the ways this topic connects with me personally, I actually want to start because of how significant I think Professor Fauner is in helping us with what is the overarching inquiry, as I understand it, for our exercise in these 2 days, is this question of what's the path forward with respect to the Equal Protection Clause. And I find it very significant that Professor Fauner has offered us a path forward that is through history, and a path forward that is through history in a way that directly engages with the question of how we find meaning in the Equal Protection Clause. And I think there's also a way forward through Brown itself. I took the time to reread it for the umpteenth time right before we started this morning. And I would say that there's also, as I think Professor Fauner and others have pointed out, including Professor Amar, there's an intellectual way forward, I think, through the Supreme Court's early precedents in its interpretation in the slaughterhouse cases, and even going back, I've also revisited just recently Charles Black's essay in the Yale Law Review, and the simplicity of his arguments is also, I think, a potential intellectual way forward. But what is personal for me is that I am both a native of North Carolina, so there are ways in which I regret not being able to be home in my home state to have this opportunity. But I'm also, as far as how I connect to this material as a human being, I'm the descendant of not just enslaved African Americans. I'm the descendant of African Americans who were free, and then I'm also the descendant of slavers. And with that, the opportunity to connect to and think about the implications of what Eric Fauner has said about the Dunning School and the view of the Reconstruction era, and having been a public school student in North Carolina, that not just learned that history, but can very palpably recollect the shame and humiliation that history had on me as a student. I think it is really an instrumental and critical aspect to what we think about as we move forward. So again, I want to really thank the UNC Center for bringing all of these amazing individuals together. And so with that, I want to shift to the 2 decades we're looking at this morning. And so I will again do that shift with a personal connection. There was talk this morning again from Dean Chemerinsky about accidents of history, and much of our Supreme Court precedent is that. But I'd also say that I am here as I think an anomaly of history, which I look forward to Professor Klarman and Professor Stone giving their scholarly connections to, because within our time period, the time period of this panel, we have Brown, we have Brown 2, we have massive resistance, we have the Supreme Court's inaction in implementing Brown, but then we also have the important cases of Green, Swan versus Charlotte Mecklenburg, and as Dean Chemerinsky mentioned this morning, outside of our time frame, we have Dowell and Milliken. And so I am an individual as a public school student from North Carolina who was really able to get through that very, we now see it was a closing crack in this door of opportunity that Green and Swan versus Charlotte Mecklenburg opened up. And so these intellectual terms, these phrases like that refer to resegregation, it's a function of something that happened after me, and then Brown and Brown 2 being cases that if it had not been for them, I wouldn't be here now. And so what we're about to get some insights from, and what I'm really been looking forward to, is first Professor Klarman is going to speak for about 15 minutes, and then Professor Stone is going to speak for about 15 minutes as well. I think I'm going to see if I can slip in a couple of questions to Professor Klarman first, and then Professor Stone, but we'll see how things are going, because I think what might work work as well is for them to both just go one after the other, and we'll talk after. So with that, I will shift to Professor Klarman and look forward to getting questions from you as those who are listening when we're all done.
Greetings, everybody. Greetings from Maine, where it's even colder than where you are, unless you happen to be in Texas without heat, in which case you have my deepest sympathies that you were unable to join Senator Cruz in Cancun. I'm going to try in my introductory remarks to tell you a few things you may not already know about Brown. I'm trying to fit a lot into 15 minutes, so this may go pretty quickly, with apologies to anyone who's trying to take notes. First of all, Brown was actually a hard case for the justices. We tend to assume otherwise today. This case seems easy, and after all, the decision was unanimous, but the justices were intensely divided when the case was first argued. A memo written by Justice Douglas the day of the decision observed that had a vote been taken after the initial argument in December 1952, it would have been, quote, 5-4 in favor of the constitutionality of segregation in the public schools. Second point, why was the case so hard for the justices? I think because it posed a conflict between what they perceived the traditional legal sources to indicate and their personal values. Most of the justices thought racial segregation was a grotesque evil. It was, quote unquote, Hitler's creed, as Justice Black put it at one point. For example, in a letter to a friend, Justice Jackson, who had left the court for a year to prosecute Nazis at Nuremberg, wrote, quote, "You and I have seen the terrible consequences of racial hatred in Germany. We can have no sympathy with racial conceits which underlie segregation policies," close quote. The same was true of Justice Frankfurter, who was an Austrian Jew who lost family in the Holocaust, had been an advisor to the NAACP in the 1930s, and had hired the court's first Black law clerk, William Coleman, in 1947. Justices such as Frankfurter and Jackson believed deeply in the separation of law and a justice's moral views. In a memo he wrote while Brown was pending, Frankfurter insisted that his personal views on segregation were of limited relevance to the constitutional question. Quote, "However passionately any of us may hold egalitarian views, however fiercely any of us may believe that such a policy of segregation, as undoubtedly expresses the tenacious conviction of Southern states, is both unjust and short-sighted, he travels outside his judicial authority, and for this private reason alone, he declares unconstitutional the policy of segregation," close quote. The court could invalidate segregation, these justices believed, only if it was legally as well as morally objectionable. But the justices had difficulty finding a legal argument for striking down segregation that convinced them. Jackson wrote, in a draft concurring opinion that he never published, quote, "Layman as well as lawyer must query how it is that the Constitution this morning forbids what for 3/4 of a century it has tolerated or approved. Can we honestly say that the states which have maintained segregated schools have not until today been justified in understanding their practice to be constitutional," close quote. Frankfurter's law clerk, Alexander Bickel, spent a summer reading the legislative history of the 14th Amendment, and he reported to Frankfurter that it was impossible to conclude that the 39th Congress had intended that segregation be abolished or foresaw that it would be under the amendment. Jackson concluded in his draft opinion, quote, "It is hard to find an indication that any influential body of the movement that carried the Civil War amendments had reached the point of thinking about either segregation or education of the Negro as a current problem, and harder still to find that the amendments were designed to be a solution," close quote. These justices were not doctrinaire originalists. They believed that the meaning of constitutional concepts could change over time. But that did not mean that judges were free to simply write their own moral views into the Constitution. In the early 1950s, more than 20 states still segregated their schools. Thus, one could hardly maintain that evolving social standards condemned the practice. Precedent strongly supported segregation. Of 44 challenges to school segregation adjudicated by state appellate courts and lower federal courts between 1865 and 1935, not a single one had succeeded. As Jackson noted, quote, "Almost a century of decisional law rendered by judges, many of whom risked their lives for the cause that produced these amendments, is almost unanimous in the view that the amendment tolerated segregation by state action," close quote. Unable to justify the abolition of segregation as a judicial act, Jackson agreed to, quote, go along with it as a political decision, close quote. Third, why were the justices able to come out as they did in Brown, notwithstanding their legal doubts? The answer is that the dramatic shift in racial attitudes and practices during and after World War II led them to conclude that racial segregation was an egregious moral wrong. All judicial decision-making, I believe, involves both legal and extra-legal or political considerations, with the latter including factors such as the personal values of judges, existing social mores, and external political pressure on the court. But when the law, as reflected in factors such as text, original understanding, precedent, and custom is clear, judges will generally follow it. And in 1954, the law, as understood by most of the justices, was reasonably clear. Segregation was constitutionally permissible. For the justices to reject a result so clearly indicated by the conventional legal sources suggests that they had very strong personal preferences to the contrary. And by the early 1950s, so they did. World War II had been fought with an anti-fascist ideology, a rejection of theories of white Aryan supremacy, which forced many Americans to rethink their views about the South's Jim Crow system. The war also heightened the racial militancy of Black soldiers, who calculated that if they were good enough to risk their lives fighting for democracy abroad, they ought to be good enough to enjoy some of it at home. Many of these soldiers became the vanguard of the domestic civil rights movement. The Cold War imperative for racial justice that followed the war impelled Americans to try to put their racial house in order to counteract Soviet propaganda that capitalized on American racial injustices and tragedies in an effort to persuade largely non-white developing nations that democratic capitalism was synonymous with white supremacy. In addition, the great migration of African Americans from the rural South to the urban North, which had begun during World War I, accelerated during World War II, pushing another couple of million African Americans into northern industrial states, where they increasingly held the balance of power between the two political parties, which competed for their votes with progressive civil rights policies. These various forces were starting to have a concrete effect on racial practices by the late 1940s. Jackie Robinson desegregated Major League Baseball in 1947. President Truman issued executive orders desegregating the federal military and federal civil service in 1948. Black voter registration in the South grew from 3% in 1940 to 20% in 1950, and dozens of urban police forces in the South hired their first Black officers since Reconstruction. Minor league baseball teams, even in the Deep South, had signed their first Black players. The justices were aware of these developments generally, if not specifically. For example, Frankfurter noted, quote, the great changes in the relations between white and colored people since the First World War, close quote, and he remarked that, quote, the pace of progress has surprised even those most eager in its promotion, close quote. Justice Jackson went even further, quote, Negro progress under segregation has been spectacular and tested by the pace of history. His rise is one of the swiftest and most dramatic advances in the annals of man, close quote. Such changes in racial attitudes and practices made Brown possible. Frankfurter later noted that he would have voted to uphold segregation had such a case reached the court in the 1940s because, quote, public opinion had not then crystallized against it, close quote. The justices didn't think they were creating a movement for racial reform in Brown. They understood they were working with, not against, deep historical forces. Fourth and lastly, let me talk briefly about one way that Brown helped pave the way for the landmark civil rights legislation of the 1960s. The traditional view is probably that Brown educated and motivated African Americans to challenge Jim Crow. There's certainly something to that view, but Brown also crystallized the resistance of Southern whites to racial change, radicalized Southern politics as office seekers competed against one another to become the most extreme opponent of desegregation, and increased the likelihood that direct action protest, once it developed, would incite a violent response. Brown may have directly fostered white vigilante violence against Blacks. Polls reveal that 15 to 25% of Southern whites said to pollsters that they favored violence if necessary to resist desegregation. Most Southern politicians avoided explicit exhortations to violence, but the extremist rhetoric they used to condemn Brown almost certainly encouraged that violence. A speech by Congressman James Davis of Georgia was typical. He insisted that, quote, there is no place for violence or lawless activity, close quote, but only after he had called Brown, quote, a monumental fraud, which is shocking, outrageous, and reprehensible, close quote, and warned against, quote, meekly accepting this brazen usurpation of power, close quote. It's hard to miss the parallels to another racist demagogue who recently incited a violent attack upon our Capitol. Virtually every year after Brown, school desegregation resulted in violence somewhere in the South. Violent confrontations that tended to reveal African Americans at their best and whites at their worst. The few Blacks who had been handpicked as desegregation pioneers were almost always bright, well-mannered, and nonviolent. The mobs that sought to exclude them from white schools tended to be lower class, vicious, and obscene. Media coverage of these confrontations showed, according to one newspaper editorial, quote, quiet, resolute Negro children defying jeers and violence and sadism, close quote. To the extent that Americans formed their views on school desegregation and Jim Crow from watching televised scenes of mob violence from Little Rock or New Orleans, Southern whites were doomed to lose the battle for public opinion. There's a compelling linkage between particular public officials who benefited from the post-Brown political backlash in the South and the brutality that inspired civil rights legislation. For example, Bull Connor, Birmingham's longtime commissioner of public safety, had been run out of politics in the city in the early 1950s by local business and civic leaders, leading to some moderate racial progress in Birmingham. After Brown, however, the city's racial progress ground to a halt, and Connor resurrected his political career. In 1957, he regained his seat on the city commission by defeating an incumbent he attacked as weak on segregation. Standing for re-election in 1961, Connor cultivated extremists by offering the KKK 15 minutes of open season on the Freedom Riders as they rolled into town. Birmingham voters rewarded him with a landslide victory at the polls. In 1963, the Southern Christian Leadership Conference, looking to conduct demonstrations in a city with a police chief who was likely to use violence, selected Birmingham partly because of Connor's presence there. The strategy worked brilliantly as Connor unleashed police dogs and fire hoses against demonstrators, many of whom were children. Newspaper editorials condemned the violence as a national disgrace, and citizens voiced their outrage and demanded legislative action to curb such savagery. The Birmingham demonstrations dramatically altered Northern opinion on race and enabled passage of the 1964 Civil Rights Act. George Wallace personified the post-Brown racial fanaticism of Southern politics. Early in his post-war political career, Wallace had been criticized as soft on segregation, but soon after Brown, he felt the shifting political winds and became a diehard segregationist. In the 1958 gubernatorial race, Wallace criticized his principal opponent for not repudiating an endorsement by the Ku Klux Klan, thus unwittingly making himself the candidate of moderation. Wallace was handily defeated, leaving him to ruminate that he would never be out-segged again. Wallace made good on that promise in 1962, winning the governorship on a promise of standing in the schoolhouse door to defy integration orders. In June 1963, he fulfilled that pledge by physically blocking the admission of Blacks to the University of Alabama. In September, he used state troops to block school desegregation in several cities. Threatened with contempt citations from district judges in the state, Wallace relented. The schools desegregated, but within a week, Birmingham Klansmen had dynamited the 16th Street Baptist Church, killing 4 Black schoolgirls. Most of the nation was appalled by the murder of innocent children, and Wallace received much of the blame. Tens of thousands of Americans participated in memorial services and marches to protest the bombing. Northern congressmen, reflecting the anger of their constituents, introduced amendments to strengthen the administration's pending civil rights bill. I'm almost done. Early in 1965, the Southern Leadership Conference brought its Southern Christian Leadership Conference brought its voter registration campaign to Selma, Alabama, a site chosen partly because of the presence there of a law enforcement officer of Bull Connor-like proclivities. The result was another resounding success, albeit a tragic one. Sheriff Jim Clark's brutalization of non-resisting demonstrators culminated in Bloody Sunday, March 7th, 1965, when law enforcement officers viciously assaulted marchers, including John Lewis, as they crossed the Edmund Pettus Bridge on the way to Montgomery. That evening, television networks broadcast lengthy film reports of peaceful demonstrators being assailed by stampeding horses, flailing clubs, and tear gas. Most of the nation was repulsed. Citizens demanded remedial action from their congressional representatives, scores of whom endorsed voting rights legislation while condemning the violence. President Johnson then endorsed that legislation before a joint session of Congress 1 week later, telling the nation that we shall overcome. To sum up, Brown radicalized the white South and brought to the surface the violence that lay at the core of white supremacy. The beating of peaceful Black demonstrators by Southern white law enforcement officers repulsed national opinion and led directly to the passage of landmark civil rights legislation. Brown may have been less directly responsible than is commonly supposed for putting those demonstrators on the street, but was more directly responsible for the violent reception they encountered. Thank you.
Thank you so much, Professor Klarman. I'm going to turn it over to Professor Stone now.
Thank you. That was terrific, Mike. You did a great job of telling that story. So what I want to do in my talk is to discuss briefly what happened on the issue of school segregation in the years after the court's decision in Brown, some of which Mike has already touched upon. And I should say at the outset that I am a big fan of the Warren Court. Indeed, my colleague David Strauss and I published a book just last year marking the 50th anniversary of the end of the Warren Court, titled Democracy and Equality, the Enduring Constitutional Vision of the Warren Court. Now, our central thesis was not that the Warren Court was perfect, surely it wasn't, but our thesis was that the Warren Court had a proper understanding and vision of the role of the Supreme Court in American democracy, which is that it is most central for the Supreme Court and the federal judiciary to interpret and to apply the Constitution with an eye towards correcting the most serious weaknesses of a democracy, and our democracy in particular. That is, first, the tendency of the majority to disregard the rights and interests of the other, whether they be African Americans, immigrants, or persons accused of crime, and the tendency of the majority to manipulate the electoral and political process so as to ensure that they, that is, the majority at that given moment, retain their political dominance. It was these issues that most drove the vision of the Warren Court in such decisions as Brown, Engels v. Vitale involving school prayer, Reynolds v. Sims involving one person, one vote, and Miranda v. Arizona involving fairness in the criminal justice system, to cite just a few of many possible examples. Now, although the Warren Court was imperfect in many ways, and as David and I note in our book, the justices of the Warren Court were, of course, the product of the times in which they lived, and therefore had many of the weaknesses and blind spots of their contemporaries. It's also the case that they made extraordinary progress in a range of important decisions that significantly improved our nation to this day. Let me turn now, though, to the reactions to Brown and to the challenges faced by the judiciary and by the nation in the years after the decision. As Chief Justice Warren, speaking for a unanimous court in Brown, declared, quote, "In the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." With those words, Warren arguably hoped to sound the death knell for legal segregation of the public schools in the United States. Now, I don't know whether Warren actually believed that it would be that simple. As an experienced politician, it's difficult to think that he would have been so naive. And in fact, the reactions to Brown, as you've already heard, were furious. So furious, especially in those states in which racial segregation was the norm, that whatever hopes Warren and his brethren might have had for a revolutionary response to the decision was soon dashed. At the time of Brown, 17 southern and border states, plus the District of Columbia, maintained segregated schools by law, and 4 states outside the region allowed segregation by local school boards if they chose to do so. When Brown was decided, the NAACP was euphoric. Thurgood Marshall, the chief litigator for the plaintiffs, declared that if the decision was violated anywhere, by the next morning, quote, "we'll have the responsible authorities in court." He predicted that as a result of Brown and the persistence of the NAACP, segregation in all of its forms would be eliminated from the nation by 1963, the 100th anniversary of the Emancipation Proclamation. Things didn't turn out so well. As the justices had surely anticipated, Brown met with furious opposition. Nearly 100 members of Congress, including 19 senators, all from states of the former Confederacy, signed a document that came to be known as the Southern Manifesto. It declared that Brown substituted naked power for established law and was a clear abuse of judicial authority. Most state and local politicians in the South announced that they would never accept integration, and state and local school boards devised ways to evade Brown. Not surprisingly, there was not much desegregation. A decade after Brown, only a handful of previously segregated schools had been integrated. A year after Brown, the court decided Brown 2, in which the court, in another unanimous decision, addressed the question of compliance with Brown. Recognizing the already furious response to the decision, the court made clear that desegregation did not need to take place immediately, but, quote, with all deliberate speed. Over the course of the next decade, the court decided 3 cases involving the enforcement of Brown in the context of public schools. In Cooper v. Aaron, decided in 1958, the court faced a crisis in Little Rock, Arkansas. In light of Brown, the Little Rock School Board initiated a plan to desegregate its schools. All other school districts in the state refused to comply with Brown, and the Arkansas legislature amended its state constitution to prohibit desegregated schools. Arkansas Governor Orville Faubus vigorously opposed desegregation, and there were constant threats of violence to the Black students who had the courage to defy the segregationists. At this point, the school board suspended its plan to desegregate. The case came to the Supreme Court, and in a bold opinion signed by all 9 justices individually, the court held that, quote, "the constitutional rights of Black students are not to be sacrificed or yielded to the violence and disorder that was occurring." Cooper v. Aaron was an unswerving affirmation by the court that desegregation was the law and must be implemented. In the court's other 2 decisions in the decade after Brown, Goss v. Board of Education of Knoxville in 1963 and Griffin v. Prince Edward County in 1964, the justices again ruled unanimously that desegregation was essential. But except for those 3 decisions, the court basically took a backseat. It either refused to hear or summarily decided cases dealing with the issue. And despite those 3 opinions, what was happening in the states over the next decade was largely a disaster, especially in the states of the Deep South. In the 6 border states and the District of Columbia, Brown had an important impact as the number of African-American students attending integrated schools increased to 55%. In the states of the South, though, the situation was quite different. 10 years after Brown, only 1% of all African-American students in the South were attending school with white students. And excluding Texas and Tennessee, which were a bit more reformist, the number was less than 0.5%, or only 1 in 200. A number of factors contributed to this failure. Most obviously, white citizens and government officials in these states were furiously and often violently opposed to integration of the schools. Not only did they physically threaten Black students who had the courage to seek to enter previously all-white schools, but they often threatened their families and their lawyers. Organizations like the Ku Klux Klan and the White Citizens Councils were openly aggressive in their threats of physical violence. They were so effective in their intimidation that as late as 1961, not a single desegregation suit in the area of education had even been filed in Mississippi. Moreover, threats of violence were often lodged not only against plaintiffs and their lawyers, but also against judges. Most Southern state court judges did not need threats in order to be hostile to such litigation, because most of them were already personally and often unalterably opposed to school integration. Chief Judge J. Edwin Livingston of the Alabama Supreme Court, for example, gave a speech in 1959 in which he openly declared, "I'm for segregation in every phase of life, and I don't care who knows it. I would close every school from the highest to the lowest before I would go to school with colored people." Moreover, those few judges, including federal judges, who were open to such litigation and supporting it, regularly found themselves and their families threatened. The District of Columbia Court of Appeals judge, for whom I clerked in 1971, J. Skelly Wright, had been a federal district court judge in Louisiana during this era. Because he was determined to make progress in school integration, he and his family were regularly threatened with burning crosses and worse. And he finally sent his wife and children to live in DC in order to hopefully secure their safety. When John Kennedy was elected president, Louisiana senators demanded that he appoint Judge Wright to the DC Circuit, not to promote him, but as they put it, to get him the hell out of the South. Southern political leaders at both the state and local levels were fiercely opposed to school integration. Throughout the South, they called for defiance of court orders. Governor George Wallace, for example, publicly proclaimed, quote, "I say segregation now, segregation tomorrow, segregation forever." And state legislatures throughout the South passed an endless variety of pro-segregation laws. As the Southern saying went, as long as we can legislate, we can segregate. Virginia closed any school subject to a desegregation order, and it even went so far as to build private segregated schools. Louisiana passed a law denying graduation to any student who attended a desegregated school. Mississippi made it illegal to attend a desegregated school. Now, of course, these laws were unconstitutional, but in light of the circumstances I described earlier, who was going to bring suits challenging them, and what judges would have the courage to rule in their favor? On top of all this, President Eisenhower during these years was largely silent on the issue of school desegregation. And even President Kennedy, although supportive generally of civil rights, took little concrete action to support school desegregation until violence erupted, as described by Mike Klarman in Birmingham in 1963. As a result of all this, to repeat myself, by 1964, a decade after Brown, only 1% of Black school children were attending integrated schools in the South. What could the Warren Court have done about this state of affairs? Frankly, it's not clear. Indeed, not only was the court being demonized for its decision in Brown, but of course it was being demonized nationally for its liberal decisions on a broad range of issues, ranging from school prayer to the rights of criminal defendants to one person, one vote, and so on. And impeach Earl Warren billboards were everywhere, not only in the South. What finally changed things was Congress's passage of the Civil Rights Act of 1964, Title VII of which prohibited discrimination on the basis of race in any program receiving federal financial assistance. This suddenly gave a huge incentive for Southern schools, which were receiving large federal subsidies, to conform reluctantly to the law. And it gave federal judges, for the first time, an effective tool to enforce segregation. From 1964 to 1973, federal funding for eligible Southern schools increased from $267 million per year to more than $1.4 billion annually. State legislatures simply could not forego this support. As a result, from 1964 to 1973, the percentage of Black school children attending school with whites in the Southern states increased from 1% to more than 90%. What's clear historically is that although the Supreme Court clearly was not able to achieve this on its own, none of this would have happened if the Supreme Court in Brown had not passionately and unanimously condemned racial segregation of public schools as a fundamental violation of our Constitution. Was there more the court could have done to compel compliance with this decision in Brown? Frankly, given the circumstances in the South and the depth of the anger, I rather doubt realistically that there was all that much the court could have done without the active and aggressive support of federal authorities. It's interesting to note, though, that Brown was not the only Supreme Court decision that has dramatically upset the American people over the years. Consider, for example, such decisions as Loving v. Virginia, which recognized the constitutional right to interracial marriage, or Roe v. Wade, which recognized a right to abortion, or Obergefell v. Hodges, which recognized the constitutional right to same-sex marriage. These were all highly controversial decisions, but they all, with but a few exceptions, won the day in terms of the ability of individuals to exercise their rights fairly quickly. Now, of course, the future of Roe v. Wade remains uncertain, given the current makeup of the court, and state laws have become ever more aggressive in their effort to prevent women from exercising this right. Roe, in this sense, although it took half a century, may be the closest analogy to Brown in terms of opposition to the decision. But it played out in very different ways over a much longer period of time and without quite the same degree of violence. One interesting question is why people in the South were so vehemently opposed to school desegregation. In the grand scheme of things, what was the big deal? Well, by coincidence, my wife, Jane Daly, who is a history professor at the University of Chicago, just published a wonderful book titled White Fright, The Sexual Panic at the Heart of America's Racist History. And it offers an intriguing answer to that question. Not a surprising answer, but a powerful one. Basically, the reason for segregation and the reason for passion about segregation, and especially in the schools, had a lot to do with the fear of the loss of white supremacy. If Blacks and whites could sit together on buses, and more importantly, if children who were Black and white could sit together in a classroom, they would get to know each other as real people. And they would ultimately come to see each other as partners. And ultimately, they would be married and have children and destroy the whole principle of white supremacy. And it was this fear, I think, that so vehemently motivated those in the South to engage in the kind of horrid violence that they did in response to Brown. Thank you.
Thank you. Those were both wonderful opportunities for us to get a lens into this historical period. And I feel like I personally have a sense of that maybe part of the answer that to the question I'm going to ask, but I want to go back to Professor Klarman and give you an opportunity to engage a question you have written about quite a bit, which is to what extent the massive resistance that followed Brown 1 and Brown 2 is a function or is inevitable given the lack of capacity as of the federal courts or the Supreme Court in particular to combat what is at the core of white supremacy as an ideology and some of the things that Professor Stone mentioned. And so if you could share what you have said about this over the years, but then I'd also love it if you could, you mentioned January 6th and what we've seen over the last several years, how, if at all, your view on this has changed as more and more decades have passed since the Brown decision.
On the first point, the Supreme Court doesn't have the power to simply decree a new set of arrangements and expect society to follow. Lots of court decisions that have intervened in very important ways on social issues have been resisted quite fiercely and sometimes pretty much nullified. So starting back in the 19th century, Prigg versus Pennsylvania, which struck down Northern personal liberty laws, produced a backlash in Northern legislatures, especially in the 1850s. Dred Scott produced a massive backlash within the Republican Party. The court essentially declared the Republican Party unconstitutional. Republicans don't roll over and play dead, rather they mobilize in opposition to the court decision. This is the same thing as Jeff mentioned, that Roe versus Wade incites the mobilization of Christian conservatives into politics in a way that they had not previously, or at least not recently, participated. Furman versus Georgia, mobilized support for the death penalty after it looked as if the court was going to strike down capital punishment. So it's not surprising that this would happen. The court doesn't have its own enforcement arm. It's reliant on the president. And as Jeff said, Eisenhower did not display a lot of support for Brown. Privately, he was quite critical, and publicly, he refused to endorse the decision. So I don't find it surprising that Brown would produce this sort of effect in the White South. And indeed, the justices knew this. Justice Black predicted this, even though he was willing to go along. President Eisenhower predicted this. One of the reasons he was critical of Brown was that he thought it would destroy Southern moderation, and that's exactly what happened. Developments politically in the last decade have reinforced my view that American history often works in a pendulum-like fashion. President Obama's election, which many of us thought and hoped would signify a new era of post-racism, post-white supremacy, pretty clearly inspired a rightward shift in the white working class that led to President Trump being able to win the Republican nomination in 2016 on a platform that was pretty close to openly racist. And now we're seeing a backlash against that. So just as Brown produced a backlash that produced a counter backlash, right? Brown brought out the violence at the core of white supremacy, which when laid bare on national television repulsed Northerners. Trump has repulsed 81 million Americans who turned out to vote against him in record numbers, and is going to lead to dramatic changes in the racial policies of the national government, and hopefully launch a new era of progressive politics. It's hugely ironic, maybe not completely surprising, that politics would often work that way. The goal of politics is to get your opponents to overplay their hand, and that happens, and things swing back and forth. That's kind of the same story that produced the Civil War in the 1860s. So no, I think what's happened in the last decade in politics reinforces my view about backlash dynamics and the pendulum swing in American politics.
Professor Stone, you identified yourself as a fan of the Warren Court and lauded it, and but I would ask you to engage with the same type of question, though, to the extent that I was trying to highlight, and I'll be more explicit, that in the 20-year period that our panel is pinpointing, the African-American school children who were the plaintiffs in these cases did not enjoy any of the benefits from being the named plaintiffs. None of the remedies inured to their benefit. And I am identifying myself as someone who's definitely not old enough to have been around then. So it's taking until the 70s and the 80s. And when someone like our now Vice President Kamala Harris says, I was that little girl, I'm identifying myself as that little girl more to make the point of which set of African Americans actually were the first truly to benefit from Brown. And I don't know that aside from those of us who are who've spent quite a bit of time delving very deeply into that, I think that is a pretty counterintuitive historical reality that these people you are seeing in the black and white photos and who were subjected to the mobs that surely Eisenhower did reinforce and send reinforcements quite literally for a Federalist concern, right? He did not want mob rule, and he made sure the white folks who were against segregation understood he was the commander in chief. But as you've both noted, there wasn't a willingness from the executive branch and really not even the legislative branch to put teeth until quite some time later. So those of us who are African American and got, as I said, through that door, it is striking to me how late that door opened, and then also striking how short a time period it stayed open. So I think it is very possible to still be a fan of the Warren Court. I certainly am myself, but I'd love to hear how you respond to what has been a longstanding thesis and perspective of Professor Klarman.
Well, I would say that I assume that the justices of the Warren Court were not naive. I think they understood that they were opening a door to what was going to be a very difficult challenge. I don't know if they anticipated how bad it was going to be. Probably not, frankly, but I'm quite sure they understood that this was not going to be, okay, now we decided Brown and we'll have integrated schools within a week. They did know there would be a serious and maybe violent opposition to this. So I think they were taking a long view, and they would have loved it if Brown had been able to be implemented relatively quickly, the way some Supreme Court decisions are. But I think they were not naive about that. And my guess is if you had asked Warren, for example, this question, he would have said, I understand this is going to be a challenge. I don't think he would have predicted it was as bad as it became. But I think he would say, we're doing the right thing for the long run. And doing this today will make this a better world in the future. And I actually think that we are a much better society because of Brown, even though we paid a price to get to where we are. We're a long way from being perfect, obviously. But I think Brown clearly made us a better society. If Brown hadn't been decided, it's unlikely that we would have had the civil rights movement in the same way that we did, because some of that was triggered by the violence about Brown. And so I guess I would say that you know, it's clear that the students who had the courage to come forward did not get what they were seeking. But that's true, you know, with abortion. I mean, you know, the women who bring the lawsuits about abortion back in the 1960s and 70s generally didn't get abortions for different reasons, but nonetheless didn't actually get the abortions. And I guess I would say they were the students who wanted this and the parents who wanted this did not get what they immediately wanted, but they got what they ultimately wanted, and they were heroes for doing it. So I think Brown made this a much better society, ultimately. And I think that the people who had the courage to pursue these rights were, as I said, heroes and deserve enormous credit. And I don't know what the world would be today if Brown had not been decided. Would we still have racially segregated schools? Would we have had federal legislation that held them illegal? I don't know. It's not 100% obvious to me, even now, that we would have gotten to that point in history. Probably we would have, but I don't know that. So I think Brown was, when all is said and done, a victory for civil rights and for the rights of equality in our country, and a victory for the rights of those children who put themselves forward, because they really are heroes and they did help change our society in fundamental ways.
Well, thanks for that. I also want to ask to the topic that is the topic of the conference writ large. We've spent the morning having individuals who are preeminent experts in the interrogation of what the Equal Protection Clause, but the 14th Amendment writ large, both should mean in a literal sense, if you are the interpreter, which is what the court is, the binding interpreter, that is, but also an engagement with what its original purposes are, and the incorrectness of Plessy should go without saying. That's why I was mentioning Charles Black and his various references in a law review article that, quite frankly, in my view, never got the same kind of attention that Herbert Weschler's critique of Brown long has. And so it is still, to me, in 2021, valuable to hear your thoughts, Professor Stone, on the substance of it. Because if Plessy was wrong from the very moment it was decided, as I got a question through the chat that was raising that point, and I think it's a good one. What does that ultimately say? Not about the ultimate morality of Brown, and there is a lot of rhetorical observation that Brown is correctly decided, but with respect to the substance of what does the Equal Protection Clause mean, and what does the 14th Amendment mean, and what is the way forward? If the way forward is designed to look to how we, as those who are studying the court and thinking about what kinds of legal arguments can be made going forward, what is there to be done with equal protection doctrine from this 20-year period? Does it have any potential for the way forward? I'm very curious as to what you think on that.
Well, first of all, when you say Plessy was clearly wrongly decided, from where we sit today, that seems clearly correct. But if you were an originalist, and a strict originalist, then Plessy would be a hard decision, because one can't say, as Michael's noted, that the framers of the 14th Amendment affirmatively understood that racial segregation was unconstitutional. That would be a very hard case to make historically, frankly. And if you believe that that's the right way to interpret the Constitution, as probably 6 of our 9 current justices do, then if they were judges back at the time of Plessy, it's not clear what they would have done, frankly. And even originalists today struggle with Brown, because they don't want to admit that Brown was, quote, wrong, because it was not originalist, but they also can't very well say that Brown was wrong. But the truth is, I think that Brown is a great example of how one should interpret the Constitution and how one should approach that responsibility. And it's a great example of why originalism, in the narrow way that people like Bork and Scalia and some of the current justices understand it, is idiotic. Because I would say the right way to interpret the Equal Protection Clause and other provisions of the Constitution as well is to think of them as aspirational. And that's how I think the framers thought of it. When they said Congress shall make no law abridging the freedom of speech or of the press, or that no state shall deny any person equal protection of the laws, they had some sense of what they might have meant at the time, but they didn't necessarily know or want to dictate what that would mean a century or two later. And they were, for the most part, people who were fairly smart and thoughtful, and they understood they were putting in 12 words or 14 words or whatever it is, something that did not have a concrete specific meaning. So I think that Brown was right. And when I teach the case, particularly in the last 15 years or so, I use it as an example of, okay, what do you guys think of originalism? Right? If originalism would force you into the decision that Plessy was right and that Brown was wrong, can you really accept originalism as a legitimate approach to constitutional interpretation? And this is one of the real problems that originalists have. So my view is the way to think about Brown is, and about the Equal Protection Clause, is that its fundamental aspiration was to create equality in our country. And I think that the best way to think of it in this respect is the way the Warren Court did, which is basically to say, are there groups in society who are the other and who are not going to be treated equally and fairly and in an even-handed way by the majority? And in those are situations where it's essential for courts to step in and to protect their interests, because democracy is not perfect. And Madison and Jefferson understood this. I mean, they talked about this at the time, that democracy is good, but it's not perfect. And the two biggest weaknesses of democracy is that majorities are not very good about being fair to the other. And the second is they're not very good at thinking about the political process in a fair and even-minded way. And those are the two areas where courts need to be most aggressive. And those are the two areas where the Warren Court was most aggressive. So my view is they did take the right approach in Brown, absolutely. And it turned out to be a winner. It was not easy to get there. And I don't know what society would look like today if the court had reaffirmed Plessy in Brown, but I don't think it would be as good a society as it is today.
Well, that is certainly something that is often taught in the context of Brown, and I think a recurring theme that Plessy was inevitable, but it doesn't fit as well, in my view, with how the morning has played out, right? The morning has, if you look at not just specific intent originalism, which is, I think, the easier kind of originalism to dismiss, which would be, can we get in the head of the people who wrote the words and, get in a time machine, go ask them the question, hey, would you approve or disapprove of Jim Crow segregation? I think that's why the new originalists and the new originalists have let that go the way of Robert Bork and arguably even his chances of being on the Supreme Court. So that's a bit of a straw man. But if we even used, and I think, again, Professor Fauner, as the historian would say, none of us lawyers should be going about trying to find one fixed meaning. So I think that may be the easier way to criticize the originalists. But Plessy itself has so many problems with both its internal inconsistency, but the fact that it is hinging on just absolute falsities, that Jim Crow segregation isn't meant to shame, harm, and denigrate, and that's all being put, that is all in the minds of the people who are being put into a caste system. I guess the opportunity to engage with how wrong Plessy has to be in the substance of, based on what people have told us this morning and what we've engaged with, that if we look to not the specific intent of those who wrote the words, but instead an inquiry into what was the purpose of the 14th Amendment writ large, it feels like what we've been brought together here to hear this morning is that the purpose is far clearer. And when we have Eric Fauner, the quintessential expert, the one who's saying we've maybe endured, and that's what I was trying to allude to, I knew and study pseudoscience, but I'm coming increasingly willing to say I was also subject to a form of a pseudo-history about Reconstruction. And is that potentially a way to shift the way we both think about Plessy and its inevitability? Because it can't be inevitable to all white men of the time when we have Harlan himself dissenting in the moment. And Harlan is someone who had dissented so vehemently and had a very specific theory in the civil rights cases. I'm curious to both you, and I'll go back to Professor Stone first, but I want to engage Professor Klarman too. Is that not a potential intellectual way forward to delve much more deeply into the reasons behind Harlan's dissents in both the civil rights cases and in Plessy, instead of just moving past Plessy? Because granted, it's quite unpleasant, but I think there's plenty to delve into substantively there potentially. But what are your thoughts?
Well, I mean, I agree with that. And I didn't mean to suggest that Plessy was right or that I would have decided it that way. All I was saying is that viewed in the times, I don't know enough about the culture of the moment to understand what the response to Plessy would have been if it had come out the other way. Justices do care about that. Justices do worry not only about the right result, but about what are the consequences of the right result. And they often, of course, temper their decisions and spread them out over a long period of time and so on. What I don't know enough about, because I'm not a historian, is what the justices in Plessy would have thought about what would have happened had they decided the case like Brown. And I don't know what would have happened had they done that. And would the society have been able to deal with that? Would it have been much worse than what happened after Brown, or not as bad? I don't know the answer to that. But I don't know, whether the justices themselves in Plessy believed this was the right result, period, based on however they were interpreting the Constitution, writing a not very convincing opinion, or whether they personally did not think this was a desirable or a right result, but that in the circumstances, it was the best they could do. Think about Korematsu, right? I mean, Korematsu is a disastrous decision. But the justices who reached it, I suspect, at the moment they reached it, thought that external factors made it the necessary decision. And it doesn't make it right, it doesn't make it courageous, but if you're trying to simply understand what's going on, right? Are the justices actually acting out of a sincere legal theory that they believe in, or are they acting out of the constraints upon them based upon what they think are the best interest of the court as an institution and the best interest of the nation in terms of what the consequences of a decision would be? So I just don't know enough about the internal workings and views of the justices in Plessy. And the very fact is, as Michael has pointed out, that the Warren Court, or the pre-Warren Court, I should say, was as divided as it was before Earl Warren replaced Vincent, is revealing. in terms of how both uncertain they were about what the quote right result was, and also about how nervous they must have been about what the consequences would be both for the Supreme Court and for the nation. So, you know, I do think it's important to recognize that justices are often affected by those types of factors. And that often explains some decisions, which may not be the right decisions in theory, but which in their view, at least, might have been the right decisions in the circumstances of the moment. And again, Korematsu is another terrible decision that I think can be explained only on that grounds.
Professor Klarman, and I also, we have only about, we have our 15 minutes left, so I'd love to get questions if folks have them, and I have one question directly that I'm going to put to you. But Professor Klarman, if you have any responses or thoughts in reaction to what Professor Stone has said about the historical context, even around Plessy.
I do. I'll try to keep this to 2 or 3 minutes so we have 10 minutes for other questions. So I agree with the way Jeff thinks about this, which is to separate the judge's inclination from their capacity. That is, were they inclined to strike down segregation but didn't think they could get away with it? And the answer, I'm pretty clear from the work I did when I was writing my Jim Crow book, is that they had no inclination to strike down segregation. But even if they did have the inclination, they wouldn't have had the capacity to make it stick. If you struck down segregation laws in the South in the 1890s, Black people would have simply been thrown off the train or killed. This is the peak era of lynching, and it's not as if whites in the South were going to accept integration regardless of what the Supreme Court said. I don't agree that Plessy is obviously wrong as a legal decision. If we're looking at things like text, original understanding, and precedent, I actually think Plessy is probably at least as right as not on legal grounds. It's obviously morally reprehensible from our perspective today. This ties in with something else when Jeff, mostly I'm in agreement with Jeff, but when he defends Brown, it's mostly on the grounds that it's obviously a morally right decision. And I would be curious how we limit that sort of methodology when we have 6 justices who are now among the most conservative in the last 100 years. If it was right for the court to invoke what seemed more obviously right morally, then why is it not right for these justices to say, well, I believe in colorblindness, so affirmative action is unconstitutional. I believe that money in politics is speech and it's a good thing, so I'll strike down all campaign finance regulation. I think that's the problem. If you want to defend Brown and simply generalize this approach to constitutional interpretation, which is that they should do the right thing, it doesn't give you much ground for criticizing a right-wing court. And that ties into the last thing I think I'll say. When you ask the question about the way forward, I think it's a mistake to think the way forward is by looking into the past and looking at Harlan dissents or looking at the original understanding of the 14th Amendment. 2 things about the way forward. One is, I think, and this is a criticism, I think, of Jeff's position about the Warren Court. I think liberals in the 1960s became too fond of the judiciary and the idea that judges would protect rights. And I think one thing we learned, maybe largely because of Roe, is that having a win in the Supreme Court does not mean a long-term victory, and that political mobilization is a more important way to secure rights than simply winning a victory in court. And I do think to win in court often disincentivizes people from staying motivated. So the best way, so that's one point, is I'm not looking for the court to produce racial nirvana. I would be actually happy if today's court would just leave things alone that democracy has produced. And the concern is that this most conservative court in the last 100 years will strike down every democratic reform initiative that the Biden administration might undertake, including efforts to fix racial inequalities on the ground that it violates the colorblind interpretation of the 14th Amendment. So my position would be, Democrats are entitled to control the Supreme Court. Mitch McConnell stole a seat on the court. Democrats have won 7 of the last 8 presidential elections. They're entitled to control the court. And I would just want a liberal majority on the court not to chart new directions, but just to leave politics alone rather than strike down gun control, strike down voting rights legislation, strike down efforts to produce racial equity, strike down efforts to expand healthcare. So a mistake to expect the court to produce liberal or racial nirvana. I would be pretty happy if the court would just leave things alone. I don't expect the 6 conservative justices who dominate the court today to be willing to do that unless Democrats threaten them with the idea of court expansion. That actually ties in, this is the last thing I'll say, that ties into where we would be without Brown. My guess is, lots of other countries have done away with pretty awful racial past without a Supreme Court decision leading the way. South Africa has done away with apartheid. Wasn't easy to do, but they didn't do it because of a court decision. Great Britain has undone a lot of its racist past without a court decision. I don't deny that Brown affected the way racial change came in the United States, but the idea that we would not have had a racial revolution without Brown, I think, is implausible. And I don't take Jeff to be saying that. He's saying it's hard to know exactly how things would have played out. That seems right to me.
Super. And shorthand can always be dangerous. So we may have to agree to disagree. But to be clear, I think the invitation that I was trying to take up is the one that when I say go back to Harlan's dissents, that is a specific invitation to interpretations of the Congress's power under the 13th Amendment, what Professor Amar mentioned with respect to Harlan's very robust interpretation of the citizenship clause. I think that is an invitation that, again, we can all have different views on whether it's a useful one, but what is the doctrinal interpretation of the 14th Amendment going forward, to the extent that there are new originalists and new originalists, they have made it their life's work to invite a reevaluation of the meaning of the Privileges or Immunities Clause, for instance. And what I heard this morning, and we know that we have amongst us scholars who've been making similar invitations, and for this two-decade period, we're kind of in a different way of thinking about it typically. So I have a great question, and I'm going to not paraphrase it, but read it, and I'm going to tell you in advance, and it'll be an invitation to either of you to respond. The question part is going to be thoughts. So there's not a big question. It's more, I'm going to read you some analysis and then get your reaction. And you might even be able to figure out who it came from, but I'm not going to identify. So one could read the court's educational jurisprudence in 1954 to 74 through a regional lens. It was remarkable, not Earl Warren, but Warren Burger, remarkably, Earl Warren, but Warren Burger, who arguably wrote the most thoroughgoing school desegregation decree in Charlotte, Mecklenburg, which accelerated southern school desegregation. Yet as the litigation shifted to the northern metropolitan areas like Detroit, the court shifted dramatically to create equal protection clause jurisprudence that foreclosed Milliken in Detroit further desegregation in much of the Northeast and Midwest. And so that's part of the historical context you've both described and illuminated, and so did Dean Chemerinsky this morning. So in a sense, one might observe that as during Reconstruction itself, the court needed a sturdy national source of political support to implement a regime of enlarging racial equality. Once the desegregation challenges emerged in the regions of the country that had largely supported Southern school desegregation, the court tamed its jurisprudence. Thoughts? So thoughts. I don't know who of you would go first, but
I'll take a shot at it.
Great.
I think part of what that was about was the notion, and Berger certainly took this position, that laws that have a disparate impact are different from laws that are intended to be discriminatory. And I think his view and his colleagues' views in Milliken and beyond were that in the South, the racial segregation was intended. That was the purpose. In the North, the argument was that there was residential segregation, but it was much more difficult to prove in as straightforward a way that that was the result of an intent to create school segregation. And Berger did not want to go into that very complicated and ambiguous area of how do you know when something was actually intended for racist reasons, as opposed to the racist effects being incidental to whatever was causing it to happen. So I think part of it was that Berger was trying to cabin the issue of desegregation to those circumstances where it was a remedy for explicit, intentional racial segregation. And he didn't want to get into the much messier question of, does every school have to be equally racially disparate, regardless of where people live? And I think that was it. He saw it as a practical issue.
Great. Do you have any thoughts, Professor Klarman? We're also we have about 3 minutes left at most, so it also could be an opportunity for some closing thoughts on your part.
Quickly, in response to the question, I don't think it's clear in 1954 that any of the justices were thinking about the effect of their decision on the South. They were striking down de jure segregation, state laws that assigned Black kids to one school and whites to another school. All northern states had actually prohibited that practice by law, although there were constant subterfuges so that they were doing it just below the surface. If you look at all the internal conference notes and memos, it's not entirely clear that any of the justices thought that what they were doing would have an impact on the North. The NAACP started bringing cases in places like Long Island in the early 1960s, and that immediately started producing a backlash. So people may remember or have read that George Wallace took his racism north in 1964. He competed in Democratic primaries in Wisconsin, Indiana, and Maryland, and he won between 30 and 45% of the vote. On Long Island, white working class, often Catholics, were already voting for Barry Goldwater in 1964 before Richard Nixon implemented a Southern strategy. So what happened in Milliken is a reflection of the Republican Party's Southern strategy, which starts with Goldwater, who runs a campaign against the 1964 Civil Rights Act and wins the vote in 5 deep South states. He wins something like 98% of the white vote in Mississippi. Nixon's elected in 1968 on some combination of being tough on crime and arguing for slowing down school desegregation. He appoints 4 justices in his first term, and the majority in Milliken is 5-4, with 4 Nixon appointees and Justice Stewart, a holdover an Eisenhower appointee. Right? This is just the politics of race. And if you'd had the Warren Court continuing into this time, then the decision would have come out differently. Whether the Warren Court could have made it stick, whether they really could have enforced desegregation on a northern population that was not really very supportive is another question. Remember, Joe Biden, who was supposed to be a liberal from Delaware in the mid-1970s, was supporting a constitutional amendment to limit busing and making nice with Southern segregationists like Strom Thurmond and James Eastland. It's not a real happy reflection on the country, but maybe there was a national consensus to end the Southern system of formal Jim Crow, but there was never a national consensus to produce genuine racial equality. We're probably closer to that as a national consensus today than we've ever been, but we just had 74 million Americans vote for a pretty openly racist presidential candidate. So it would suggest we're still a ways from producing any deep consensus to that effect.
And that certainly is reflected in the equal protection jurisprudence as well, that the Washington versus Davis Feeney line of cases, which is, I think, where the conference itself is heading. I don't know if we, I think, are we at time or do we have, okay, we're at time. So thank you both very much. Really a pleasure.
Thank you.
Thank you so very much. That was a very rich discussion, and thank you very much, Professor West-Falcon, Professor Klarman, and Professor Stone for talking with us and among yourselves about Brown and the evolution of Brown between 1954 and 1974. Tremendous. To our attendees, we will now be transitioning over to our next panel. We'll get started with that panel at 3 o'clock. Thank you. Good afternoon. I would like our moderator and panelists from our next panel, panel 3, to please turn on their cameras. Thank you. I can see you. Okay, great. I can see you all. Thank you for being with us for our panel 3. We have the great honor and pleasure of introducing our moderator, who is our very own Professor Erica Wilson. We have our panelists, Professor Elise Bakke, Professor Jerry Spahn, and Professor Osamudia James. They will be talking about the arrival of Washington v. Davis and Bakke, which yielded a judicial demand for proof of invidious intent, along with the ironic cry from whites for equal protection between 1976 and 2014. Professor?
I'll start us off by thanking you on behalf of the panelists for staying with us through this, what's been a wonderful symposium so far. Again, my name is Erica Wilson, and I'm a professor here at UNC. So I want to lay the groundwork for this panel by noting that in what is now an infamous decision in Washington v. Davis, the Supreme Court considered the constitutionality of an employer's use of facially neutral employment tests that resulted in a racially disparate impact for African-American candidates. The court infamously concluded that the Constitution does not prohibit facially neutral policies that have a racially disparate impact, absent proof of a discriminatory purpose or intent. This intent standard imposed by Davis has had a profound effect on the modern development of the equal protection doctrine. As our panelists will discuss, the rejection of the disparate impact and embrace of this intent standard hollowed the relief available to people of color, particularly African Americans, under the 14th Amendment. I think it's important to point out that this is the case because of the way that modern racial discrimination works, right? Racial discrimination in the modern context is often effectuated through the use of race-neutral methods and institutional arrangements that interact with patterns of historical racial subordination to create racially exclusionary results. And so the court's thwarting of disparate impact in Davis and embrace of the intent standard insulates this kind of modern form of discrimination from constitutional scrutiny. Also, as the panelists will talk about, we saw the equal protection doctrine stretched with the Supreme Court's decision in Bakke, which interpreted the 14th Amendment Equal Protection Clause in ways that opened the door for reverse claims of discrimination and claims that the Equal Protection Clause was also intended to and needs to protect the majority or whites. So these two cases have had a profound impact on the way that the equal protection doctrine has been deployed in modern times to address racial discrimination, and have also had a profound effect on the ability or lack thereof of equal protection doctrine to substantively make a difference in terms of undoing centuries of racial subordination, particularly for African Americans. So the good news is that you don't have to listen to me talk about this for an hour and 15 minutes, but we have an esteemed panelist who will discuss the trajectory of this doctrine. As Alan mentioned, we have Professor Osamudia James, Professor Jerry Spahn, and Professor Elise Bakke. So I'm going to get us started in this conversation by asking the panelists to comment generally on the question of when and how the modern Supreme Court went wrong in its equal protection jurisprudence, and what you think should be done about it. Each of our panelists will generally answer these questions. Then we'll have a facilitated conversation between the panelists and myself, and then we'll open it up for questions and answers. So I'm going to turn it over to Professor Osamudia James to get us started with this, what should be a really riveting discussion.
Thank you so much, Professor Wilson. And I want to start by thanking the organizers of this conference and panel for including me in the conversation today. It's a delight to be in the company of such distinguished co-panelists, but it's also a delight to be in the company of future colleagues. So this is particularly special for me. I'm going to open my remarks about equal protection and talking about it as the cornerstone of modern equality jurisprudence in the United States. The Equal Protection Clause states that no state shall deny to any persons within its jurisdiction the equal protection of the laws. Ratified by the states during Reconstruction in 1868, 14th Amendment encompassed specific intent to abolish Black codes. The Southern states' attempts to negate the 13th Amendment prohibition on slavery by targeting Blacks for unequal treatment in labor, land ownership, and criminal penalties. Just 4 years later, a court fully aware of the doctrine's commitment to African Americans interpreted 14th Amendment's pervading purposes as securing freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freeman and citizen from the oppressions of those who had formerly exercised unlimited dominion over him. Justice Miller, writing for the majority, further noted that the 13th, 14th, and 15th Amendments were all specifically intended to address the grievances of race. Now, I could detail all the ways in which contemporary equal protection jurisprudence has not done all it was intended to do. There are tactical problems. Equal protection has been critiqued as balkanizing groups by appearing to award benefits or protection to particular groups at the expense of others. Identity itself has been critiqued as essentializing individuals, reducing them to only their race or ethnicity. And doctrinally, the identity canon is closed, offering solicitude, however watered down, to race and ethnicity and parentage, to a lesser extent, religion and gender, but to neither class nor, but not to class, or sexual orientation, excuse me. But I want to focus, however, on two problems in particular. The first problem is how equal protection renders minoritized identities as impoverished and problematic. Judicial pronouncements regarding the salience of identity in general, and Black racial identity in particular, are jurispacific, rejecting race as a lens through which legal actors might assess obstacles to achieving substantive societal equality. Key desegregation cases, for example, like Dowell and Freeman v. Pitts, illustrated impatience with any long-term commitments to race-conscious integration remedies. In higher education, the court has consistently refused to acknowledge societal discrimination as a compelling interest, embracing instead the easier to de-race diversity. And in voting rights cases, the court relies on aspirations of colorblindness to ignore reapportionment schemes that dilute Black voting strength, and to suggest in cases like Shelby that absent birding crosses and hoods, pre-clearance requirements encompass unnecessary and troublesome acknowledgement of race and racism that are simply no longer justified. Further, cases like Brown illustrate the court's fixation with impoverished Black identity. Manifest and Dahl tests purporting to suggest that young Black children hated themselves, when the Dahl test suggested only that Black children understood whites' preferred social hierarchy. Similarly, a line of affirmative action cases from Bakke to Grutter to parents involved repeatedly present Black people as guiltily taking benefits they don't merit, and whites as innocent victims in all of it. By staying committed to this binary, white affirmation and Black deficit, we miss not only the curative and protective benefits of minoritized identity in general, and Black racial identity in particular, but we also fail to recognize the political utility of identity, blind to the ways in which recognition of race helps us understand and respond to democratic misrecognition among citizens, alerts us to defects in our democracy, and operates as a crucible of sorts that produce necessary social movements as we continue our push for equality. The second the problem with equal protection I'd like to address is inversion, a problem about which I can spin two different narratives. One inversion narrative is the one with which we're all already familiar. In the absence of an anti-subordination framing for equal protection, courts get equal protection claims exactly backwards. Both benign and invidious racial classifications are subject to the same forms of judicial scrutiny, such that facially neutral laws with disparate impact on minority groups are preserved so long as discriminatory intent cannot be found, while race-conscious government policies with specific intent to ameliorate racial inequality is prohibited, thus eroding protections against racial discrimination in labor and employment, education, criminal justice, and many other spheres of American life. The second inversion narrative is a little less familiar, although no less dangerous. And that's the way in which equal protection is increasingly used by the courts to grant legal solicitude to groups who have not been saddled with disabilities, or subject to a history of purposeful unequal treatment, or been relegated to a position of political powerlessness. Rather, the court is instead granting legal solicitude to people in the majority, when we're thinking about race, often whites, who have been made powerful on account of their race, or as powerful as other factors like class or racial or sexual orientation would allow them. We saw this, for example, in Parents Involved, where the court not only struck down a race-conscious school assignment plan as a violation of equal protection, but suggested that in doing so, it was protecting the white parents who had brought the suit and who had been harmed by their racial classification as white, a classification these parents understood as the reason that they could not enroll in the school of their choice. More recently, we saw it in Masterpiece Cake Shop, which doesn't deal specifically with race, but thinks about this, it features this inversion problem in the context of sexual orientation. There, the court found that the Colorado Civil Rights Commission had failed to review claims regarding the refusal of white, straight Protestant males to serve LGBTQ couples with the proper neutrality, finding that Colorado had exhibited hostility to religion. In Masterpiece, those seeking accommodations on religious grounds had, as Professor Melissa Murray has put it, reframed themselves as dissenters from majoritarian norms. And the court was happy to oblige that reframing, thus weaponizing anti-discrimination law against those whom it was originally meant to protect. And if we broaden our lens even more, even those decisions that seem like equality victories for minoritized groups ultimately work to benefit those in the majority. The diversity rationale that came out of Bakke divorced race-conscious admissions from notions of racial justice, such that predominantly white institutions of higher education can now make superficial attempts at improved racial optics, do little about substantive equity on campus, and still get sued by primarily white interest groups for it, as was the case in the latest Harvard affirmative action litigation. Similarly, in Obergefell, all of the cases understood as a win for LGBTQ rights, the court fails to declare sexual orientation a suspect class, and in so enthusiastically inviting same-sex couples to behave more like, I put that in scare quotes, behave more like opposite-sex couples, the court only reinscribes a social and status hierarchy that places heterosexuals, and white Christian heterosexuals in particular, at the very top. We think about Obergefell as a win, but in fact, I believe it lays the groundwork for more of these inverted equality claims later when white males feel displaced. In a time of increasing material and psychic precarity, both phenomenon, jurisprudential approaches to minoritized identity and the inversion of equal protection to protect the majority is a particular challenge. Materially, under an aggressive and increasingly unregulated form of capitalism, insecurity infiltrates more and more American households. Incomes have stagnated or fallen even as GDP and work productivity have increased. Volatility in household incomes is on the rise. Political and corporate leaders shift responsibility for the risks of work, illness, or old age to employees. And instead of risk sharing, choice is used as a disguise behind which people are really left to self-insure themselves and their families. Psychically, whiteness is increasingly being decentered in social spaces. Noted journalist Thomas Edsall, for example, has named status as a key driver of increasingly intractable societal conflicts and situated increasing identity politics among whites as a resentment that never sleeps in response to the fading hegemonic power among the previously powerful. Ultimately, status threat and accompanying rising anxiety among whites, regardless of financial well-being, drove results in the 2016 presidential election and will continue to shape American politics for some time to come. Moreover, the roots of this problem are embedded in doctrine. Brown, for example, was not framed by the court really as a problem of white supremacy. It was framed instead as a problem of Black inferiority, allowing the court and society to move toward integration without disrupting a social order in which whites are inevitably placed at the top. As equality movements look to more aggressively disrupt our racial hierarchies, those at the top will increasingly feel insecure. Now, the problems of materiality, of economic insecurity, should turn our attention to a more robust set of class politics that might be able to move us forward. Economic precarity is touching more and more people in the majority, revealing for more and more people the benefits of a living wage, universal health care, affordable higher education for us all. But that does not, however, eliminate the problems of status disorientation and the very real sense, regardless of economic insecurity among whites, that they are losing something as we work to bring people of color and Black people in particular more fully into the franchise. And in that environment, not only will we continue to see equal protection challenges that present whites as innocent victims in need of protection, but we will also lose grounds in efforts at racial equality on account of an equal protection jurisprudence that will be, unfortunately, sympathetic to those claims. Now, I don't have much in the way of solutions, and anti-subordination framing for equal protection would address both of the problems I've addressed here today, particularly the latter problem of inversion. But equality scholars have tilled that barren field for generations without success. And for it to take hold, we need a radically different court composition, which is not soon forthcoming. I do believe, however, that my co-panelist, Professor Jerry Spahn, will give us some insight into how to squeeze water from a rock by sneaking in equality law and legal work through the jurisprudential cracks. And so with that, I'll stop, and I'm happy to answer more questions during the Q&A. Thank you.
Thank you so much, Professor James. That was wonderful. I'll now turn it over to Professor Spahn, who will pick up on some of the threads where Professor James left off.
So thank you very much, Professor Wilson. And I'd also like to thank my co-panelists. And I especially want to thank the UNC Center for Civil Rights, all of you, for giving me a chance to just sort of vent for a while about race and the Supreme Court. In fact, I'd also like to thank Mitch McConnell. His recent manipulations of the Senate confirmation process have unapologetically outed the Supreme Court as a political institution. The justices are selected by a process that makes their personal ideologies dispositive, and the Supreme Court's political ideology has historically favored the interests of whites over the interests of non-whites. That's particularly troublesome now in the renewed quest for equality that's followed the deaths of George Floyd, Breonna Taylor, and countless others. The way we proceed can help determine whether we move forward toward the goal of racial justice or backward to a time when our commitment to white superiority was as explicit as it is oppressive. Okay, so there's a lot of racial inequality out there, but our current culture has largely learned to mask overt racial hostility with indirect forms of structural discrimination. And the prevalence of implicit bias shows that much current racial discrimination is unconscious. As a result, neutralizing racially disparate impact offers the most trustworthy way to end ongoing racial discrimination. But the Supreme Court, in its infamous Washington versus Davis decision, rejected a discriminatory effects test for unconstitutional discrimination and held that the Constitution actually protects disparate impact discrimination as long as the intent to privilege whites is not overly conspicuous. The court's decision in Personnel Administrator versus Feeney then adopted such a narrow definition of intentional discrimination that even knowing indifference to racially disparate harm does not satisfy it. The current law is simply not responsive to contemporary forms of racial inequality. Moreover, as Dan Farber has pointed out, the Supreme Court's racial jurisprudence is itself racially discriminatory. The court ignores disparate impact that harms non-whites in discrimination cases like Washington versus Davis, but invalidates disparate impact that harms whites in affirmative action cases like Adirond and Gratz and Parents Involved. The Supreme Court is one-sidedly protecting whites, and reliance on the Washington versus Davis intentional discrimination test has now become the standard way of shielding white privilege from constitutional challenge. The new 6-3 Supreme Court conservative majority seems unlikely to reconsider the rejection of disparate impact as a form of unconstitutional discrimination, but there's a way around the court's recalcitrance. All other things being equal, in a non-discriminatory culture, we would expect the racial distribution of societal resources to mirror the racial makeup of the pertinent population. It would therefore make sense to utilize affirmative action programs to replicate the proportional distribution of resources that our history of discrimination has precluded us from achieving naturally. However, in Regents of the University of California versus Bakke, Justice Powell barred race-conscious remedies for what he termed societal discrimination. And in Grutter versus Bollinger, the Supreme Court reaffirmed its oft-stated view that the pursuit of racial balance through the use of quotas is patently unconstitutional. Those views are consistent with a long history of Supreme Court decisions that sacrificed non-white minority interests in order to benefit the white majority. Cases like Prigg versus Pennsylvania, Dred Scott, Plessy, Korematsu, and even Brown itself. But within the confines of the court's existing equal protection rules, we could still seek to remedy the racially disparate impact of our present resource allocation schemes by relying on chance rather than so-called merit in the allocation of resources. Consider university admissions. Rather than utilize the grade point averages and standardized test scores that we typically view as measures of merit, university admissions could instead be determined by lottery. Statistically, the racial profile of an admitted class would then reflect the racial profile of the applicant pool. Assuming no significant barriers to entry, each racial group would get a share of university seats that roughly approximated its proportion of the population. Lotteries would mimic the resource distribution that would exist in a non-discriminatory culture, and randomization would serve as a statistical safeguard against structural discrimination and implicit bias. Universities could ensure that they were admitting only qualified students by setting minimum standards for participation in the lottery, as long as those standards did not simply replicate the racial disparities of our current admissions criteria. Nevertheless, there would be a cost to lottery admissions. As Justice Thomas recognized in his Grutter opinion, in the absence of demanding admissions standards, prestigious universities would lose selectivity as a tool to establish and perpetuate their elite status. But if we had to choose between a system that allowed fancy schools to retain their elite status and a system that ended the racially disparate impact embedded in our educational hierarchy, choosing to remedy pervasive racial discrimination seems plainly preferable. Notwithstanding the goal of reducing disparate impact and increasing racial balance, lotteries would almost certainly be constitutionally valid. They are facially neutral with no impermissible because of invidious intent to harm whites under Washington versus Davis. Rather, their permissible intent is to improve educational quality under Feeney, in spite of any disparate impact that might have on whites. Even Justice Thomas seems to agree, stating in Grutter that open admissions or abolishing the SAT are valid race-neutral ways to promote diversity, and nothing is more race-neutral than a random lottery. Lottery admissions are a viable alternative to GPAs and test scores. Some European universities already use lotteries. Some US high schools and charter schools have expressly begun using lotteries as a means of reducing the disparate impact of racially correlated measures of merit. Analogous lottery-based selection strategies could also be used to combat racially disparate allocations of other societal benefits, such as jobs, construction contracts, FCC broadcast licenses, and COVID vaccines, all of which have continued to privilege whites disproportionately, despite our existing legal prohibitions on racial discrimination. There's admittedly some controversy surrounding lottery-based resource allocation. Opponents claim that lotteries would improperly discount the importance of merit, but their claim is belied by the deviations from so-called merit that we now happily tolerate. For example, we embrace our current athletic, geographic, legacy, and donor preferences for university admissions. And certainly, enhanced racial justice is as important as those factors in justifying any departure from so-called merit that lotteries might be thought to entail. But rather than departing from the concept of merit, lotteries actually help redefine the concept because diversity of perspective is itself an important component of merit. Do we really want white males with high test scores to be the only ones in the room when we discuss cases like Brown versus Board of Education or Roe versus Wade? Diversity matters. It matters a lot. Merit-based objections to lotteries also reveal that we incorporate factors correlated with whiteness into our baseline definition of what constitutes race neutrality. That's why we're so enamored of racially correlated test scores, despite the racial disparities that they produce. Our culture has internalized as one of its unexamined baseline assumptions the belief that resources are distributed fairly and equitably when whites possess a disproportionately large share of them. The advantage that whites possess over non-whites is simply perceived to be part of the natural order. But that baseline assumption is, of course, just another form of white supremacy, reflecting the tacit belief that non-whites are simply not as good as whites. The history of the nation suggests that we will only be able to achieve racial equality if we force ourselves to do so. We can break out of our racially skewed conception of neutrality if we pre-commit to a strategy that will override our structural discrimination and implicit biases. and lottery-based resource allocation offers a self-enforcing mechanical way to commit ourselves to a degree of racial justice that we will not be able to obtain if left to our own devices or to the devices of the Supreme Court. Ironically, mere random chance can do a better job of forcing us to value racial justice than the unsuccessful measures we have tried thus far. But I fear that we will continue to resist this strategy because I fear that we will continue to favor the familiar benefits of white privilege over the loftier ideal of racial equality. Thank you. I am done now.
Okay, thank you very much, Professor Spahn. That's very provocative, and I look forward to discussing it more in our question and answer session. So we'll close it out, last but certainly not least, with Professor Bakke, who will give us her take as well.
So first of all, I want to add my thanks as well as my congratulations to the UNC Civil Rights Center and all the terrific people who have organized this conference. I'm delighted and honored to be here, and I welcome the conversation at the end of this panel. So what I wanted to do was to spend my 8 to 10 minutes on Justice Powell's opinion in Bakke, which entrenches white innocence and resentment as a constitutional concern in equal protection and is responsible for many of the doctrinal turns that you have heard Professor James and Professor Spahn mention already. And here I want to give a special shout out to my friend and mentor, Professor Ted Shaw, who I know is going to discuss the Bakke opinion after this panel. And Professor Shaw, shall we say, learned me up on Bakke at a very early age when I was a baby lawyer. So I want to acknowledge him as well. So you all may remember that Bakke was a case about affirmative action in admissions at UC Davis Medical School. Justice Powell joined with 4 justices to strike down the use of quotas in UC Davis's admissions program under Title VI. But he also critically writes a constitutional opinion that poisons the well of equal protection, the ramifications of which you've already heard a bit about. In this opinion, which he writes only for himself, argues that all racial classifications, even those that are designed to serve racially inclusive goals, are presumptively unconstitutional. And it's important to focus on what that means, right? It means that he's placing affirmative action, race-conscious affirmative action, on the same constitutional plane as Jim Crow laws that were designed to segregate and subordinate Black people and other non-white people. What's important here is that he rationalizes his argument by invoking white innocence and the specter of white resentment toward any uses of race that seek to remedy generations of racial subordination. And I want to read for you the language that he uses, which is from footnote 34 in Bakke, because I think it's important to hear Powell's own words as he comes to this conclusion. He says, all state-imposed classifications that rearrange burdens and benefits on the basis of race are likely to be viewed with deep resentment by the individual's burdens. The denial to innocent persons of equal rights and opportunities may outrage those so deprived, and therefore may be perceived as invidious. And he goes on to say that these individuals are likely to find little comfort in the notion that the deprivation they are asked to endure is merely the price of membership in the dominant majority, and that its imposition is inspired by the supposedly benign purpose of aiding others. And he concludes by saying one should not lightly dismiss the inherent unfairness the inherent unfairness of, and the perception of mistreatment that accompanies a system of allocating benefits and privileges on the basis of skin color and origin. Now, there is a lot that one can say about this, but let's start by noting that it says nothing about historical context. It erases historical context from his proposed constitutional calculus. He says nothing about enslavement and segregation and ongoing racial discrimination, the deeply rooted intergenerational harms that created the need for affirmative action in the first place. And when we read this language of innocence, we know that he is referring to white people. And we have to ask ourselves, if white people are innocent, then what is he saying about Black and brown people and Asian people and Native Americans? And you can hear from some of what Professors Span and Professor James have already said about the ways in which Black and brown people are minoritized and devalued, right? The contributions are overlooked. The potential is overlooked and degraded. Right? And we see these ideas surface in Justice Powell's opinion in footnote 34. And what he seems to be saying is that the presence of non-white people in institutions of higher education as a result of affirmative action is not legitimate, and that white people are undeserving of those opportunities. And at the same time, the presumption of innocence that is conferred on white people who are somehow denied access to institutions of higher education means that they should have almost a right to attend certain institutions of higher education, and affirmative action is denying them that right. And what we have seen in so many affirmative action cases are white plaintiffs who challenge the consideration of race in admissions, even though they would not have been admitted to the university without that affirmative action program in the first place. Justice Goodwin Liu, before he was a justice, wrote about this in the Bakke case. We've seen that in other cases, like the University of Georgia case, like a case out of Rutgers, actually, where a white plaintiff alleged that he had been denied admission, unjustly denied admission to the university, even though he would have been denied, even without any consideration of race. And so race here occupies an enormous amount of the terrain of white resentment and white frustration at any indication that people of color are somehow benefiting from race-conscious policies. Even though he writes for himself, Powell's opinion has far-reaching consequences. It helps to create a constitutional framework that prioritizes malice and guilt as the benchmarks for judging equal protection claims. And these benchmarks are embraced later by the court in Feeney and Croson and Adirond and parents involved in some of the other many cases that you've heard already today. These benchmarks also set the procedural and substantive rules of equal protection. That is, it applies strict scrutiny to any claim that involves considerations of race. By rejecting the use of race to remedy pervasive racial inequality, what Powell referred to as societal discrimination, that is also illegitimate under Powell's framing of the issue. And also limiting remedial uses of race to identify discrimination, specific instances of discrimination that have to be proven by evidence of bad racial intent. And the reason for all of this, Powell suggests in his Bakke opinion, is that we have to protect white innocence. That part of our constitutional duty under the 14th Amendment, the very provision that was ratified to make real the promises of freedom and democracy and opportunity for Black people emerging from slavery, is to guard against white resentment. That is likely to result from government policies that rely on racial classifications to improve opportunities for people of color at the perceived expense of white people. So Powell crudely and cruelly, I'll add, twists and perverts the meaning and spirit of equal protection. There's been some conversation already about Washington versus Davis and Arlington Heights and a mention of Feeney. I'll just stop here by noting that this perversion is fully realized in Feeney, in which the court explicitly embraces the malice test, which begins to shift equal protection away from what Ian Haney Lopez has referred to as the contextual intent standard that it had embraced in Davis and Arlington Heights. So embracing this rationale, the Supreme Court has concluded that individualized considerations of race by state actors are presumptively disfavored and under most circumstances completely prohibited, even for purposes of remedying pervasive racial inequality. And one last point. So I've talked about what I'll refer to now as the equivalence principle, which is that strict scrutiny applies to beneficial considerations of race that are intended to benefit people of color who have long been excluded from the fabric of American society, as well as to intentionally discriminatory uses of race. The origin of this principle, as I've described, is grounded in a fear of white resentment and outrage, that beneficial considerations of race are harmful to white people. And it reflects a perverse race-conscious colorblindness in equal protection, right? That is, equal protection is guided by principles that limit considerations of race in order to protect white people. And I will stop there. Thank you for your attention.
All right. Well, thank you all so much. A lot for us to chew on in terms of what you've all told us. So one of the common themes that seems to go throughout all of your remarks is this idea of white supremacy, and that our equal protection doctrine operates against the context of white supremacy, and that some of the rules that come out of the doctrine are related to protecting, as Professor Bakke alluded to, notions of white innocent and potentially the backlash against white resentment. So I want to start our conversation by asking a question for actually Professor Bakke. So you note that in the Bakke decision that Powell was against using race as a basis for eliminating societal discrimination. And I think many of us can maybe agree, or most of us can agree, that societal discrimination probably does deserve some forms of race-conscious redress. But question is, what should the limits of any permissible government action be if we were to allow societal redress through race-conscious admissions, since frankly, the role of the government in perpetuating racial subordination runs so deep and is so deeply ensconced. Is there a way really to use the doctrine to appropriately address societal discrimination in a way that would have manageable limits?
Sure, thank you for the question. And just a quick note. So when we talk about the pervasiveness of racial inequality, because race is everywhere and it affects everything, I'm reminded of, I think it was it Justice Brennan's opinion in McCluskey, where he said we have a fear of too much justice, right? We have a fear of too much justice, right? That's the first problem. But I think we had doctrinal tools for addressing this, right? It was Washington versus Davis that decimated, for the most part, disparate impact doctrine, at least as a sole basis for finding intent. The intent standard, as it was perverted in later years under the Berger court. I mean, and the foreseeability doctrine that came, that was decimated by the Feeney decision. Disparate impact was a workable doctrine. The foreseeability test that had been adopted to help identify disparate impact was also quite workable, especially in the context of school desegregation cases. There were many courts that were working with those standards to try to work through the effects of rampant discrimination. So I think that we had tools, but the court has rejected them.
Okay, thank you. And so I think that leads nicely into a question for Professor Span, who very provocatively suggests a different path that we could take in terms of his idea about lotteries for college admissions as a way to better distribute access to elite universities. But I guess a motivation question there for you is, what would induce elite universities to take such a step in the absence of massive and highly resisted coercion?
So I have an answer. I hope you're just not going to laugh at me. Because it's the right thing to do. When you look around, as Professor Bakke just emphasized, when you look around at how pervasive discrimination is, and as Professor James has emphasized, when you decide that all the victims seem to be the white people whenever we try to remedy that, it's pretty clear that something is out of whack. And I have to give it to universities so far, at least sort of standard Northeastern universities. They seem to have identified this as an issue that they want to address, causing me to think, yeah, they like racial diversity, and I'm giving them a strategy for racial diversity. They have promulgated these affirmative action programs that have been challenged by sort of white so-called victims and often invalidated by courts. Well, here's a way to do it that won't be invalidated by courts. So why don't you just do it because it's the right thing? If that's unlikely to work, I have a fallback argument, because we're going to withhold your funds under Title VI if you don't, because it constitutes racial discrimination if you just acquiesce in the existing disparate impact. Now, I understand I don't have the votes to do that on the Supreme Court, but that's a problem with the Supreme Court. That's not a problem with the theory.
Okay, so I think that feeds nicely into actually Professor James' point about precarity. And Professor James, you've written in previous scholarships that perceptions of diminished social status relative to minoritized or lowest status group often prompts attempts by the privileged to reinstate their superordinate status. So in some ways, playing off of Professor Span's idea about the lotteries, do you think or hope that this increasing social precarity of the present time might actually induce whites to adopt proposals to do the right thing, as Professor Span said, that would be fair and more equitable for all groups, including non-whites?
So I think that the impulse of people to get on top and try to stay on top, and that's not always sort of a I need to hoard, even though I do think people give into an impulse to hoard. Sometimes it's sort of things, the word you use is precarity, things are unstable and I need to find a way to create some sort of stability, and climbing over people to get as high up as I can. And that's going to create some floor below which I won't fall. And I think those are impulses, we could call them right or wrong, natural or constructed, but they are impulses. And I think a big problem with our legal system, our democratic system, is the way in which politicians have capitalized on that impulse, right? And really encourage people to continue moving in that direction, or affirm their sense that it's the right thing to do, right? And when I think about the integration cases in the early 1990s, the court was essentially telling white people, yes, please do run, and we will protect your running. That is the right thing to do. And so I am encouraged by the work of Ian Haney Lopez and others, who looks into how messaging by politicians will push people in one direction or the other. Right, when he was thinking about why Trump was even able to make some gains among people of color, the idea that a lot of people can be uncomfortable with a race narrative and might pull away from, let's say, a Democratic Party because these messages about racial equality are unsettling for them, right? And the alternative is giving them a message that they like. Or they feel like, well, we don't have to deal with that because we don't like the use of race. And he was suggesting that if you can flip your use of race to tell people, it's being used to divide us, and you can help people understand that, right? People are using race so that none of us have healthcare. People are using race so that none of us are getting access to good schools. People are using race so that none of us have any job security, right? If we could push back and band together, we could sort of create some stability for ourselves, right? If you can effectively deploy that messaging, you might be able to make some progressive gains, right? And so I don't want to say it's not possible. And I do think that if politicians and policymakers are thoughtful about the precarity that people are experiencing and think thoughtfully about how they use their narratives around race in the midst of that, right, you can get people to behave differently. That being said, I don't want to be naive about the real sense of disorientation and instability that people who have enjoyed being at the top and don't even realize that they're at the top, right, have when things start to look different. The sense that they are losing something if other people get more. And those themes, those ideas are aspects that can be very deeply embedded parts of American culture. And so I do think even if you can get sort of coalitions that band together to try to create stability for everyone and sort of understand how race is being used in that narrative and how it could be used productively, I still think you have to confront people who believe that the natural order of things is for some people to be at the top, that is justified, that that's legitimate, that other people are on the margins or at the bottom because they deserve to be there. And that a change is not just a reordering of the hierarchy, but a loss of culture, right? A flipping of history. And a distortion of what the proper state of affairs is. And that has to be confronted no matter what. And I don't think, if people talk exclusively about sort of class politics, I don't think you get, I don't think class politics gets you all the way there. I think you do have to confront the norms of white supremacy that are in fact deeply embedded in our society.
So that's also a great segue. If we think about the law as structuring societal norms and the way that we behave, right? To Professor James's point about disrupting notions of precarity and trying to coalition build around the idea that this is hurting all of us and a more equitable distribution would help all of us. Back to Professor Span, one potential counter argument to your proposal regarding lotteries is that, right, it would eliminate the cachet of elite universities. Unfortunately, we're not there yet where the names don't matter and that cachet is still important. And arguably, right, it might water down their significance at the exact same time universities are becoming more diverse and more people of color are getting access to them. How do you respond to that counter argument, Professor Span?
Okay, so I think that's a good and an important point. And don't get me wrong, the last thing on earth I want to do is upset voluntary efforts by universities to increase their diversity. But as I suggested earlier, I think universities ought to be in favor of lottery random-based admissions because it'll do a better job of doing what they're trying to do now. With respect to the threat to the elite status of Harvard and Yale, I have two answers. First of all, I don't think they're going to lose their elite status because a lot of reasons. They're Harvard and they're Yale. They've been around for a long time. This is tradition surrounding them. They have enormous endowments. They have fancy faculty that publish fancy things in fancy places, and the newspapers call them up when they need quotes. So I think the threat to elite status is marginal. But my real answer, my fallback answer, actually reflected in one of the questions that I think was posed in the Q&A is what would be wrong with just homogenizing universities? Why do we have to have this hierarchy? The thing that matters is that we give people university educations when we think it will help them. If all the schools are the same stature, that strikes me as progress, not a problem.
Okay. I should also add for our audience members, if you have questions, please do put them in the Q&A and we'll get to them in the latter 10-15 minutes of our discussion. So I want to shift gears here now, and this is a question for everyone, but perhaps we can start with Professor Bakke because I know you've written about this. As I alluded to in my opening remarks, right, we know that the way discrimination manifests itself in modern times is complex, nuanced, and not easily captured by the current equal protection doctrine, particularly with its rigid intent requirements. How might the doctrine evolve to capture the nature of discrimination today, particularly what we call implicit bias?
Well, I think that I think there are ways to I think there's a good argument that there are ways to capture implicit bias through existing intent doctrine. And if that were to happen, I think that's a good thing. I'm not sure how much work implicit bias or a recognition of implicit bias in the doctrine would do to dismantle these very deeply rooted structural inequalities that we face today. And maybe that's just me being pessimistic in this moment. But I'm not sure that implicit bias will do it. I think that we need a system of laws and policies that are connected in very adaptive ways to address issues of racial inequality, that we need some flexibility, not only in the way that our doctrine is interpreted, but the way in which our doctrines are deployed to be, to sort of, to adapt as the systems adapt. And we have not been able to accomplish that, in part because I think we've relied too much on sort of juriscentric legal paradigms rather than looking to, I guess federal law is a possibility, but also even state and local laws that could adapt more quickly to local and state inequality.
I know, Professor Span, you've also talked about the role that disparate impact analysis might play. Any thoughts on the way that disparate impact analysis might be deployed to deal with modern forms of discrimination, particularly implicit bias?
Yeah, so one of the reasons I'm in favor of a disparate impact understanding of the equality concept and equal protection clause is precisely because there's so much structural discrimination and so much implicit bias floating around out there. Washington versus Davis just is not addressed to that problem. We're not going to pick it up. Because it's unconscious, because of a lot of our discrimination is unconscious, the only way we're going to be able to pick it up is through sort of statistical measures, like for Justice Thomas, it would be open admissions and getting rid of the SAT. For me, it would be using lotteries. But that's the whole point. Just disparate impact, I think, is the thing that matters. If you're not willing to go along with me on that, at least it seems to me you ought to go as far as Professor Bakke wants to and either abandon or reformulate Feeney, or go as far as Professor James wants to and stop treating whites as if they were the victims of the racial problem. So there is this 6-3 Supreme Court majority that's unlikely to do what I'm suggesting, or unlikely even to put their head in this space. But I think it's important for the rest of us to understand that all of the grievances that have been articulated so far, the reason we need Washington versus Davis as opposed to disparate impact, those are all rooted in a notion of preserving white privilege. They start with the assumption that under the current state of affairs, things are equal, and if we change the current state of affairs, then whites will be harmed. And that's just the wrong way to look at it. So my answer is disparate impact is what we ought to do.
Okay, fair enough. And so I'll ask Professor James to follow up on that because you actually in your comments said something that really resonated with me in terms of the way that equal protection doctrine has looked at Black, or framed things through a Black deficit lens, right? And you also alluded to the possibility of reframing the doctrine in a way that focuses on anti-subordination instead of anti-discrimination or anti-differentiation. So can you talk a little bit about what an anti-subordination framing of the equal protection jurisprudence would look like?
Sure, right. So an anti-subordination or maybe even a redistributive justice version of this would place an affirmative obligation on the state to address disparities, right, in the way resources are distributed, and act without any sort of reference to intent, right? And so we could look at any number of areas in American society, housing, education, healthcare, and think, are there disparities here? And without suit, without trying to sort of ground it in intent doctrine, we have an obligation to address these disparities. And we might even frame it as, to the extent that these disparities reflect historical patterns of discrimination. The issue is, I can think of very few places or very few areas in which it's not rooted in some sort of history. And so that question is less of a problem with me, although you do get to the too much justice problem. If you're afraid of too much justice, yes, there's going to be a lot of places in which we might have an affirmative obligation to act. And so I think that's one piece of it. I think the other piece of it is how the court has thought about identity, sort of a distancing from it, because we think about identity as linked to minoritized identities, and so it must be bad, right? You're only talking about this because those people are clinging on to this thing that's not useful. Not only will white people resent it as if they don't have identities, which is not the case, but why would you want to be associated with that? And so there's a distancing of it, which I think creates all sorts of problems. It affirms what I see as misrecognition. Melissa Harris-Perry has talked a lot about this, misrecognition in society. When people get confining, demeaning, contemptible images of groups, it distorts those groups, right? It distorts their experiences, and it distorts their experience in a democracy. It undercuts their notions of citizenship. And there's a link between that distortion and your attempts to even redistribute, right? You cannot effectively redistribute cultural value or material resources if you don't properly recognize citizens. Right? It's a reason why the surest way to tank policy is to racialize it, right? Housing subsidies would be great for everyone, unless we think housing subsidies go to Black people, and then we don't like it, even if it means elderly white people are not going to get the subsidies that they need. And so that misrecognition undermines our attempts to move forward under any sort of politics, whether it's sort of a class politics or race, ethnicity, or identity-based politics. And so I think an anti-subordination framing would help us get at a lot of that, but also would respond to the tendency of the court to think about identity as this terrible thing, as opposed to a factor that we have to respond to, think about how it orders our society, and also think about how we might use patterns related to identity to understand, to diagnose what problems are in our democracy so we can address them and move forward.
That's a nice segue to ask you all about affirmative action. Professor James mentions affirmative obligations to act. And so one of the few arguably anti-subordination-like frameworks we have is affirmative action. And so I have a general question here and then a more specific question here. So the First Circuit recently issued an opinion upholding the constitutionality of Harvard's affirmative action plan, specifically as it relates to the claim that the Harvard's admission plan discriminated against Asian Americans. And so that case, or potentially the case involving UNC even, may very well make its way up to the Supreme Court. So I'm interested generally in the panel's thoughts on how the court might turn the Supreme Court could go if one of these cases makes it up to the Supreme Court in terms of the interpretation of the equal protection doctrine there. The more specific question I have is that given what we know is a more specific, a more conservative makeup of the court, I think it's fair to say that we might expect them to continue as they've been doing to privilege things like right to free exercise of religion and religious identity. Professor James mentioned the ways in which racialized identity has been cast negatively, but arguably the court hasn't taken the same tack when it comes to religious identity. Does it strike you as inconsistent, the idea that a more conservative court might interpret the Constitution in ways that privileges religious identity, but then turn around and curtail the ability of universities to consider racial identity, particularly where applicants have self-identified as belonging to a group which the university might find value in having more people from that group on campus. So maybe put more succinctly, how can we reconcile the disconnect between the court's treatment of racial identity versus religious identity?
I can jump in here. So first of all, I do think there is an inconsistency, and if you look at the free exercise cases that have come out of the court that do heavily emphasize, and even Establishment Clause cases that have come out of the court that heavily emphasize the importance of religious identity, and I agree with you that that is in stark contrast to the way that the court has treated race. I don't think there's any way to shame this court, quite honestly. So they may be happily willing to live with that incongruity. And, I will say that I think one thing that strikes me, and it may or may not be persuasive to 5 justices on the Supreme Court, but I think it might have an intuitive appeal in public discourse, which is the idea that an important aspect of one's identity, whether it be race or religion or some other facet of one's personhood, should not be sort of equally valued in the constitutional calculus. I think that there is something sort of intuitive about that, right? You'll consider, in the context of diversity, you'll consider religion, you'll consider sex and gender, you'll consider religious principles. You'll consider where they grew up, where a person grew up, and whether they play the piano, but you cannot consider race. And it just especially now, given the moment that we're in with Black Lives Matter, and and parenthetically, I do think that there is a way in which Black Lives Matter may be reshaping public discourse, certainly, and maybe even legal discourse in other realms, if not the Constitution. So I just think there's something counterintuitive if you lay out all the different ways in which people are identified, the way that they express themselves, and then to take race off the table, I think would seem odd to many people, especially in this moment. I don't. Well, I'll stop there and let everyone else talk.
I have two thoughts in response to that question that I want to explore. The first is the idea, I think, when we're talking about religious identity, I think the court is really thinking about white Christian religious identity. And in that way, it's understood as sort of the baseline, as good as the normal, the natural order of things, such that when white Christian males in particular come forward and say, I can't exercise my right to this thing that we all know consciously or subconsciously is the natural state of things, the court feels justified in being like, well, we have to protect what's natural and right and good. And we contrast that to the court's exhaustion about race in general, right? In Shelby Roberts' remarks that, look, no one's he didn't say this, but it was essentially no one's burning crosses. And so we don't really need this anymore, right? And it's a dissent that gives you a sense of the second generation voter disenfranchisement that's happening and the way in which it's still creating disparities. But Roberts is like, we just don't live in that world. They're done with it, but are sort of attuned to the ways in which the natural order of the world, the natural order of the United States as expressed through white Christian identity is being disrupted. And so there's an impulse to protect it, but it is, it doesn't make sense, right? It's not coherent in that way, unless you take a step back and think about how these things are culturally understood by the court and by society in general. In terms of the affirmative action litigation, I am not optimistic about it. And I do think that we have to be careful, or we have to watch the way in which the court is going to use Asian penalty in the admissions process as a cover for dismantling affirmative action. And I think that question around how Asians are treated in the pool is a complicated one. I think it's something that we have to pay attention to, right? To the extent that we do think that Asians are being penalized for that, more whites can be admitted. Like, we have to think about that. And we've been through several rounds of this. And, in some Asian communities, opposition to these more race conscious initiatives. We've seen that at the K-12 level with the elite schools in New York City. We saw that in pushing back to attempts to reinstate race conscious affirmative action on West Coast California schools. And so I don't want to sort of put that aside. I think those are real concerns, and there are serious dynamics that we have to think about that question, again, sort of that push back at a black-white binary in terms of how we understand race, to forces us to think hard about coalition building, and forces us to think with more granularity about the different experiences of the large group we call Asian in the United States, right? Which have actually very different histories and experiences, and looks different in some communities than it does in others. At the same time, right, this is, for me, classic triangulation of Asians, right? They are valorized as better minorities than Blacks and Hispanics, and so they deserve overrepresentation in these places, but they are also understood as unassimilable, right? So you don't actually read them politically. And so in the elite K-12 high schools in New York, they weren't consulted in any of the planning to eliminate the standardized testing and instead do sort of top 20% admissions across the city, right? Because they're not actually American. As Asians, they don't figure for us politically. And so we just don't consult with them with the plan that's going to decimate Asian enrollment in those schools. But we defend the existing plan by saying, well, look how hard these Asians worked. If Blacks and Latinos would just work as hard, they too could get access to the Stuyvesants of the world. And that dynamic, I think the court is going to use it in a way that justifies undercutting, dismantling, continuing to sort of chip away at affirmative action or the diversity rationale, maybe just getting rid of it altogether. And at the end of the day, that doesn't serve anyone but white people, doesn't even serve Asians, who the court will suggest it's protecting by taking that action.
Can I just respond very briefly? I believe I agree with what Professor James has said. I think one thing to think about with respect to the current composition of the court, it seems that the Chief Justice is no longer, quote unquote, in control of the court. I would have said before Amy Coney Barrett was confirmed and he was still retaining a slim majority, that what sort of Roberts would have done in the context of affirmative action is what he has always done, which is to sort of adopt a new standard for evaluating the constitutional question in the case before him, with the long range goal of eventually overturning it under the new standard. And so I don't know, I mean, now he seems, I think it's right that Roberts is an institutionalist and does care about public perception of the court. But it doesn't seem like he's the one who's driving the ship, the truck, whatever it might be. I think he's out of it. So it'll be interesting and possibly heart-wrenching to see what happens in the case.
Mr. Wilson, I think both of your questions are good and important. With respect to your general question about affirmative action, I share the views of my co-panelists that the Supreme Court, the current Supreme Court, is unlikely to look favorably upon affirmative action cases, including the Harvard case, if it gets there. The reason for that, as I've written elsewhere, is I think the Supreme Court understands that one of its social functions is to protect white privilege. So if it looks like white privilege is going to be eroded, it will step in to do its societal job. Having said that, I have two minor reservations. So that's, I want to be clear about that. That's my ultimate conclusion. I think the Supreme Court is not going to be at all friendly to affirmative action going forward. If the Harvard case is the one that gets there, there is something about Harvard. I mean, this is Justice Powell in Bakke, right? There's, the Harvard exception to constitutional law. And if this is the Harvard case, maybe they'll uphold it because it's Harvard. And if you think about it for a second, if they're going to be a really conservative court, occasionally they have to let the bad guys, that's us, the people that favor affirmative action, occasionally they're going to have to let the bad guys win. And a Harvard case might be the time that you do it. So, in Grutter, they uphold the Michigan Law School plan, but they invalidate the university plan in Gratz. So every now and then they'll uphold one. The other thing I want to say, and I'm not sure if I actually agree with what I'm about to say, but I think it's important enough to put on the table. I think the Supreme Court thinks its job is to protect white privilege. the strongest argument against the constitutionality of the Harvard Affirmative Action Plan is that it constitutes invidious discrimination against Asian Americans. I don't agree with that, but I understand the argument. And so what I'm thinking is, yeah, but those are Asians. Those are not white people. Those are the people that we put in concentration camps in Korematsu in World War II. Those are the people that we now blame for the Kung flu virus. This court might be willing to sacrifice the interests of Asians, meaning it might actually uphold a Harvard Affirmative Action Plan. I'm not predicting that. It just strikes me something we might want to pay attention to. With respect to your question about sort of affirmative action and religion, again, like my co-panelists, I think that the two instincts are completely irreconcilable. The court just seems to have a stronger preference for protecting religious liberty than it does for protecting racial liberty. But so this strikes me as interesting. I mean, I'm going to sound like a law professor, but it does sort of pose the question of how the Supreme Court would react to a claim that someone's religion required affirmative action in order to avoid complicity with structural racism. Now, we already know the court has honored the claim of someone's religious beliefs requiring an exemption from the contraceptive mandate in order to avoid complicity with birth control. And it also looks like the court has honored the claim that someone's religion requires an exemption from general anti-discrimination laws in order to avoid making a wedding cake that might show complicity with same-sex marriage. So why don't we can do it right now. We will just all adhere to this new religion that is so opposed to racial injustice that we think we have to adopt effective affirmative action plans in order to avoid complicity with structural discrimination. If we all sign on, I think the court, under these religion precedents, has to uphold our affirmative action. All right, I'm done.
I think that goes back to Professor James's point about about sort of the free exercise and Establishment Clause jurisprudence privileging the Christian religion, you have to show that that the religion is actually a mainstream religion. So,
well, I wasn't claiming this was going to be a winning argument. It's an argument we'd be able to condemn the Supreme Court for rejecting.
I'm with you.
Let me say one other thing. If it turns out that the court is unwilling to buy the claim that my anti-discrimination religion is not a real religious claim, but it's just sort of some moral claim, but it accepts the religious claim and not the moral claim, which the court seems perfectly prepared to do, that does strike me as an establishment of religion. That's exactly what the Establishment Clause is designed to prevent. And the court seems to just be sort of running roughshod over that part of the Establishment Clause. Okay, so now I'm really done.
Okay. So we have about 5 minutes left, and so I'm going to take questions from the Q&A. I will try and synthesize some of them. So a few people have asked Professor Span about your lottery suggestion, your lottery proposal, and the potential for it upsetting the education hierarchy. I'll add a more nuanced question to it, which is this. You referenced the idea that lotteries have been used, for example, with public charter schools. But one of the things that we've seen with those lotteries is that social capital dictates who's even in the lottery, right? That the way that the lotteries in some ways reified the existing social orders and social privileges by using techniques that afford folks with more social capital the ability to know about the lottery and participate in a lottery. So the question for you is it possible, or do you have any concern that your proposed lottery system could in fact reify some of the same kinds of racial disparities that you are trying to address due to the dissonance between social capital and race?
Yeah, I'm really, really concerned about it. First of all, just so everybody knows where I stand, if it turns out that the lottery just equalizes university status, I can live with that. So I don't view that as a problem. I do view, however, as a serious problem, the danger that when universities try to specify who is eligible for the lottery, they will apply criteria that just replicates sort of the current hierarchy in admissions. And because I'm just a thoroughgoing legal realist, I don't think there's any linguistic way that we can prevent that from happening. We can't come up with a standard that will prevent that from happening. But I'm hoping that if schools actually want diversity, and at least elite schools seem to really want diversity, they will want to do this. They will want to make it work. They won't want to submarine it. If I'm wrong about that, then this won't work.
Okay. So I'll leave you all with one more question for the entire panel. In the brief 2 minutes we have left, closing words for everyone. And the question is, we're obviously in the middle of a challenging and potentially transforming period for our country. The recent insurrection by white supremacists, the fallout from COVID-19, to name a few things, may fundamentally change the way our society, our country looks. Is there a path forward through which we may be able to revitalize the equal protection doctrine to institutionalize more racially equitable practices? Big question, I know, for the last 2 minutes we have left.
I like that question, and I'm optimistic that the social changes that we're seeing now that have been wrought by the pandemic, and I think off the top of my head, right, we've got stimulus payments to people who are unemployed. We have the College Board limiting the use of SATs. We've got people embracing healthcare for all, where they, were previously reluctant to do so. And I think that's so often so often is maybe an overstatement, but the court doesn't like to get too far ahead of where society is. And so one possible outcome of this very tragic time is that if the court sees how sort of the public, people around the country are embracing a new social order, a fair and more just social order, then maybe it would be less inclined to strike down laws that are intended to achieve the same result, provided they're done through race neutral means. So I think so I'm optimistic about that. And I think also we can't overstate the significance of the Black Lives Matter movement. We've, people who are putting up Black Lives Matter on their, in front of their houses and carrying signs about Black Lives Matter. So when we think about sort of the court's reluctance to even acknowledge that race matters, there's a possibility that when I have my more optimistic hat on, that this discourse could maybe push some of the justices in that direction. But ask me in 5 minutes and I may say something totally different.
Sorry, so we're at time now, and I want to respect the panel of the symposium and let us get on board. So thank you all so much for your wonderful contributions, and that's a positive note for us to end on.
Thank you so very much to Professor Wilson, Professor Bakke, Professor Spahn, and Professor James. Thank you for walking us through the Equal Protection Clause and its manipulation over the past few decades since the 1970s. To our attendees, we will transition very shortly in the next 4 minutes to our afternoon address from Professor Ted Shaw. Please don't touch that dial. Good afternoon, and welcome back after our short break. It is my honor and privilege now to introduce our speaker for the afternoon session. Professor Bakke called him a mentor, and I have to lay the same claim as well. I too have learned a great deal and continue to learn a great deal from Professor Shaw. In 1982, he joined the staff of the NAACP Legal Defense Fund. He worked for over 26 years, including litigating cases related to elementary, secondary, and higher education, housing, voting rights, and capital punishment. He also directed LDF's education docket. In 1987, under the direction of LDF's third director counsel, our own Julius Chambers, Professor Shaw established LDF's Western Regional Office in Los Angeles. In 1993, he returned to LDF, and in 2004, he became its fifth director counsel. Professor Shaw is now the Julius L. Chambers Distinguished Professor of Law at UNC School of Law, and he is the director of the UNC Center for Civil Rights. He will now give us some insight into one of the collateral and cruel consequences of Bakke, the disappearance of Black voices in affirmative action and diversity litigation. Professor Shaw.
I was, can you hear me?
Yes.
Okay, there you go. I was, first of all, let me say thank you to everyone who is working on putting on this symposium. For all of you who are here once again, I'll mention how ironic it is perhaps that we're in COVID time, but it's a silver lining, because I think we probably wouldn't all be here. I know we wouldn't all be here today. So it's wonderful to have this time together. I want to start by saying what I've said many times over the years, which is that I was at the Supreme Court on June 28th, 1978, when Bakke was decided. And I remember leaving the Supreme Court that day devastated by the opinion that I had heard announced, or the opinions, as everybody knows. And I was devastated because for Black people, when Bakke was decided, Bakke was a loss. There's no question that it was a loss because it did a number of things that we've lived with now for many years. I ironically have worked for decades now to defend and preserve Bakke, and I'd do it all over again. But I recognize that Bakke was a mixed bag. It was a loss for a number of reasons. I just want to quickly outline some of them. It was a loss because it portended a fatal wound to conscious efforts to open the doors of higher educational opportunity as one of the ways of remedying and addressing the history and legacy of racially discriminatory exclusion and subordination of African Americans, Latinos, Native Americans, and other people of color. It was a loss for African Americans because, one, the court claimed, ironically, only 2 years after it decided Washington versus Davis, in which it required plaintiffs in civil rights cases to prove discriminatory intent. So you had to get into the minds of the actors in order to win. But somehow in what followed, the court found itself unable to distinguish, or refusing to distinguish, between invidious discrimination rooted on the one hand in the belief in racial inferiority, antipathy, and subordination, and refused to distinguish it from race consciousness for purposes of engaging in actions intended to include individuals who have been subjected to racial discrimination and exclusion from equal opportunity. As a consequence of that failure to distinguish invidious from benign intent, the court applied the same standard of review, strict scrutiny, to all race-conscious measures. The court refused in Bakke to acknowledge the original intent, if you will, of the 39th Congress to the extent it could be discerned. But as Professor Eric Schnapper, who was with us earlier today, wrote many years ago in a law review article that followed his role in drafting the NAACP Legal Defense Fund brief, amicus brief that was filed in Bakke. The 39th Congress engaged in all kinds of actions that were clearly race conscious. And so it could not have, across the board and definitively, been of the view that race conscious actions were per se a violation of the 14th Amendment in all circumstances. And the court refused in the Bakke case that those benign / invidious discrimination terminologies really had any significance. The category of societal discrimination that we've heard talk about today was enunciated in Justice Powell's opinion in Bakke. I've said over the years that societal discrimination, in quotes, is discrimination for which no one is responsible and for which there is no remedy. And so the court has wrung its hands over it and washed its hands of it. And subsequently began to push more and more discrimination into the category of, quote, societal discrimination. And so it cannot be remedied. The court effectively in Bakke killed the remedial rationale and was designed and implemented to cure the impact of slavery to Jim Crow discrimination. And the court embraced a false equivalency between racism and race consciousness. And the part of Powell's opinion that was joined by 4 other conservatives pushed back on Black voices and individuals with respect to their role in race litigation, particularly litigation that went to and was decided by the Supreme Court. As I said, ironically, I've spent a good deal of time over the last 42 years working to preserve Justice Powell's opinion. In spite of everything that I just said about it, allowing colleges and universities to consider race on a limited basis in admissions. Now, why do that? If I say that it was all those things, race conscious measures can stand on 2 legs now, theoretically. Can stand on the remedial leg, that is the notion of remedying our history of discrimination, or much of that now would be societal discrimination, but remedying then specific acts of discrimination. Or race conscious measures can be taken sometime in pursuit of diversity. And so the diversity rationale has been the rationale that's kept the doors open to higher education for many African Americans and Latinos, people of color. It's been the diversity rationale. And so it's important, I think, to be conscious of where we are right now in 2021 with cases working their way toward the Supreme Court that may once again present the question of whether or not it's legal and constitutional for institutions of higher education to engage in race-conscious measures to keep the doors to selective institutions open. Let me acknowledge that at times, some of the institutions of higher education, or IHEs, as some people call them, we've had to go to them to urge those institutions to toe the line and not only to stay within legal constraints, but to avoid intentionally or otherwise painting targets on their backs for diversity opponents. The Grutter case that the Supreme Court decided in 2003 was an example of an institution of higher education that had to change its admissions programs to make them Bakke compliant, at least at the law school. Now that was done before they were sued, and the program they implemented, the admissions program, was Bakke compliant, and it was upheld by the Supreme Court, as we know. Not so in the undergraduate case, a little bit more about that in a few minutes. But in the years following Bakke, supporters of the remedial rationale have had to accept, or felt they had to accept, the Supreme Court's constricted applications of the 14th Amendment. And Bakke and the court's interpretation in Bakke have been the governing principle. Yet, those who are opposed to what we call affirmative action or diversity, in the instances in which we have prevailed, whether we're talking about Bakke or Grutter or Fisher 1 or Fisher 2 or in other cases, in those instances, our opponents have not given up. They didn't go away and said the Supreme Court ruled against us and so it's over. They came back again and again and again to challenge race-conscious measures in higher educational institutions. And that's been important because, on the other hand, when supporters of diversity efforts have lost, often we have not engaged in the same kind of pushback. And so we haven't looked at times at what the possibilities were or are with respect to pushing back on the stingy jurisprudence of the 14th Amendment in this context. Let me give you an example of what I'm talking about. In Bakke, there was, and there is, there are some holes, there are gaps with respect to evidence that was lacking in Bakke that the court talked about, and it's never been revisited. Those gaps, those holes have not been filled. What am I talking about? Well, you'll remember part 4C of Bakke. And when I say Bakke, I'm talking about Powell's opinion, of course, because as we all know, that opinion bridged those two camps and stood as the opinion for several decades that we understood to be governing, even though there were people who attacked it and said it didn't command a majority or no single rationale commanded a majority. In 4C of Bakke, Justice Powell looked at the state of the record in that case. And he pointed out that there were, as I said, some holes. Although Bakke agreed that the goals of, or the court in Bakke, of integrating the medical profession, and here I'm reading and quoting, and increasing the number of physicians willing to serve members of minority groups were compelling state interests. It concluded that the special admissions program was not the least intrusive means of achieving that goal. And Powell went on to say that it can be assumed that in some situations, a state's interest in facilitating the health care of its citizens is sufficiently compelling to support the use of suspect classifications. But Powell went on, there's virtually no evidence in the record, in this record below, indicating that petitioner's special admissions program is either needed or geared to promote that goal. And then in a footnote 46, the court points to the fact that the only evidence in the record with respect to such underservice of minority communities with respect to healthcare is a newspaper article, one newspaper article that's in the record, or was in the record at 473. And the court said, with respect to this failure of proof, the university concedes it cannot assure that minority doctors who entered under the program, all of whom expressed an interest in practicing in a disadvantaged community, will actually do so. It may be correct to assume that some of them will carry out this intention, and that it is more likely they will practice in minority communities than the average white doctor. But there's no empirical data to demonstrate that any one race is more selflessly socially oriented, or by contrast, that another people is more selfishly acquisitive. So the court concluded that petitioners simply haven't carried their burden of demonstrating that it must prefer members of a particular ethnic group over all others in order to promote better health care. Now, Bakke was a long time ago. There is evidence that has come to light since then, but the court has not been made aware of this evidence. And so Bakke and its successor cases still stand. I want to point to some evidence that exists with respect to healthcare. There is evidence that, and research, that Black doctors do in fact serve Black communities differently than white doctors do. There's a significant study that was done fairly recently that shows that Black doctors, in fact, Black physicians and Black patients, improve health outcomes for African Americans when they interact. And that evidence doesn't stand alone. There's also evidence that the race of doctors affects the health of Black men. In a study that was done and published in 2018 by the National Bureau of Economic Research. There's similarly other evidence that exists with respect to Black women who die at significantly higher rates when it comes to mortality in childbirth than white women. There's evidence about the fact that these kinds of interventions, more African American physicians, it matters. And so in that sense, what the court did in Bakke and what Justice Powell said is just wrong. Or at least, even if it wasn't wrong then, it's wrong now. In this time of COVID, there's a study that shows that the COVID-19 pandemic not only threatens Black communities, it threatens Black healthcare workers and the workforce that serves in those Black communities, and that has a consequence with respect to how COVID-19 is disproportionately affecting African Americans. I think the same is also true for Latinos. The point I'm making is this: in many respects, Bakke was either wrong then or can be shown to be wrong now. But it also has had other impacts on African Americans. As a lawyer and as a civil rights lawyer, somebody who litigated with the NAACP Legal Defense Fund for many decades now, I came to know many of the lawyers who, from the 1940s and 50s, litigated the cases that broke the back of American apartheid. And also through them and through working at the Legal Defense Fund, I came to know about the lawyers who, even before their time, did work to promote racial equality. Many of these lawyers, not all of them, were African Americans. So I want to be clear. There are two phenomena that I'm talking about. One is Black lawyers who have litigated in trial courts and appellate courts and in the United States Supreme Court, highest court in the land, for decades and decades, that go back to the 19th century and certainly in the 20th century, worked on behalf of African Americans. And then there are other lawyers who weren't or aren't Black, white lawyers, Asian American lawyers, lawyers of other backgrounds, Latinx lawyers who have worked for racial justice. And most Americans don't know these stories. The first African American lawyer in the United States who was a member of the Supreme Court bar on February 1st, 1865, the same day that Abraham Lincoln signed a joint congressional resolution sending the 13th Amendment that would abolish slavery to the states. John Rock became the first African-American Supreme Court lawyer. He never argued a case. Unfortunately, he died before then. I want to thank my research assistant, Jeffrey Joseph, for bringing this fact to my attention and bringing a lot of other research to my attention. The first African-American lawyer to argue in the United States Supreme Court was Samuel Lowry, a former slave from Alabama. Appeared in 1880. We don't know much about the cases that he argued there, but we know that he was the first African-American lawyer to argue there. And I can go on and talk about James Alexander Childs, graduate of, or who studied at Michigan Law School. We don't know whether he actually graduated or not. And argued a case that was decided in 1910. We could go on and talk about these lawyers until we get into the 20th century, when the lawyers who became the backbone of the NAACP Legal Defense Fund began to do their work. I'm spending this time because it was significant, substantively and otherwise, that Black lawyers were among those. And in fact, it was more Black lawyers than not who worked in the federal courts, in the state courts, and in the United States Supreme Court to bring about racial justice. And you all know some of those stories. You know about the cases that Charles Hamilton Houston argued, brought to the court, and how he trained and mentored Thurgood Marshall and Oliver Hill, who would be two of the lawyers. Thurgood Marshall, everybody knows. Not everybody knows Oliver Hill, but those are two of the lawyers who argued the Brown cases. You know about, or you should know about, William Hastie, and you should know about Jack Greenberg, a white lawyer who became the second director counsel of the Legal Defense Fund. When I was preparing, and I'm still doing the work of tracking down the cases that I knew were there, I was conscious of the fact that during my time at the Legal Defense Fund, the Legal Defense Fund had lawyers almost every year, not almost every year, just about every year in the Supreme Court. Sometimes multiple cases in the Supreme Court. They appeared regularly. These cases, you can go back to, at least with respect to the Legal Defense Fund, till 1940 when it was created. But even before then, Black lawyers in the Supreme Court, Williams versus Mississippi, voting rights in 1898, Cornelius Jones. We could talk about Hansberry versus Lee, Earl B. Dickerson in 1940, Adams versus United States in 1943. I could go on, Shelley versus Kramer, Sippuel. You all know these cases. There were almost no years during the period between the 40s and the 60s and into the 70s where a Legal Defense Fund lawyer or a Black attorney from somewhere else, most of them were LDF lawyers, some of them NAACP after the two organizations split, were not present in the Supreme Court. Why am I spending time on all of this, you might ask? Because I contend that one of the effects of Bakke, when it killed the remedial rationale in favor of the diversity rationale, which, as I said, I've supported the diversity rationale, but not as the most powerful rationale, not as the first order rationale. But one of the things that's happened is that Bakke has contributed to the fact that there are almost no lawyers who appear in the Supreme Court any longer. Very few. Why? Well, one reason is that the cases that were brought or are brought on behalf of African Americans meet a much more hostile reception. The court doesn't take many of those cases. It has also shifted to taking more so-called reverse discrimination cases when it does take cases. But even where cases are brought to the court, because the remedial rationale has been so badly compromised or damaged, most of the cases now are cases where institutions like the University of California at Davis, like the University of Texas, like the University of Michigan, and I can go on and on, now Harvard and UNC, those are the cases that are defending the actions that preserve opportunities for people of color in higher education and elsewhere. But it's not only with respect to higher education. When we think about the challenges in the late 1980s, and they shifted to the cases like Croson, like Adirond, that were attacking, contracting programs, so-called reverse discrimination cases, and there's no voice in those cases for African Americans or Latinx people other than as amici. Now, let me be clear. It's important to file amicus briefs, but we also are equally clear that the records are made by the parties. I could spend a great deal of time talking about these cases and the significance of the fact that Black voices have been excluded or marginalized in these cases in recent years. You might say, well, that's optics. It's symbolic. It's not merely symbolic. So, for example, when I was director counsel of the Legal Defense Fund, among other things, the parents involved case, or cases, because it was Louisville, Kentucky, and the case out of Seattle, they came to the Supreme Court together. The Legal Defense Fund had been a so-called litigating amici. We were allowed to have a place in the courtroom and a limited role in the trial court in the Louisville case. The school district had been declared unitary quite some time ago. I could go into the detail of the significance of all of that and where that fit into the shift in the jurisprudence that made it more difficult for Black and brown people to protect their interests in the federal courts. But here's the bottom line. Knowing, because we had experienced it over and over again in cases where institutions post Bakke were the parties that played the role of defending the opportunities for Black and brown people in those institutions, we knew that it was important to have voice if we could get it. So, for example, when Parents Involved was before the Supreme Court, we had worked with a lawyer. I don't intend to denigrate anybody, but we knew he might be asked the question, what what are you relying on? What arguments are you bringing to us? Are you in fact arguing that there's also a remedial rationale supporting or that should support race conscious measures? We wanted the answer to be, we rely on both of those legs. But when asked that question, the lawyer for the school district, and I suppose I can understand it, but said, no, we're not making a remedial argument. And it was so frustrating sitting in the courtroom. But the fact is that for decades, like other school districts, the Louisville School District had been working to get to the point where it was unitary. And even when it was unitary, that doesn't mean all of the effects of the past segregation have been eliminated by reason of having achieved unitary status. Well, I think you get the picture. We asked for argument time in that case, a rare step. The court denied it, didn't give us time. Similarly, in the Michigan undergraduate case in Gratz, and here, Elise Body was at LDF then and worked on this along with other lawyers, Ollie T. Johnson, who's at Columbia Law School now on the faculty there, and others. We had different arguments that justified what even the undergraduate institution at Michigan was doing, even though it was my view that it was not quite Bakke compliant. There were still other arguments that should have been heard and made that I could talk about with respect to what justified race conscious measures. The institution isn't going to fall on the sword, isn't going to make those arguments. Black folks, brown folks will make those arguments. This is not just a question of optics. It's a question of what arguments get made, what the substance of what the court hears is about. When I argued in the Sixth Circuit, when that case was on the way, the Gratz case up to the Supreme Court, I borrowed a term or saying that I had heard not long before that in another context, nothing about us without us. It was Black and brown people who had the most at stake in the Michigan cases. With all due respect, I think working with the institutions was important. We had a collegial relationship. It's important to do that. And yet, if in fact diversity efforts and affirmative action efforts end, it's affirmative action that ends for Black and brown people. It's diversity that ends for Black and brown people. The institutions will survive, they'll go on. I hope that Erwin Chemerinsky, my friend, is right, that even if we do lose these cases as they head to the Supreme Court, that institutions will find a way anyway. Let me draw to a close by saying this. I have thought about what happened in Bakke. Powell, God rest his soul, as comparable to what Hollywood did for a long time. It couldn't tell stories that were about Black and brown people except through the eyes of white folks. And so whether we were talking about The Help or many of these other movies that I could call, you know what they are, Mississippi Burning. It was an absurd proposition that the FBI were the heroes of the civil rights movement in Mississippi, when in fact Black folks were the primary agents of their own liberation, aided by many white people. So I think you get the point. That's what Powell did in Bakke. He couldn't see the 14th Amendment interest of Black and Brown people as something he would support, the remedial interest there. He saw the First Amendment interest of the institutions. That's fortunate that he at least saw that, but it's not the most compelling interest. And in many respects, it has abandoned the original interest that motivated universities and colleges and selective institutions to begin to consciously take actions to admit people of color. They didn't wake up one day and say, you know, we've been missing something. This diversity thing is important. They weren't using that word, that term. They were trying to remedy the long, long history of exclusion and racism and discrimination. Now, is this all sour grapes and nothing else? I don't think so. There's even some confusion, and I'll end on this note, I think, in the Supreme Court about the remedial rationale and the diversity rationale. And Fisher, at one point, Justice Alito asked a question of the university's lawyer, in which he criticized the notion that the son or the daughter of a middle class or upper middle class Black couple, a doctor, a lawyer, could be the beneficiary of diversity efforts, and said, I thought this was all about disadvantage. Well, with all due respect, Justice Alito, the Supreme Court pulled the rug out from underneath disadvantage and discrimination in Bakke. And the diversity rationale means that if students bring something different to the university, even the sons and the daughters of a middle-class Black couple, those considerations should be allowed as considerations. There's a lot of confusion still about what these rationales are about. It's my hope that these institutions stay open to students from all backgrounds. I believe that universities now and institutions throughout this country, as we saw in the many amicus briefs, corporations and military, et cetera, are committed to diversity. That they understand that this country has changed, the demographics have changed. We're not going back in spite of a lot of the confusion of the moment and of the last 4 years. And so I wanted to share those thoughts about the significance of Bakke, but also of the way the 14th Amendment has been undercut and weakened in Bakke. But my hope is that we'll find a way anyway, as Dean Chemerinsky and others have mentioned. A lot more that can be said. I'll stop there. I thank you all for being with us today. And I'm going to continue to work up much more along these lines. And I'll turn it back over then to Alan for questions. Alan?
Thank you so much, Professor. I would like to invite our attendees to submit questions in the Q&A box, and we'll go through our question and comment period here for the next 30 minutes. So one question I want to go ahead and pose to you, Professor Shaw. You've said early on in your address that there are those opposed to affirmative action and the diversity rationale, and they haven't given up just because they've lost cases such as Grutter and the Fisher cases. At what point would they stop? In other words, not to sound too apocalyptic here, but what would they consider to be a battle won when it comes to the jurisprudence of the 14th Amendment's Equal Protection Clause?
I cannot get in the minds of an Ed Blum, for example, and say what motivates him. What I can say is that he has been an opponent of efforts to politically empower African Americans. See, Shelby County versus Holder. He's been an opponent of opportunities in higher education for Black and brown people. See the two Fisher cases, see the Harvard case, see the UNC case. I think that the only thing I can tell you is that when we watch what people do, we assume that I assume they mean the consequences of their actions. And his are the actions of someone who is intent on narrowing down opportunities for African Americans in particular. There's a piece of evidence in the Harvard case that I understand was a video or is a video in which he was speaking to a group and he says words to the effect that he has to go and find some Asian American students to be plaintiffs. It's not that they came to him. He strategically decided that he was going to try to divide and conquer and thought that he would have a better chance of winning than he's had in these other cases by bringing Asian Americans. So I don't know that he will ever, give up his attempts to work in ways that disadvantage African Americans.
Thank you. And I'm gonna pull out a question from our Q&A here. So we have a question about Bakke, and do you see an argument in the pipeline that might repudiate or reject the Bakke decision, overturn the Bakke decision?
Well, as I said, I do think that there's some empirical evidence that we can point to now. I mentioned there's research that shows African American women in the United States, Black women, 3 to 4 times more likely to die as a result of complications from pregnancy, labor, and childbirth than white women. Or a study by Dr. Marcella Olson at Stanford Medical School, patients who do not, patients who met with Black physicians, Black patients, Black children included, were asked to receive, they asked rather to receive more preventative services in patients who met with non-Black physicians. So, the hole in Bakke that Justice Powell's opinion pointed to, the language that I read seems to me to be a defect in the rationale in that case. Do I know that this court, if those holes are plugged, are going to change their ideas about what they will allow and what they won't allow with respect to race-conscious actions? I don't know. But I feel that we are duty bound to try to put that evidence before the Supreme Court. And then the other evidence that we come up with, Black men, lowest life expectancy of any demographic group in the United States. And research shows that health outcomes for Black men are better when they are treated by Black doctors. Now, I wouldn't have known that necessarily, but the evidence is there. So I think we have to try to put that into play.
Thank you. We have another question in our Q&A. Can you speak more about the remedial justification for race-conscious remedies? Bakke, one could say, damaged it significantly with the societal discrimination theory, and with Croson as well, damaging it further by establishing a high bar for plaintiffs to justify race-conscious remedies. would you agree that the door is still open a little to the remedial theory?
Well, I think that we have to keep pushing on that door. In spite of the fact that there are some on the court who've tried to close that door over the years. But the fact is that the inequality that exists in this country, measured across the board, whether we're talking about health or wealth or housing or now the COVID-19 impact. I mean, my goodness, if that doesn't tell us anything about how inequality continues to work in this country, although it wasn't a surprise, if that doesn't tell us, nothing will. And not all of those manifestations of inequality are easily identifiable as specific actors in recent times or days or years taking action that has the consequence of creating inequality or in one way or another disadvantaging African Americans, Latinos, Latinx people. And yet, how can we give up on showing what the impact is of actions that have disparate impact, as we talked about earlier? We have to keep pushing this court because it's factually defensible, not only defensible, but a necessity. And if the court doesn't acknowledge the importance of those arguments, shame on it, but we have to keep trying. Even while we try the other arguments also with respect to diversity, but it's no coincidence that the Ed Blooms of the world and others are attacking diversity also. Either way.
Gotcha. Thank you. Another question here. As someone who cares about disparate impact, this person who was one of our panelists is worried about what the Supreme Court will do with disparate impact statutes such as Title VII. Do you think the current Supreme Court will invalidate such statutes as the court threatened to do in Ricci?
Well, whether we're talking about Title VII, whether we're talking about Title VIII, whether we're talking about the part of the Voting Rights Act that still stands, and some of the jurisprudence that looks at disparate impact and accepts it. No question that conservatives are going to attack that. They're going to continue to try to undo disparate impact. There are people in this country who are intent on undoing anything that consciously and deliberately helps African Americans escape the impacts of inequality. And now the court's changed. How many people on the court will vote to uphold disparate impact is anyone's guess, but I suspect that very few people are going to put money on the court if they were betting people upholding disparate impact. But to borrow a term that was misused in another context recently, I say all the time, if you don't fight, you can't win. I mean, if you fight, you may win, you may lose, but if you don't fight, you may win. And of course, when we say fight, we're talking about fight with the Constitution, with arguments. We're not talking about violence like some people were talking about. So do we have a court that's poised to overturn disparate impact? We might, but here's the other thing that those of us who have litigated and watched the court for years, what we know is you never know. You don't know what's going to happen. You don't know where people are going to go with respect to their jurisprudence. And I want to, if I may, because I guess we're just about out of time. Correct me if I'm wrong.
We've got about 50 minutes. We've got a little bit of time left.
Well, I want to say something about Frederick Douglass.
Absolutely.
You know, there's a wonderful book. I hope that people have read it. If not, I really commend it. David Blight's biography of Frederick Douglass. And as I was reading that biography, I came to the point where the Dred Scott decision was handed down. And David Blight, you know, I love Eric Foner. And then I love David Blight also as a historian, among some other historians. And David Blight wrote about how discouraging it was. If you could only imagine being in that moment. You know, the abolitionists have been working for decades to end slavery. And then the Supreme Court of the United States hands down this decision that says not only do Black people have no rights that white people were bound to respect, but also that, you know, even free Black people could not be citizens of the United States. Imagine that moment. You know, imagine the despair that would cause. And yet, no one could have seen, Frederick Douglass couldn't have seen with any certainty that within a few years, slavery would come crashing down because of a civil war, and that the 13th Amendment would be ratified. The 14th Amendment would be ratified, the 15th Amendment. No one could have seen that. All you can do is keep struggling and fighting. And it's the same thing here. Yes, the disparate impact standard is under attack. You know, diversity efforts, affirmative action efforts under attack. The court more conservative than it's been at any time during my lifetime. I may not live to see a court that is less conservative than this one. This may be it for me. But I think about Frederick Douglass and I think about Dred Scott and how they kept fighting, not knowing that victory was around the corner. Might have been a long corner, but there it was. The moral arc of the universe is long, but it bends toward justice. If we don't believe that, we give up on hope. And if we give up on hope, we die.
Well, in that spirit, then we had another question come through in the spirit of continuing to fight and continuing to struggle. Are courts going to be our only route to change? What else might we do? What other options do we have?
Well, I'll clean up my language and say, oh, heck no. Obviously, courts are not going to be the only avenue. And I know when you ask that question, I know you know the answer to that. Just as, you know, this morning, when we heard from Erwin Chemerinsky, he talked about the fact that we might be, he didn't use these terms, but I'll use them. We might be in a post jurisprudential struggle moment with this Supreme Court in some respects. But even if we don't want to go to the court, sometimes we're going to get dragged there. But we have to work politically for change. We have to change people's minds and hearts. We have to vote. We have to make sure that we leave no stone unturned. Yeah, it may be that, look, even at the best of times when Brown was decided and Brown inspired many of us, you know, the courts were never a panacea. And, you know, we never could look to the courts alone. We always had to struggle on all fronts. That's not going to change.
Gotcha. Thank you. This may be our last question here, unless others come through. But President Biden has promised to put a Black woman on the United States Supreme Court if a vacancy comes open. Taking for granted that he means that promise and that a Senate would be able to confirm that, do you think that having a Black female, presumably younger voice on the court would be able to persuade any of the conservative justices in the affirmative action context or other contexts involving race?
I think that who is on the court matters, obviously. That's why we have these battles with respect to judicial nominations. I think that it might be that a Black woman, depending on who and what she was, would bring another perspective to the court. But, you know, there's no guarantee of that, even if you put a Black woman on the court. I mean, we've had, I don't mean to say anything that disparages a sitting justice. I mean that, I'm sincere about that. But what is more important to me is the judicial philosophy of the justices on the court. And that first, we've learned that lesson the hard way, I think. Don't misunderstand me. There are plenty of Black women who are qualified and who would make excellent appointees to the Supreme Court of the United States. But I'm interested in someone who is committed first to enforcing the Constitution in a way that is that protects the rights of individuals. That first. But I'll be happy if we get a person who does that, and it's a Black woman. But I can be happy with a lot of other people doing that too.
Thank you. So we've talked about, or you've talked about, and we've heard from other panelists and speakers today about 14th Amendment Equal Protection Clause in the context of education, especially higher education. For this question, what role or what place is there for corporate America to play in this struggle?
You're asking about corporate America,
Yes.
Alan?
Yeah.
Well, I'm conscious that in the Grutter case, there were 65 briefs filed, amicus briefs filed by some of America's largest corporations. There was a time that never would have happened. And they were in support of diversity and keeping the doors open, the doors of opportunity open. They argued about how they had to have pipelines into corporate America and how diversity matters in corporate America, how having Black and brown people and Asian Americans and women, diversity across the board writ large, that at one time wouldn't have happened. I think that America's institutions have changed and been changed as a consequence of the struggles that Americans have engaged in recent years. And I believe that even in this moment when racism, and misogyny and other forces have been unleashed, I believe that most Americans are going to want to see our institutions, including our corporations and the military and our colleges and universities, be representative of what America is. And I still believe that America is more, like it looks than it was on January 6th.
Thank you. Thank you. So with that, we are out of questions and we're pretty close to our end time here. Again, want to thank folks for being with us today. I know it's been hard for folks around the country, but it means a great deal that you stuck with us today. I'm going to turn it back over to you, Professor Shaw, to close us out.
Well, thank you. I hope that those of you who have been with us today have had a sense of why Alan Boyncey is one of the things that that gives us hope. Young, bright, committed. He has a wonderful way about him, as you can see. And so I want to thank Alan for what he's been doing. I want to thank April McKinley, who's behind the scenes today, who works at the center and is just such a hard and wonderful worker. But in addition to that, I want to say a quick word of thank you to the Frank Porter Graham folks and allowing us to use their or to fill up their lecture as we did today. And I want to thank James Laludis, Professor of History here at UNC. And I also want to thank all of the individuals who are supportive of us. Tomorrow, when former Attorney General Eric Holder speaks, he will give the Wheel Lecture, and we want to thank the Wheel Lecture folks for being supportive of us in this effort. I want to thank the Chancellor for being with us this morning. And I hope you come back tomorrow. Another day. You've gotten, with all due respect, you've gotten the part that I was doing behind you now. And the best is yet to come. Well, I shouldn't say that with respect to the other. We've had a lot of wonderful and great speakers and panelists and moderators, but there's more to come tomorrow. So rejoin us. We'll look for you here. We can't go out for a drink right now, but you're at home. You can do whatever you do to relax, and then come back in the morning. Thank you.